Kia ora koutou, and a really warm welcome to this hearing today in beautiful sunny Chris Miller's flat. We're here to hear the application by Hawkeswood Mining for their gold mine here in Miller's flat. We'd like to start our proceedings today with a karakia from Commissioner Dave Cleven.
Whakataka hau ki te uru, whakataka hau ki te taonga, kia mā kina ki uta, kia mā taratara ki tai, kia hi aki ana te atakura, he tio, he huka, he hauhu, tihe moriora.
Kia ora koutou, ko tititia te maunga, te wanaka te awa, no Otepotu Aho, ko Robertson Tahu ko Louise Taylor Toku Ingoa. Welcome, hello, my name is Louise Taylor. I'm the chair of this independent hearings panel today. The three of these colleagues beside me and myself have been delegated authority to make a decision on the resource consents on behalf of both the Otago Regional Council and Central Otago District Council. A little bit about me. I'm a resource management professional. I've been in this game for about 25 but more years. I'm based in Dunedin, and my recent practice is a mix of commissioner work like this and working with councils and other developers, submitters, all sorts of mixture of projects. So I sort of mix up the planning side with the commissioner side. So welcome everybody. Really great to have such a good turnout today. And we're here very much eager to listen and learn from you all. I'll just ask my fellow commissioners to introduce themselves.
Morena koutou, ko Rose Tokuinga, no Otepotu Aho. My name is Rose Day Cleven. I'm based in Dunedin. I've got a background in resource management planning and have been doing commissioner work for some years now. It's a pleasure to be here today. I'm looking forward to hearing from everyone through this process. Kia ora.
Thank you. Good morning, Craig. My name is Craig Welsh. I'm currently living in Nelson. I'm an independent resource management commissioner. I've been a commissioner since 2015. I'm from Mid-Canterbury, Ashburton, and grew up on the Kaya River. I've got started resource management 2 years ago in 1992, and I've got 20 years mining and environmental management experience. Yeah.
Okay. Before I go on, can I just check that those online can hear us okay? If someone could just...
MJ, can you just let us know if you can hear and see us?
All good, loud and clear. Great, you're loud and clear as well. Excellent. Very, very good. So just a bit of an intro about how we're going to run the next couple of days. The commissioners have read all the material that's been provided, so the application, all the submissions, the evidence that's been provided by submitters and from the applicant, legal submissions and from council staff. We have, as Commissioner Dave Cleven mentioned, we're very much interested to hearing from you all and understanding the issues that are important to you. It's really important to us that this is a really respectful, safe, positive space. And the goal here is for us to understand the issues that are relevant to our decision today. So I ask that everyone keeps that in mind as we go through. We'll try and keep it as informal as possible, but we are required to have a reasonably solid sort of schedule and process. There will be no cross-examination for witnesses. If there's no questions between parties, if you have an absolute burning question when you're up, when you're presenting and you have a burning question for another party, you can ask me and I'll decide whether that's okay to ask that person. So nothing from the room, please, just as you're up when it's your turn. If you did have a question you felt that was important, you can ask me through me. In terms of the, I haven't introduced staff, very sorry. Actually, if the staff would like to introduce themselves, that would be fantastic.
I'm Taryn Lyons. I'm the Hearings Administrator for CODC.
Well, I'm Rachel. I'm the Hearings Administrator.
Thank you.
I'm Olivia Spelling, the Independent Planning Consultant for CODC. I am Jenny Osher, the ORC planner.
Morning, Matt Bell, team leader consent, so I see just Mr. Portadinio.
Thank you. And we'll take appearances a little bit further on. As you will have seen, the council planners have prepared reports making recommendations in relation to the application. Those are recommendations only. We will consider that as just part of all the other evidence and information that comes to us. They have recommended, both have recommended decline. That does not bind us in any way. We will consider all information and make our own decision based on what's before us. In terms of the way we act, you will find that often we will start talking with witnesses and submitters about potential conditions of consent. That doesn't mean that we're of a mind to grant the application, but for us to be confident, if we were to grant the application, we would need to be very clear that any resource consent conditions were appropriate and in place to manage any of the effects that have been identified. So as part of this hearing, we will be talking about conditions, we will be talking about management plans, but that doesn't give any indication of whether we're of a mind to grant or decline the application. In terms of just approach, if we don't ask you any questions, don't be offended. That's okay. We have pre-read it, and it's probably that you've been very clear. So we may have questions, we may not, of you. And again, thank you for those that did pre-circulate information. For submitters, if you haven't pre-circulated, that's totally fine. We're very interested to hear from you when you talk to your submission. In terms of our schedule, I'll come to that in a bit more detail, but I just wanted to flag that we do have in our schedule the council staff and associated experts right at the end of the day after the submitters have, at end of the hearing, so probably tomorrow, after the submitters have presented. We may have questions throughout today for yourselves or some of the other experts that fed into your reports. So we'll just see how we go with that. If hopefully they're either in the room or online, and we can jump in and ask questions as we go. But after the submitters have had their applicant, then submitters have had their opportunity, then the floor will be yours to give us some updates, and we are very likely to have questions for you. In terms of that, I just wanted to flag that we had noticed there's some inconsistencies or possible different conclusions between the two of you in your reports regarding the same matters. It would be very helpful for us if you, prior to coming to us tomorrow, could have a conversation together, and at very least explain where those differences are or whether you're now in agreement. That would be very helpful. There's no doubt other things that you're wanting to discuss as well. And just also a flag, if you do look to make any changes to your conclusions or recommendations or assessment in your report, we will be looking for that in writing. If it can't be by the end of tomorrow, then we'll agree at the end of the hearing what sort of timing you might need for that, but we'll look to that. In terms of media, we do have media here today. Welcome along. If anyone in the room does not want to be photographed, please let the media person know. Otherwise, I understand there may be photographs taken at some stage through the hearing. Thank you. So in terms of the schedule, I will, that has been pre-circulated. At this stage, we're looking at about a day and a half. That can evolve a little bit through hearings. For those who have been here to hearings before, you'll know that it can go slower or quicker depending on how we go. At the moment, we've got our applicant will present first. So we'll hear from Mr. Brabant and his team. We will have questions for some of those submitters, and then we'll go in, those witnesses will then go into submitters, and I'll check shortly who we've got attending. And then, as I mentioned, after our submitters, we'll look to the council staff to provide an update on their recommendations, and we may have questions for them. And then from there, it will be the applicant's right of reply. And it may well be that we agree that that's provided in writing. That's most usual for something of this sort of nature, but we'll see where we get to. So that's the overall schedule. Just also to let you know, the panel, we visited the area yesterday. We're all familiar with the area more generally, but it's really useful to have a look around from public viewpoints along the Crewther Trail, along Teviot Road, and along some of the other roads. So we've had a look around the general area and the general vicinity of the site. We haven't been onto the site yet. We are interested in doing a fuller site visit probably tomorrow afternoon. So we'll talk to the team about that and potentially submitters from submitters properties if that's useful as well. So we'll arrange that towards the end of the hearing. That's all I've got. Anything else? No? Great. So if I could just take appearances, please.
Good morning, Jeremy Brandon is my name. I'm the barrister for the applicant. We have a team of witnesses here today, and they are a number of them, well, in fact, almost all aside from those who will come up during the hearing. So alongside, most of them are at the back. We had, you will recall, Mr. Willerman, who's in the UK.
Yes.
And his appearance has been excused, and so you won't see Mr. Willerman during the course of this hearing, either in person or online. But of course, if any issues arise, that can be dealt with written questions.
Thank you.
We had Mr. Chapman, who is the expert with respect to lizard ecology in particular, and in the communication with the panel, you indicated that Mr. Chapman will need to appear online and in person today, but again is available if needed.
Thank you.
Currently, Karen Pio, Colin McDermott, and Logan Popland will be appearing online. And I leave it in your hands, of course, whether you decide in due course whether any of those individuals are people for whom you don't have questions, but they are intending to appear today.
Thank you.
Beyond that, with the exception of Ms. Colley to my left, and that is her sitting to my left, the rest of the team are behind me. And what I might ask them to do, is always awkward otherwise to turn around, is perhaps has slightly schoolroom vibes, but perhaps I'll ask the fine officers behind to each put up their hand and indicate whether they're here or not and who they are, and you can put a name to a face.
That would be very helpful.
So,
thank you.
If I just go in alphabetical order, which is the order in which I have listed the witnesses in paragraph 12 of my statement. I think Mr. Alabone is here. Ms. Colley, I've already introduced you to. Mr. Goodhue, I believe, is behind me. Mr. Hawkeswood is here. Morning. As far as I know, I don't think I've seen Mr. Heatley as yet, but he is on his way, and he is on his way, I think, with Ms. Ross in a carpool series. They will be appearing today, but they're not here yet.
Okay.
Did I see Mr. Heller? Yes. Good morning, yes. Mr. Heller is here. Mr. Johnston is here. Mr. McDonnell is here.
Yes.
Mr. Moore is here.
Morning.
And I believe Dr. Wills is here as Yellow. Morning.
Right. Yes.
We'll circulate a piece of paper around the room and put like you're going to put your name on it so we know who's accurately recorded, who's present and who you represent. If you're just appearing to watch the hearing, just put watching the hearing on the paper, but it helps us with that, our decision who's attending the hearing.
Yeah.
So thank you. That's the team on behalf of the
Thank you. And I have an order, a list here of order. That's presumably how you'll run your case.
Yes, so I think Ms. Colley sent that in yesterday, I believe. So that's right. Paragraph 12 of my legal submissions at the time just adopted a alphabetical order for ease of reference, but there is an actual order that you have in your hand.
Yep.
And then hopefully I have correctly noted down for myself here.
No, that's okay.
Right.
Great. Thank you very much. can I just take appearances from submitters who have indicated they wish to be heard? Do we have Georgia Parker, Matthew Hunter? Welcome. Georgia, is Matthew here as well? Okay, okay, thank you very much. And Simon Gulick? Sorry, Stephen Gulick, I apologise. Not at this stage. Wendy Gunn? Not. Miller's Flat Water Company, thank you. And Graham Young. This afternoon, thank you very much. Is there anybody here that I haven't mentioned that is looking to be heard that would like to speak to this submission? Hello, sir. What's your name, please? Alan Parker. The ALAN Parker. Thank you. And Mr. Parker, did you pre-circulate any evidence or any statements? Just your submission?
Just my.
Thank you. No problem. We can fit.
Most of that to my daughter.
Ah, I see. Fabulous. Thank you very much. Fantastic, thank you. So just to reiterate our schedule, at this stage we're looking at spending the morning with the applicant, their witnesses. We're not going to rush that process. Apologies, missed file. Kia ora. Yeah, I've got you on the second page, that's why I left you up. So we've got Te Runanga o Ngāi Tahu, we have Katiha Rapa Runaka o Pukuraraki, Te Runanga o Tako and Hokanui Runanga. Are you here representing the both submissions today?
I'm here today, my submission book.
Yes.
Tomorrow, which is the capacity of Taco and adopted in the vote of someone who is presenting evidence and should be appearing on Teams.
Okay, so we'll have Lyndon Murchison by Teams.
Yes.
And Mr. Cassidy in person tomorrow. Thank you. So we've scheduled you for 10 a.m. tomorrow morning. That's suitable?
Yes,
thank you. Thank you. And anybody else? No, pretty good. Excellent. Right. So as I was saying, applicant this morning, we'll see how we go. We won't rush that process. It's really important for us to get a good understanding of some of these more technical issues. Between us, we all have a planning background, so warn you now, we're likely to have quite a few questions. At this stage, it looks like we'll probably have applicant through to lunch, break for lunch, and then a goal is to fit in submitters this afternoon with Kaitahu parties tomorrow morning, first thing at 10 o'clock. But we will have to play that by ear a little bit. If it's looking like the applicant is taking longer and we may not fit the submitters in this afternoon, I will flag that later, sort of around lunchtime-ish. So ask for your patience. These hearings are, you never quite know how long everything's going to take, but my guess is that we will have time for submitters today. And then it's entirely up to you if you've spoken, whether you want to come back tomorrow or not. Okay. Mr. Parker, I wonder if you could help us. We can't find a submission from you in your name. Did you file a submission in your name?
Possibly not.
There's a few Parkers.
Sure, I agreed with it, being a landowner, but maybe I did not.
Okay, well, we might, in the morning tea break, I might ask if you could have a chat with Miss Lyons, and we will see if we can find if there is a relevant submission, or it's possible that you're speaking to support your daughter with her submission, and that's actually fine too. So let's just see where we get to on that. Thank you, though. Great. All happy? And is it Brabant?
Rabbit,
Brabant, thank you. Excellent. We're in your hands.
thank you. Just if I think about it in Mr. Parker's position.
Yes,
It's not my practice to take procedural issues for no purpose, so I would simply indicate, obviously, if Mr. Parker's lodged to no submission, then can't speak in that context, but I agree with you, Madam Chair, that it would be open to his daughter to call him as a witness, and that would resolve the matter.
thank
And
you.
we simply need to be clear on what basis he's proceeding to speak.
Excellent. I'm very comfortable with that. Thank you. But sorry, I hadn't actually just double checked. Does anyone have any procedural matters they did want to raise before we begin? Right, thank you, Mr. Bramett, we're all yours.
Now, I understand you should have with you, provided the 14 summary statements,
If those, thank you.
and those have been coming in over the last day or so, and some work as well to pick up some documents received last night, being an additional memo with respect to landscape and visual effects, and an addendum to the ORC section 42A report, which I think came in at 9 o'clock last night. My witnesses have had a look at those. It may be that they have some verbal comments to add with respect to that as well as.
Thank you.
The reason for the 14 statement is just to clarify that, given there are 16 witnesses, and so Mr. Willerman hasn't produced one, again, as person in the UK. And then Mr. Keogh's statement is so short that producing a summary didn't seem to be required, to be honest with you.
Thank you. And thank you for circulating those in advance. We have had a chance to read some of them. So that was helpful, but obviously wasn't a requirement. So I appreciate that.
No, thank you. Well, and that it's obviously our understanding that, and what's been evident from the chair and the panel's communications, that happily you very much across into written material lodged. We can see that you pre-read a lot. And therefore we wanted to contribute to that exercise, obviously flowing into the efficiency of this process, so hence the to get those lodged. Touching on those, was it your preference that, or at least as matters stand, I've indicated to the witnesses that they should read their summary statements, but not read out, of course, the original statement. So if you wish matters to progress in a different way, please let us know, but otherwise that's the process that the witnesses will adopt.
Yes, yes, certainly. Yep. No, as I say, we've been able to read some, but not all certainly. And very much the intention was summaries are useful for familiarising ourselves all in the room, and for the witness also to settle in. So no, absolutely, if they could read these summaries, that'd be very helpful.
Thank you. The only other matter perhaps I'll touch on before we start, the landscape and visual effects assessment memo that came in last night referred to a set of plans from memory, February, but certainly
Yes.
outdated rather than 22 April, and I was wanting to check with you that you have in front of you the correct plans, and also I'm not entirely clear why Mr. Kensington had been available to you. The 22 April 2024 plans were attached to the evidence of Mr. Johnson. And so I want to just ask before we go any further, firstly, I suppose, whether you as a panel have seen those and understood what's
Yes.
being referred to, and then secondly, there's that question for Ms. McKenzie, although she of course has time to familiarise herself with that before she speaks
Yes.
tomorrow.
So the plans I have here are actually 26 February. So they were the plan set provided, I had understood, separately by the applicant. So if we have a later version, it would be extremely helpful if we could get those sent through and printed.
The later version refers to the bundling, focuses on the bundling. And so I think what we'd prefer is to have the February version of the plans, which are quite useful because you can flip down the page and it changes the stages through those 8 plans, with that bundling from Mr. Johnson's evidence shown on the February version of the plan. That makes sense.
So what I might do
Unless you have a full updated set or not.
what I might do is invite this colleague to speak to this. She, along with Mr. Johnston, has been involved in managing this aspect of it and making sure that you've got what you need. So I think it would be most efficient if I invite you just to engage with you now to make clear what you have,
Yes,
what we understand you've got, and then if a solution is needed, what that might look like.
thank you.
I think that is a normal submission.
Yes, we'll see where we get to.
So if the plans that you have dated February 2024 were circulated with the information on the 5th of April prior to the circulation of evidence.
Yes.
Hearing evidence, we made 2 changes to that plan set, and those are outlined in paragraph 16 of my evidence. So the changes were addition of bunds along the western boundary of stage 2, which is the natural business Mackenzie Braces Centre, January last night. And reserve an amendment to the site vehicle access location for stages 3 and 4. So if you have Mr. Johnston's evidence printed, the plans appended to his evidence are the updated version dated 22 April.
And that is appendix H to the evidence.
Okay, just one moment. We'll just. Yeah, okay, thank you. It would be helpful if we could just have that set printed. Couple of copies. That's it.
Perfect.
It's a full updated plan set, is that correct?
It is a full updated plan set. The differences are limited to those 2 matters that are addressed in paragraph 16 of my evidence.
Thank you.
So there are changes made to most of the plans within that plan set, but the change are limited to those 2 discrete matters. Everything else remains the same.
Commissioner Welsh, does that solve your?
It may be that our questioning results in plans needing to be
Yes.
updated anyway through the hearing process, so maybe we just relax on that matter and just carry on with it as you described, with the knowledge that it may change over time.
But can I just confirm though, that you do have, we haven't had something go astray for some reason, you
No,
do have. in front of
Yes, 22 April.
those plans.
Thank you.
You do have the ability.
Correct. And that's Johnson's. Thank you.
Called appendix H, merged site plans.
Correct.
Yes, thank you.
So, my legal submissions, I haven't prepared a summary of those. What I will do is speak to those, and I'm going to speak to those in a summary fashion.
Thank
Right,
you. We
because
have
you-
read them.
Both because you've read them, and because really this matter in many respects depends on two issues. One, of course, is a wealth of technical information. And I say that that's been resolved in a manner that is favourable toward the grant of consent, but nonetheless there are, of course, there's a lot of material there for you to work through. And that aspect attracts limited need for specific comment from me from a legal perspective. The other aspect, of course, are cultural considerations, and that ties then in many respects to the more significant issues remaining on the table, high reference to objectives, policies, higher order plans, how you interpret those, how you apply those. I've included some legal guidance on aspects of that, and I will briefly touch on those, but there are other aspects to it which may have more light thrown upon it once we have the evidence on behalf of Karanaka. Obviously, we have written statements from them, but they will of course also present verbally to you. They will answer questions, and that forms part of their overall position. And so it may be that there's more to be said subsequent to the hearing. that evidence in its full extent. Turning to my submissions, then the proposal, I'm not going to go through any lengthy description of it. You read the material, you're familiar with it. There are some key points that the applicant will come back to and are core to the approach it's taken. If we start paragraph 8 of my submission, there's just that description of the mechanics of how the exercise is undertaken, and I understand you're familiar with that. You, from memory, you said you haven't been on site yet, correct?
Not on the site itself,
Right.
correct.
So when you do go on site, and it may be you've seen this sort of operation before, maybe you haven't, but what I would say to you is that when you see the dredge floating in the water in the pit that's been formed, it really does help, I think, crystallise in your mind an understanding of how the exercise works. Now, you may not have had any issues getting clear in your mind how it all unfolds. I would simply say I think you'll find that site visit helpful in that regard. The dredge obviously isn't working, but it is sitting there, and it is easy when you look at it, need to understand how the process actually unfolds in an on-the-ground sense. But in short, as you know, there's a need to remove overburden, and that includes topsoil and some other material. And then you have your layer with which the gold sits within. That is what is fed through that dredge machine. Importantly, that dredge machine is operating without chemicals, so it's just a water wash. And then that material, of course, separates out into, in effect, gold, and that other material which is returned to the land. That material then is placed back, place the overburden back on top, and there's rehabilitation that follows. And key to the applicant's position is, with the exception of the land that forms part of this site remains on the site. The water that is used on the site is a non-consumptive use, and it remains on the site. It is. It might be stretching to say it is a completely closed cycle, but it is close to it. And that is an important aspect to the applicant's position, and the reason why it's a subject to all the technical detail. This proposal is one that can successfully operate here in the context of effects and the other matters we need to consider. So paragraph 9, I speak to some of those technical perspectives. And it talks about, in summary, then that reference to the water take being predominantly non-consumptive, and that water being returned to the land. It's not discharged to water. It's not discharged into Timber Burn. It's not discharged into the water. It is returned to land, which, from the applicant's perspective and their understanding, is an important aspect in the context of concerns around cultural matters. And allied to that and relevant to that and those matters considerations, it also is a deliberate commitment to setting back the operation, both on timber and from relocation. Purposes we addressed, and I won't go over that list again, but it will unfold in line with the order that we had.
Before you go into that, at paragraph 10, you talk about consent duration. And that is a matter of some concern, particularly by Ms. Sterling, that you are seeking a 10-year land use consent term, but a maximum of 6 for the water take. Just flagging that is something that we just wanted to tease out with the witnesses, and whether there is any particular issue with that, or whether it's a matter of risk on the applicant, and how much should we concern ourselves, I suppose, is something that we're looking to.
So the witnesses can definitely respond to that.
Yes.
One, it is a matter of risk to the applicant. Secondly, there isn't a concern about enduring or issues arising as a consequence of that mismatch, because fundamentally the activity cannot take place without water being available, and water being available in line with that region take. And so if that consent were to expire and if for some reason it could not be replaced, then the applicant would be left in a position where the land use would cease and they would need to complete rehabilitation as required by conditions of consent, and that would be the end of it.
Okay.
And the witnesses can speak further to it. My understanding is that the 6-year maximum duration, there was some basis back in time reference in one of the statements as to how particular numbers come about. It's somewhat unusual in my experience, but you know, it's there, it is what it is. But from the applicant's perspective, there is no risk from a commissioner perspective making a decision on the matter that the mismatch would result in unexpected or undesirable effects, because ultimately both consents are required for the activity to continue.
Okay, is there anything?
And I should add the upside, the reason, of course, the applicant is taking that approach, this exercise is a very expensive one. They acknowledge that they are left with, or may be left with, if you approve this application, they're left with a degree of risk around obtaining a new regional consent. But their preference, if you determine that the proposal is appropriate, is that they're not also left with a whole nother consenting exercise for the land use that would appear to impose an unnecessary element of cost and process. If you found it's acceptable that the land use aspect go through in its entirety, then the risk should be limited simply to that regional side, and that's for reasons relating to the historic 6-year limit, which not much can be done about.
And the situation legally is that an applicant can't seek an extension of time, can they? They would have to seek a new consent.
Correct. Which is unfortunate. There is
That's what
no
that is.
alternative in that regard.
Yes, and the other point, I suppose, is that the land use consent includes the rehabilitation, which obviously, if granted, this would be a critical component of the consent.
I agree.
And that would need to be undertaken within the consent term,
Correct.
say 10 years, if that's where it lands.
Correct.
Yes, thank you.
At paragraph 11, you've made a note there around the retrospective components of the consent. And you've written there that there is nothing inherently wrong with the grant of a retrospective consent. Noticed a footnote there around that consent authorities should not use the resource consent provisions of the RMA in a punitive manner. So that's understood. As a panel, we are interested in the general approach of why those works were undertaken without it as unauthorised works. And we're interested perhaps to talk through that with your witnesses today. I'm not sure if you've got any comment now from a...
My comment with respect to that would be, it is of course open to you to ask questions as to why it occurred. But ultimately, from a decision-making perspective, the why is irrelevant to your decision-making context, because any past conduct issues tied to matters such as enforcement, the RMA has a policy perspective that retrospective consents are provided for, and the reason for that is obvious when one gives some thought, namely that what we want is for people to act in accordance with the law and to regularise activities. If there is enforcement action that needs to be taken, that's a separate council's activity, and that exists to the side. From a consenting perspective, the purpose of that reference in paragraph 11 is that a retrospective consent ultimately is treated like any other in most respects, with a couple of exceptions. Well, one is, and this is not a reason for it to have occurred, but is a reality that often arises by virtue of it having happened. there can often be more certainty about what the effects of any given activity that's being undertaken in advance of consent are, because you can see it, you can measure it. That's not an indication that it's appropriate, it's simply an observation of fact. Also relevant though, and it's a matter you need to engage with here, is that concept of environment, in terms of that Hawthorne has and what the environment is, and you will remind yourselves, I'm sure you'll be familiar with this experience, commissioners, that when you consider this proposal, you must discount any works that are unlawful. You have to somewhat go back in time in your head, unfortunately, and as do all of those undertaking our assessment, and imagine that the environment against which effects of this activity are measured reflects only the position on the ground which is lawful. So permitted activities then form part of the environment, obviously, but to the extent that there is an excavation on the site which is not, which hasn't been subject of consent and requires one, you have to presume that that is not present for purposes of your analysis. But returning to your question, you're free to ask how it came about. I would simply caution you that that is maybe of interest, but it doesn't feed into the resource management context of the decision making directly.
And in terms of, we have got some submitted concerns from Karunaka in particular around conditions of consent, and I guess where it perhaps does concern us is the commitment to rehabilitation in terms of how those conditions of consent are then adhered to. I guess what I'm trying to say is I guess having the unauthorised works didn't particularly create a good start to the process. Would you accept that?
Oh, yes. So I can say that it is perhaps more common than it should be for me to be instructed to obtain consents for applicants where unauthorised works of varying degrees have occurred. I've literally just finished drafting a reply on the weekend for that very activity where steeples were constructed without consent. So it is a thing that happens in our society for a range of reasons. Case law has engaged with some of the complexities that come in that. I've referred, we just had an exchange about the fact that it isn't used in a punitive way. Case law has also engaged with the concept of conditions in the future and whether a decision maker or council are entitled to be nervous, if we can use that term, about whether those matters are going to be compliant with given effect to. So there's long-standing case law that as a decision maker, you must in law assume that a lawfully imposed condition will be compliant with. And so you can't sit here and look at any past conduct and decide that as a result, a lawful and appropriate conditional consent is not going to be worth the paper it's written on. What they would say is it is of course open to you as commissioners, and I'm sure you would do this anyway if you never heard to satisfy yourself that the rehabilitation conditions are ones which are appropriate and where they need to have the necessary teeth to ensure that things occur, that they have the necessary certainty to achieve outcomes. Now, you'll hear from Ms. Polly and other witnesses about rehabilitation and some of the options. I guess what I would add to that is there is always, I think, a balance around rehabilitation between certainty and avoiding fixing outcomes now in a manner that might close off or unduly restrict potentially better outcomes moving forward. And there are various aspects in which that is engaged. But one obvious one that I think of off the top of my head is that the applicant has clearly indicated in its evidence and through the records of attempted consultation with Karunaka that if this proposal is granted consent, again by reference to rehabilitation. There is a desire to consult and discuss and get input from Karanaka and others about rehabilitation and the appropriate outcomes for the site. Now, the applicant, as you know, has indicated that the core rehabilitation intended is to return this land to its current function, that being pastoral use, but there are other opportunities in specific areas, and you have some evidence about that, and you will hear more. And so I would simply observing about the rehabilitation side that you shouldn't be concerned, and you can't be, about the applicant ducking out of their responsibilities, but you will, I'm sure, want to give careful thought to how those conditions are structured and make sure you're comfortable that they will ensure outcomes that are acceptable, acknowledging the various areas that it may be suitable for more detailed plans to be produced down the track for certification, so long as the objectives, as you know, the certification of plans objectives are clearly identified, and therefore it is a certification exercise that you will bring.
Thank you, that's helpful.
The statutory assessment, I don't think I need to speak to. You're all very experienced and familiar with how that works.
If I could just while we're going through that, obviously your 14B talks about conditions. In terms of where we're at with conditions, my understanding is we have a recommended set of conditions should we be of a mind to grant from Mr. Hume, and Mr. McDonald has made some suggested changes to those but hasn't reissued a condition set. Is that correct?
Correct.
Thank you. And in terms of the district council, we've got Ms. Colley has issued an updated proposed or preferred set of conditions in her evidence. So that's
correct.
Where that's so it's just to flag now, I think all three of us do have some concerns about the conditions as they are, and we will be looking for probably we will likely send the planners away to do some work on those, and in particular things that you just referred to in terms of management plans, certification processes, purpose of those plans, how they all link together, rehabilitation plan, that sort of stuff. So just to flag now to all parties that we have we're not comfortable with the conditions as they are currently proposed if we were to grant consent, and we will probably look to use this process to make some improvements to those. So I just thought I'd indicate that now so the planners can start thinking about that and perhaps have a chat in morning tea or however.
So certainly I'll be very, in any event it's irrelevant, my thoughts on it, because it's open to you to direct it, but I'm certainly very supportive of in having Ms. Colley and Mr. McDonnell engage with the reporting planners to address areas that would seem sensible and efficient use of time. Some areas maybe get closed up, maybe they all do, and at least if there are differences of opinion they're highlighted. We don't have to resolve it right this second, but if they were to do that during one of the breaks, is there any merit in you may not be able to do this, but is there any merit in you identifying particular areas that you would like them to focus on? Perhaps I leave that with you and you can come back to it, but they obviously could go into a room together and talk generally, but if there are particular areas which you are interested in, some direction might make the process more efficient.
Yes, well, we've got certainly I have comments, and I'm sure the other commissioners have comments on the conditions Ms. Colley's put together. So when we get to her, we can go through those with her. Be pretty clear, I think, what the concerns are there. The reason I was wanting to clarify the latest version of the ORC conditions is that they sit with Mr. Hume, who we're not due to hear from until tomorrow, so we wouldn't usually have the opportunity to provide questions on that until then, which obviously is quite late. So in the break, I'll have a chat with my fellow commissioners, and we'll just see if there's some opportunity to perhaps do that earlier, so it gives the planners a chance to have discussions over the next day and a half.
I was simply going to observe, you're correct, the written version from the regional side, such as for him. But Mr. McDonnell effectively has adopted those subject to changes. So it is
Yeah, we could do it.
open to you
Right.
to have some discussion with her.
Yes, okay, well, we'll have a chat and
Yeah, I'll
come
leave
back
it.
to you, but see where we get to, but I just wanted to flag that. And, sorry, I'm just jumping ahead for you, but in terms of the written approvals, obviously you've prepared, or your planner has prepared a really useful plan that shows written approval and from a mapped situation. It would be very helpful. I think that Ms. Colley can confirm exactly how accurate the latest version we have of that is. I suspect there's one or two that need to be added, but if she could clarify that at some point, and then if we could get an updated version of that plan, that would be very helpful.
Yes, of course, and you'll appreciate, you can see, as an output in particular of Mr. Johnston's significant consultation efforts, that has been a little bit of a moving feast, and we'll try very hard to try and make it as clear as possible for you. So if any updates are needed, that's fine.
Thank you.
Flow through.
Thank you. And while we're talking about such matters, there was a recent withdrawal of evidence from Franklin and Co.
Yes.
Can I clarify, they've withdrawn their evidence, their submission does still stand though, and they haven't provided written approval, is that correct?
Their submission.
Oh, the whole submission, sorry, I apologise. Yes, no written approval.
No, the land is now owned by the applicant, and I will ask Mr. Hawkeswood to talk about it.
Thank you.
So that's correct, that the land is now owned, that land is now owned by the applicant, and obviously, as a result, the effective position is one now of written approval, because that's implicit in fact that the applicant now owns that land.
Well, if they're occupying still though.
Correct, there is still a remaining issue to clarify around the occupier.
Yes.
So Mr. Hawkeswood can speak to this. My understanding is that if we can call them the sellers of the land, have the right on an agreed basis to remain here for a period of time. As far as I know, they are intending to exercise that, but Mr. Hawkeswood can speak to that in some more detail, because that is a negotiation process that's occurred to the side and has resolved itself fairly recently, as you know.
Thank you. Yes, thank you.
When you say he owns, the applicant now owns the land, does the applicant now own the buildings?
Correct. Sorry, yes, the property.
Yeah.
Correct. So the receiving environment, and I discussed from paragraph 15 onwards, and we've already talked about aspects of that. Paragraph 17, I just mentioned, as is always necessary, I think, to remind yourselves as decision makers that there is a need for a real world analysis that flows out of the whole of those cases that Fogarty did, Justice Fogarty did back in the day in Queenstown. And that means then that whilst references might be made to desired outcomes or hypothetical outcomes or historical positions, you can't substitute that for what willfully exists. And there's always a framework within which you're considering the environment as defined, overlaid in this case, as you know, the point we've already discussed, namely that unlawful works, though, have to be treated with head-on present.
Thank you.
Written approvals touched on, and to the extent within the updates required, those will be provided. But in short, there's a significant number of them, and by reference to regional matters, I think the only bore for which there is a potential set of effect, for which there is no approval, is misgovernance. Consultation is, of course, both a very important part of the RMA, and one always has to remember something that's not required. What can be said here is that substantial efforts been made by Mr. Johnston. You have seen those efforts in his evidence. In paragraph 24, I referred to the absence of a cultural impact assessment. That's unfortunate. The applicant has made efforts to obtain one. You can see those exchanges in the communications and record of consultation that is attached to Mr. Johnston's evidence. And ultimately, the applicant can't do much more than request a cultural impact assessment and indicate their willingness to pay for one. And I can't take that particular aspect much further. But what it does translate to, though, is a scenario where it certainly wouldn't be appropriate for the applicant to be, for want of a better term, punished in the absence of a cultural impact assessment when one has been requested. The applicant has engaged in good faith and has done what it can, and we then are left in a position where more information and detail would be nice to have, and it may be that some of those gaps have been filled in by the evidence now lodged on behalf of Kaurunaka, and we're going to hear, of course, their verbal presentation tomorrow, and that may fill in more. In the interim, what can be said is that the applicant remains open to more consultation. The door is open. They've continued to engage with Kaurunaka, and the proposed conditions of consent anticipate further engagement in a range of areas as well, by reference to works on the site with potential archaeological implications, and also by reference to matters like rehabilitation, the like, and the applicant's open to engagement with Kaurunaka about matters like that, monitoring and so forth. The effects assessment for this matter is extensive, of course, because of the various matters engaged. I make the observation that, as you would expect, aspects of mitigation and outcomes and imposing conditions of consent, of course, are relevant to your findings as to degree of effect, because those go to, if you like, the net outcome. There's nothing controversial in that statement.
In terms of 29, you touch on temporary effects, and there's been some discussion in, I think, all of the planners' evidence around that. I wonder if it's useful just to touch on that. Am I correct that I think only one of the planners think that this activity comprises a temporary activity in terms of the district plan? And I think that's with Sterling in her report, but the others all have the view that it's not a temporary activity as defined. So I'm intrigued that you've raised temporary effects as
well. The point being made really there is, in a lot of ways, the focus on the word temporary has been unfortunate because it's defined in a certain way, and it's perhaps led some of those accepting this application into an unnecessary cul-de-sac. The point is that it's an activity of limited duration.
Yes.
And it's one that, when complete, will result in the land, all intents and purposes, the bulk of the site looking the same as it does now, being pasture, or essentially the same. And there is the opportunity as well.
Hopefully it looks a lot better than it does right now.
Sorry, you're quite right. I should refer to its former condition. Pasture. And then there is the commitment by the applicant as well to undertake further planting and betterment of various areas from the respective landscape and biodiversity type outcomes. But I think that's really the observation made in 29 about betterment. It's rather it hung up on the temporary.
Yes.
It is that it is of limited duration, and I say to you that is relevant.
Yes.
To your consideration. And there's even a subset of that, and more relevant to some effects than others, relating to the staging of the site and the fact that, perhaps unlike some other mining activities which may have a more fixed area in many respects. This is one where, as you know, the pit area and the dredge will move around the site. And that will result in differing levels of effect at different times. If you were to talk about a view of the site from further away, where you could see all of it, the area of effect will move around, and perhaps the overall, in an overall sense, it might not make a significant difference because it might be in one part of the view, but in another. And from a noise perspective, that shifting around by virtue of the staging and the way the activity unfolds is significant. Because when Mr. Higley's assessment talks about what is, in essence, peak effect, if I recall correctly, he's talking some 3 to 6 months period where you might have that peak effect in the context of a 10-year duration, and then that activity and noise moves away. So that's a subset of the way in which the activity is undertaken, that effects vary over time because of that aspect of it, and after 10 years they cease altogether, and you are returned to a scenario where that land begins as, from a visual perspective, as something that aligns with what sits around it. And you could easily think, of course, of other activities where either classically as a land use they have no end to them and they can just continue, or others which involve a permanent change to landscape that will never be reset. And in that sense, this application is different.
Thank you.
Turning to Ms. Colley's assessment, and we have some very detailed, comprehensive assessment comparing a lot of the piece that I don't really propose to address the permitted baseline to any significant degree, other than perhaps it's been referenced most commonly in the context of the noise assessments. The applicant is not saying to you that you should adopt a permitted baseline approach whereby you discount effects of noise sitting at the maximum noise level permitted 7 all the way through. That would be offensive for proposition, I think, and that's not the approach that's been adopted. What I would say, though, while we're touching on that aspect, is that the noise limits in the plan as a method giving effect to higher order objectives and policies, those noise levels do reflect ones that are regarded necessarily as reasonable in the environment in a general sense, subject to any assessment always having to take account of section 16 of the Act and unreasonable.
Yes. Thank you.
Visual amenity and landscape character. My understanding from that most recent communication, accepting as we started a few minutes ago, the 22 actual plan versus the temporary ones, but my understanding of that latest addendum that's been provided by is that really the gaps, such as they were between variables and more, have been resolved, and there's agreement that the outcome is appropriate. And I would simply record then that the application in front of you has been carefully considered by Mr. Moore. The exercise you'll need to go through, as Mr. Moore has, as Mr. King has, of course, needs to discount effects on persons on land where there's been written approvals, which there's quite a few, and then the applicant's taken a range of steps to manage visual effects through adoption of bunds and so forth, and some of which have landscape functions, some of which also are there specifically to manage noise. And key to this proposal as well is the fact that in my submission is that the rehabilitation is one that is ongoing through the project. So I'm familiar with a number of other foreign methods where I'm engaged, where your rehabilitation exercise is very drawn out and in the end doesn't occur essentially until right at the very end of the process. In this case, the evidence from the applicant, which is can see from that staging plan is that we have progressive rehabilitation following along behind the moving mining activity. And I think is helpful and beneficial from a landscape visual engineering perspective. Touched on noise, you're going to hear from Mr. Egley. I'm not familiar with Mr. Egley. He's been around a long time, very experienced expert. I must say, I always find slightly frustrating the acoustic assessments in the sense that what is common, I find, with them is that the assessment is undertaken on the basis that it adopts a worst case scenario. And my experience over many years is having undertaken this worst case scenario and identified a maximum noise limit. Many in a hearing, often in submitters, and with respect to them, perhaps because they're not that familiar with the process, then start talking about the proposal as if that maximum yield is what is going to be expected all the time. And I would simply caution you and remind you that where a very conservative position has been adopted at the you still need to look through that and remind yourself of what the real expectation of the activity is. And if it reflects a peak noise scenario, which in fact is unlikely to occur and is subject to varying peaks and troughs because of, by way of example in this matter, the operational area moving, you need to remind yourself that that peak level is not what we've experienced. Yes, in fact, it represents a high watermark for a shorter period of time, and may in fact be a high watermark that of itself is never reached, because Mr. Egley's assessment is assuming, by way of example, a number of machines working in very close proximity in a way that in fact doesn't represent what is likely to occur on the ground, because it would be unlikely that all of those will be crammed together in such a small area. It's been done to give a very conservative position. So it's something that.
Okay, thank you. Yep.
Vibrations after the light spill, I don't make particular comments on. There's been a lot of work on the dust side, and one of the benefits of this process, as you believe with, is that it is a wet one, and so the operation of the dredge itself, because of the way it works, essentially resolves dust. Beyond that, if you have a review from PDP, is agreement, I think, that the dust management plan, the draft dust management plan is something that will be effective. And certainly that can be spoken to further by Mr. Hill, you and I say, to the extent we have concerns there that can be resolved either directly through conditions or through construction of a management plan condition that is appropriately constrained and has appropriate objectives. Rural character, I don't have much to comment on, particularly other than I would emphasise, because it's raised in various aspects during reporting and the evidence, the question of functional need. So there is a functional need where one is mining a resource for the activity to occur in the place where the resource exists. That's self-evident. That's a different thing, of course, to whether it's appropriate that it goes in. That's a separate thing. But from a functional need perspective, where one is extracting a resource, the functional need is driven by where that resource is.
Question on that for you. Functional need as opposed to an operational need. Do you see those being different?
Clarify operational need.
So functional need perhaps being where the resource is, but only being in one position, one place, for example. Operational need being wherever that resource is. Operationally, you can achieve the outcome.
Do you mean by that question, is the proposition essentially there might be gold in lots of places, so why get gold from here?
Yes.
Well, that's not a matter for you, because If we were going down that road, we'd be talking about a licensed economy or a state-directed economy where central decisions are made about what resources citizens can choose to explore. That's not the way the RMA is constructed. Any applicant is entitled to apply to undertake any activity in the location. The question is, as to whether it's appropriate, is driven by other factors, but not that classic kind of proposition, or why don't you go somewhere else?
Sure. I guess from my question was angled, given the policy framework that we will be considering coming down from the NPSFM, which uses that word quite purposefully and deliberatively. Just interested in how functionality is actually defined. But I think you've addressed that.
Yeah, I mean, if you're talking about fresh water, I mean, I'm familiar, having read the decision, and I think one of the commissioners made and been on the panel pushed out. There was an application recently, wasn't there, to dredge in the river, and that's a different example of someone looking to extract gold. The approval or not, and there was a not in the case for that exercise, is driven by what effects it will generate and how it lines up with the policy framework, but it doesn't equate to a proposition which is one that's been considered and rejected in case law, that an applicant must demonstrate what they are proposing is the best alternative for extraction, in this case of gold, in New Zealand or in Central Otago. You don't need to go through that exercise. What you have to show is that in the particular circumstances, this proposal is one that can be executed and carried out in a way which from a fixed perspective is acceptable and which aligns up appropriately with conditions of consent.
I was on that Clutha Gold.
I thought you would.
That thing with the functional need is that the mining permit, exploration permit and mining permit process under minerals has some bearing on functional need. You have to demonstrate with Crown Minerals that you have functional need to mine that site. So I thought that's got some relevance to that issue.
Yeah, I mean, I suppose that might be to some degree evidence, perhaps a functional need.
What demonstrates there's gold there.
Yes.
So therefore you can't extract the gold without being in that location. Therefore, it's a functional need.
Yeah.
I think it's quite simple.
Yeah, I accept that. I agree with that.
Thank you.
I suppose the only other observation, just in passing, I think Mr. Moore used some reference to the activity having a semi-industrial type character to it, and I think it's quite an interesting proposition to grapple with in that sense, because the reality is, in a real world sense, the prospect of someone applying to establish a mining operation of whatever type in an urbanised area is, I would suggest to you, essentially nil. The reality is mining is always going to be establishing largely in a rural area, but it has, of course, a different character to pastoral use. And I'm reminded of that need not to be trapped when one thinks of rural amenity, trapped into sort of the pastoral ideal type. You know, we're not talking about a bucolic concept simply of waving grass and gently lowing cows. The working environment does have those things, but it is also a working environment, and there will be a range of effects that sit within it. And in this case, that semi-industrial reference made by Mr. Moore, as I understand it, firstly is sort of to the proposal in its bare bones sense without the mitigation overlaid on the top. And I think also relevant is that limited duration discussion we've already had. It would potentially be a quite different thing if the activity were one that was permanent. But it's really that need to adopt that real world lens about rural community and character encompassing a range of different activities. Archaeological and heritage values, that's the subject of Ms. Ross's report, and you will hear from her later today. There are some archaeological sites that are known within the project area. They're referred to. The values of those in a general sense, as says by Ms. Ross, are relatively low. I want to hasten to it that does not mean that they don't matter, but there is, of course, a need to be objective in that assessment and identify the values of what I was talking about, and that is something that Ms. Ross has done. Some of them will be destroyed by the proposal. Some of them will largely be avoided. There is an application in train, an accidental government authority, the HCPCA. And I think there's an opportunity as well that's evident when you look at the proposition and mitigation that Ms. Roth advances, which is summarised in paragraph 50. There's a range of steps that are proposed. So you will have seen that a site has been divided up into different risk areas, and that informs quite detailed conditions of consent about how works in those areas will be managed. I think it's an entirely proper and appropriate response. Going beyond that, there then is some direct archaeological monitoring of topsoil stripping, which is, as I understand it, where if there were things to be found, the expectations would enlarge from there in that layer. But then matters have gone beyond that into particular areas in the vicinity of team review. I've seen reference there to specific test trenches. There's a methodology explained for why that is adopted, and that exploration is intended to occur before further works, any further works occur in that location. And that's, again, a very directed and intentional approach to establish the potential for further informed assessment. And that's the other aspect that one can derive from Ms. Ross's assessment in that respect, as you will see. The proposition is not simply that two trenches occur and that's it. The point of the trenches is, in fact, to inform them an expert input on what more might be required. Now, it's possible to know what might be required, but it's also possible that the information derived from those trenches mean that more will be needed. And so the point I'm emphasising here is simply this isn't a set and forget. We'll dig a couple of trenches and we're done here. Those trenches are intentional and they are focused on informing next steps, and more may be needed. Works aren't occurring until that is explored and resolved. And the other matter, I think that offers real upside are the artefactual remains that do exist. You would have seen the evidence, there's some huge buckets and some wire and rope and various other bits and pieces. It's possible more may be found. And there is an opportunity to take those, which currently sit on private land, and place them next to the cycle trail, which, as you know, attracts tourists and visitors to the area, and display them along with information which is very additive, I would say, to the experience of the public introducing through this area, and help inform them about that background. And although there was a lot to read in the archaeological report of 140 pages, but it was actually awfully interesting, I felt, which is some of the sidebar, but it was really interesting to read about that backdrop. And so there is a real opportunity then through this mitigation to help bring that archaeology and history to light. And that mitigation, therefore, is something that I say isn't a token, but in fact is particularly meaningful in many respects because of the presence of that trail. As therefore you are interfacing an active recreation area with tourists with information about the landscape through which they're travelling, and that I think is meaningful in this case. Transport and flood hazard, I think there's a lot to be said there. Transport, there were some exchanges I believe, around the appropriateness of the exact type of access required, and I understand that it's now being dealt with. Public access, I simply observe, I'm not clear why there's been concern about public access. Critical to this proposal, and I think pleasing about this proposal, is that there is a solution to rerouting of the cycle trail in a manner which keeps that trail moving, doesn't materially change the experience, can be protected by bunds from works that are being undertaken and throughout the exercise, both for those using the trail and for members of the public visiting this general area. There will be a way to access the river throughout, and no point is that severed. So public access being maintained is of course an important outcome and is provided for. Biodiversity, I don't think I really need to say anything. You'll have questions, or may have questions from experts from a perspective of livers that's been dealt with. The assessment of Dr. Wills engages with Flora on the site. And then you will have also seen that analysis from memory, Dr. Albone, about Team Burn and what's actually present. So you will have noted that there were some species that were recorded earlier in times and been there that sadly are no longer. That reflects a real world position from an applicant's perspective. It is set back from Team Burn. There will be water augmentation required. And the expert opinion in front of you is what the applicant is undertaking will have no adverse implication for species of biodiversity generally or in Team Burn itself. And the only other matter I've observed from memory is at least some of the submissions made, at least one submission made reference to the potential for enhancement around Team Burn possibly. And I just remind you, the applicant doesn't control that direct interface with Team Burn. It's land owned by others that sit in the place, so it's not something. Cultural values are one.
So just on that, so they don't own the land. Is the owner of that land a party to the proceedings at all?
I will leave the detail around discussions with the owner of that land and what is possible and what is not to a combination of Ms. Colley and Mr. Hawkeswood.
Thank you.
Mr. Johnston. My recollection, I'll preface this by saying.
That's okay.
Correct.
Why don't you leave it to your witnesses? Yeah.
I simply say I understand there was discussion about some enhancement, but that the landowner wasn't prepared to agree to it.
Thank you.
Cultural matters engaged with by Ms. Colley and of course then in the regions by Mr. McNeil to the extent it is appropriate for them to do so. They both acknowledge that they can only go so far and it is not for them to make definitive statements about cultural values which are forthcoming and they can make. But within the confines of their expertise by reference to the way that the exercise is being, the proposal is being advanced and the understanding of the issues that have been shown taken to date, there is an analysis provided.
Thank you.
Regional council matters.
Could you just hold a moment? I'm sort of overdue for a break and I'm waiting for people standing. There's apparently chairs in the back room and it takes about 10 minutes to take a break now. So we can get some seats. We're going to take the morning tea break. Really mindful we've got people standing, which I'm uncomfortable about, and there are some seats apparently in the back cupboards, but didn't want to disrupt. So we'll take our morning tea now. We'll get some seats so that everyone can have a seat, and we will come back at 11:05. Thank you.
It is regarded as a very direct wording. There is the associated observations, both with salmon and in other subsequent cases that might be summarised as words matter.
Yes.
And the point about that is you just can't do the wording in a very binary fashion, and as soon as you see it, red flashing lights go off in your mind and you run for the hills. It's a scenario where you need to carefully look at the wording in question, because often it may be qualifying in various ways. And it's also the case as well, if you look at 103A, there that there are cases where litigation or other people may certainly be avoided standard by bringing a level of harm down to one which is appropriate. So just underlining it's not a sort of a binary or a blunt scenario.
Thank you.
Beyond that, I'm happy to respond to what questions you might have.
Thank you. What?
Paragraph 96. About heritage, historic heritage value defence. We've got the ORC land use consent for wall construction versus the CODC land use consent, which have got sort of different interpretation of the effects on those values. I just wondered which should take precedent in your mind, or so they're both important. And this may come back to the chair's statement about the planners needing to talk to each other.
And sorry, just so I'm clear, when you say which would take precedence, what are you comparing?
Well, there's two land use consents. They both address effects on heritage values.
Yes.
I'm talking about the Section 42A officers' reports.
Yes.
Both address heritage values, but they've got different ideas on the effects on those heritage values. So which would trump the other?
Well, I don't.
Well, they're both important and they need to.
What neither really trumps the other, I think, isn't if you as decision makers, you're going to have to make some findings around the degree of effect, and you have a range of opinions in front of you about where that sits, and you are going to have to make a determination as to what your view is the ultimate position. It would assist you, no doubt, if the planners post some sort of discussion, we're able to close gaps. But I when you say one comes the other, and you know, their opinions.
I understand where you're heading with the, we have to take the evidence into account and weigh up the evidence, but normally in other processes I've seen the district council takes the lead on heritage values and the regional council is silent. So it's just wondering whether you thought that the district council should really be the one making the statements on that basis.
Certainly, for what I perhaps I could say about that is from a reporting planner perspective, you would expect the commentary and opinions expressed should be confined to, would relate to the jurisdiction that's engaged.
Under 30 and 31.
And so in a scenario such as this, you would have thought the primary expression of views would likely be by reference to the land use aspect. I don't know if I'm going to say one. I appreciate it's just a turn of phrase that's come to mind, but trumping maybe it's not the right way to think about it, but I certainly agree that you should be looking at those views in the context of what the consent is sought for, and you would have thought, and I would expect that in this case, the primary consideration will in the context of the district consent.
Yeah.
Well, other than
I'm here to guys. Paragraph 131. This is an issue about 30 people, 30 persons on site and 20 versus 20 persons on site, and whether or not that's within the scope of the proposal. My understanding was that was to cater for mitigation measures. Is that correct? The staff involved with monitoring and on-site water monitoring, air dust monitoring, etc., and helping.
Perfect. As explained to me, my understanding of Mr. Mitchell and Mr. Johnston is that having given more thought to the package of obligations that can flow with the conditions if this matter is approved, there's going to be quite a lot of work engaged on the monitoring side, mitigation side, and there was also a potential concern that perhaps the numbers should be capturing visitors to the site, dropping off and so forth, and that is the basis for that relatively small adjustment, correct?
Thank you. Thank you. Anything for you, Christine? No, we're ready for your witnesses. Thank you.
Okay, so the first witness called on behalf of the applicants is Mr. Hawkeswood. Morning, Commissioners. My full name is Andrew Theodore Hawkeswood. I am the Director and Shareholder of Hawkeswood Mining Limited and Hawkeswood Civil Limited. I've been involved in infrastructure projects, construction and demolition waste recycling, resource recovery, exploration, drilling and mining for 29 years. Over the past 3.5 years, I've collaborated with Simon Johnson, the Hawkeswood Mining Limited Operations Manager, on various aspects of the US Flat project, including permit applications, consultations, exploration planning and public engagement. I produced a statement of evidence dated 29 April 2024. My evidence addresses the following key matters: acquisition of gold mining, alluvial gold mining assets, and investment in alluvial gold. Hawkeswood Mining Limited is a family-owned New Zealand-based company. Alluvial gold mining assets and an option for permits on the site were purchased from Kaika Limited in 2005. Hawkeswood Mining Limited has an extensive family history of involvement in gold mining, tracing back to my wife's grandfather. We hold the largest inventory of mining equipment in Central Otago, including the largest operational alluvial mining dredge in New Zealand. Over the past 3 years, Hawkeswood Mining Limited has invested over $12 million into alluvial gold mining in Central Otago, primarily into this Millers Flat project. During this time, our workforce has ranged from 4 to 14 full-time employees. We anticipate the need for 20 to 25 full-time staff directly at the Millers Flat site, along with an extra 8 to 10 positions off-site and through subcontractors. At current rates, that we anticipate that over the life of the mine operation, approximately $28 million will be invested into the local employment, wages and royalty payments. Hawkeswood Mining Limited anticipates that the mining operation will result in significant flow-on effects for local providers such as accommodation, hospitality, mechanical engineering and manufacturing. We intend to fill 90% of the employment positions from the local Millers Flat community, contributing to the wider economy over the life of the mine. Hawkeswood Mining Limited considers the contributions to the local economy will be significant.
Thank you, Ms. Hawkeswood, very helpful. In your evidence and in your summary, you suggest that you intend to fill 90% of the employment positions from the local and wider Millers Flat community. And certainly we've seen numerous submissions from all sorts of people who are supporting your proposal due to gains they perceive for the local economy and for local employment. How do you know, or what basis are you making that assumption that you'll be able to obtain 90% of your staff from the local community? How do you know? Do they have the right skills? Do you know there's available people? What are you basing that on?
Just from the last 2 or 3 years when we've been here, the local inquiry, it's quite significant. We get probably 2 or 3 inquiries per week, especially after some sort of newspaper article or something like that about employment from, especially with the slowdown with the economy. A lot of people from Queenstown that are travelling to Queenstown and are looking to stay in the area.
Yeah.
To work.
I've got a follow-up question on that one. Thank you. So in terms of follow-up inquiries, what's the nature of the roles that generally you require on such a, the scale and the type of mining project? Are there certain skill sets that you require on site, or are they general skills that can be readily found?
Skills for excavator operators and bulldozer operators and stuff like that. Apart from, you know, dump truck operators can be trained. You know, obviously the monitoring and all that that we dealing with now
Yes,
can be trained, but we'll probably need semi-specialist people for that sort of role.
right, and so those semi-specialist skills, are you know with certainty that they are in the local area
The
through?
specialty skills I couldn't, off the
Okay.
top of my head, I can't answer that, but definitely, you know, the welding, you know, the engineering side, the operator side, we have no problem following those roles.
Okay, and so what proportion would be specialty skills and what proportion would be general skills that you would feel comfortable training?
Probably 60% specialty, 40% general.
Okay. Right, and so so you expect to fill 90% of the employment positions from the local and wider Millers Flat community, but but there's still a little bit of uncertainty perhaps about those specialist skills that you would need. Have I heard that correctly?
Yeah, there is a small bit of uncertainty just about specialists, but yeah, the unskilled work is no problem.
Okay, great, thank you. And in paragraph 15 of your evidence, you've mentioned that you use the services of the following local providers. Are these all the providers that you're using within this environment, or are these providers that you generally use in some of your other operations?
These are all local, these are all within this project.
Right,
Yeah.
so all found in
Other
the,
projects, maybe other projects in North Island, but these are the specialist ones to be used. Local Millers Flat, as like Alexandra. Project.
Is that currently used? You currently use those, or
Absolutely.
you will use those?
And we will use, yeah, we currently use and we will use.
and in terms of, so it's really helpful, thank you for that contextual information about the skills and experience, and you've got some projections there around value to the wider economy. Have you sought any independent expert economic analysis at any point to support those projections?
No, I haven't, but I can only rely on past experience.
Yeah, from your other operations.
Absolutely.
Okay, right.
There doesn't seem to be much money left over after the end of it, so I guess it goes somewhere, but I ain't got it.
Okay, so no independent economic analysis or social analysis for this process. Okay, thank you.
Just wondered in paragraph 14, just one couple of questions. What do you mean by wider economy? Paragraph 14. Is that Otago region or is it?
I mean, I would say the New Zealand, I mean, the wider economy, I'd say the New Zealand economy, I mean, fuel's a factor. Tax is a huge factor. Royalty payments.
And local employment, is that central Otago? Is it Otago regional? Do you know what do you mean by local?
I would say anywhere between Dunedin and Alexandra. We would prefer, we actually prefer to have local because then we don't have to provide accommodation. We don't want to be a fly and fly out. I'll move here myself and be here for the duration of the project.
Would it include Queenstown as well?
Yeah, we would take people from Queenstown, but they would have to stay here during the week. It'd be too far to drive.
Cromwell.
Yeah, absolutely. Cromwell, there's a couple of guys that come from Cromwell now.
Where do you live at the moment?
Southeast of Auckland.
And Commissioner Day Cleven touched with your legal counsel earlier about the fact that you've started works that have breached district plan rules, regional plan rules, and obviously you're now seeking retrospective consents for that. Can you give us any context about why that's occurred, what your intentions were there?
We believe that we had, starting the district plan, that we built our 4 titles, we would be able to move 12,000 cubic metres as of right. And that there was no limit on the roading in rural areas. You could basically move, I mean, it was If it's, we accepted that was a mistake. We did the work. We were initially terrified of the filter river, that we would get ingress into we wanted a decent sized pit that we could actually measure that, and we did a lot of studies in hydrology. We initially thought that the energy cost of this project to keep water upward, or to put sheet piling down the side of the river, would make the project uneconomic.
So when you say ingress, do you mean flows from the river into the site or the other way around?
No, it flows from
Okay.
the site.
Yeah.
That was our biggest concern ever since the late 2000s when we first looked at this. We were always concerned about the river. Once we'd established all of that, and we did our exploration, gold recovery as per the drill results, we stopped work immediately. It was 2 months between the period when we stopped work to when the council inspected the site, and we stopped. And we have an impeccable track record on other sites, and since then we've done everything to comply and to make right what the mistake we made.
So when did you stop work?
March 2022.
And no further work since then?
Apart from the settling the dredge, which was an allowable activity in.
Okay, thank you. And no further earthworks or excavation? And is it you or is it Mr. Johnson we're best to ask about the relationship with kind of Runaka and the work?
Mr. Johnson.
Okay, and how that's gone and so. Thank you. Thank you.
The next witness is Mr. Johnson.
Perfect timing.
Good morning. My name is Simon Johnston.
Just a moment, Mr. Johnson, I'm just pulling up your evidence. Thank you. Off you go.
Right, yeah.
No, you're all good.
So my name is Simon Johnston. I'm the operations manager for the Hawkeswood mining project at Miller's Flat. I live in Alexandra with my partner and my 2 children. Travel down to site each day. I have 18 years experience working for Hawkeswood Mining and have worked on gold mining projects in Oldham Station, Wi-Fi, Blenheim, and Hawkeswood. I'm familiar with the area the application for resource consent relates. I've visited the site and surrounds, and I am on site most of it. Scope of evidence will address the following: consultation, operation of the mine, rehabilitation, and our just recently granted archaeological. Just this one.
Just this minute, even.
How good is that?
Thank you.
I wasn't aware of that.
I was going to ask that question.
Consultation. I've had extensive involvement in project consultation since September 2020, engaging with neighbours, community groups, and relevant organisations. Efforts to address concerns raised by the likes of Ministry of Education, Fire and Emergency New Zealand have been made, and despite challenges with consulting with Runanga, significant efforts, including negotiations and technical assessments, have been invested to address concerns, demonstrating commitment to comprehensive stakeholder engagement. The operation at the mine and exploration permit was granted in October 19, 2021.
following by a mining permit on April 17, 2023. Operations await consent and pre-operational conditions. Recruitment, training and dredge preparations are necessary for port commencement, with no anticipated recruitment delays due to local interest. Updated site plans address feedback, including bunding and site vehicle access adjustment. An erosion and sediment control plan responding to Pakaha's concerns is drafted with ongoing refinement plan. We have worked extensively in accordance with various reports, dust, sound, water, etc., to ensure we are good caretakers of the land. The rehabilitation plan for the farmland project area involves backfilling the mine pit, contouring the ground surfaces, and reinstating farm infrastructure as per the landowner access agreements. Biodiversity efforts will focus on exotic species removal and native plantings along the cycle trail and riverbank, with ongoing consultation with stakeholders. We have invested time with key stakeholders like the Cycle Trail Trust, Aotaha, etc., to ensure we understand and consider their biodiversity requirements and requests. Our archaeological authority was applied for and accepted on the 22nd of March 2024 and is no longer undergoing processing, has been granted today. That's all I have.
Okay.
Yes, thank you for your evidence. My first question is, what's the settling time for 18 metres of backfill?
What's the
Settling time? You take a bank cubic metre, put it on the ground, it swells, then you put it back, it's swollen, and then it settles back down. What's the settling time?
Due to my experience with putting material back, I've found that once the heavy trucks have been running over it for over a month, you generally find that that's basically dropped back to where we would expect ground level to be sitting.
In this case, the backfill is going straight back into the pit behind. It's not being compacted as it goes. There's 18 metres of it, so I just wondered if compaction on the surface with trucks would make any difference to the stuff that's 18 metres. Yeah,
Again, with the experience I have in the past with our past mining projects, we've had our heavy machinery, the loaded trucks running around on surface, and that has been sufficient to compact the material below and allow the top surface not to have a sinkhole in.
Right.
Which you can actually see that in the areas that we've mined in the past. At Ulrich Station, at Thompson's Gorge.
I don't want to dwell on those because they're not the site. My question relates to this site. So in your opinion, is 1 month appropriate settling time with compaction on the surface for that 18 metres of backfill?
Yes. To give us a accurate level for us to topsoil to a month, isn't it?
Is it possible to, because you were quoting other examples where that's been appropriate, but I've seen other sites where it's not appropriate. It takes 1.5 years for settling to occur. So have you got any technical evidence about that?
We haven't had our geotechs look at that. The geotechs have only looked at slope stability at this stage.
Okay. The reason I'm asking the question is it relates to the rehab staging. And if it takes, for example, a year for it to settle, you've got to deal with that topsoil on site before you can place it back on so that it doesn't settle, and then you've got to place more topsoil on to fill the gaps. So from our perspective, it's an important part of the rehab of the mine site, so we'd like to get some more evidence on that if we could, please.
Yep.
No problem.
Are you clear on what the commission is looking for from you on that, or Mr. Grant, do you want to?
Settling times on the alluvial gravels here at Hawkeswood is what I assume, I seem to.
It's just that there's 18 metres of swell to account for, and so, you know, it's quite a thick lens.
The same stuff can be looked at the Waikaia Gold Project and Waikaia there. The same way our project will operate is the way their project operates.
If you're going to make comparisons to that site, you have to make sure that it's the same kind of alluvium.
Yep.
Same depth, everything. So
Yep.
it needs to apply to this site, not just say, hey, it's okay on this site. Okay. Yeah.
Yeah. Want to go?
Yeah. Thank you, Mr. Johnson. I have a couple of questions for you. It came up earlier around the enhancement of the timber burn, and there was some suggestion that that was out of the applicant's control due to property tenure. Are you able to talk us through that issue, if you're familiar with that?
We have chatted with the landowner who occupies that piece of land, and their take on that is it is not something that would be possible for us to do.
Right, so, okay. So you've chatted to them once or on more than one occasion, or?
I've spoken to them about that.
Okay, right. So from your perspective, you can't take that any further?
I took it as a strong no.
Do you know if that landowner is a party to these proceedings? Are they a submitter, or have they provided effective party approval, or?
Yes, they've provided a people party approval, and yes, they are submitter on.
A submitter as well. So submitter and support, one assumes, if they've provided a, yeah, thank you.
And so where is that, which on our affected party approval map, which one is that? What number?
Uh, 1534 Teviot Road.
1534 Teviot Road. Oh, yes. Yeah. Thank you. I recall in some of the documentation, it may have been in Ms. Colley's original application documentation.
Sorry, just on that. 15, did you say 1534? That's Matthew Ross Hunter.
Correct.
And so we're going to, Matthew Hunter's going to talk this afternoon, is that right?
I don't think Matthew will, but.
But someone on behalf of that, so we could ask questions on it as well.
Thank you. Ms. Parker, you're obviously listening there. You might be able to talk to that when you have your opportunity this afternoon. Brilliant, thank you.
Yes, so I recall some discussion potentially in Ms. Colley's application document around those properties further up Clutha Road. I think it was 61 to 68. We've got 67 has not provided written approval. Are you able to comment on that? Have you engaged with those parties?
Yes.
Could you just remind me of where things sit with those parties?
The last conversation, and I have been trying to contact them recently, the last conversation we had with the guys over there, they basically just wanted to be seen as an affected party, and that they had small issues with noise and that was basically the end of their concern. I have obviously spent quite a bit of time trying to get a hold of them, but I think they must be out of the country at the moment.
Right, so that's for all of those properties along that stretch of road, or?
Only the one that was.
Okay.
Yeah.
Yeah, and which number is that again? 67?
Yes, 66.
67. Okay. So in the summary evidence of Miss Badenhop for the ORC, she has raised an observation that when she was on a site visit with yourself, that you stated that there were several groundwater monitoring bores that had been monitored for over 12 months.
Yes.
And she was unclear in her evidence as to why none of that data had been documented and used within the assessments presented by the applicant.
I would suggest that's a question for Mr. Allen.
Okay, thank you. And
We have all of that monitoring information available. There was also some concern she had around the collar heights of the drill holes throughout our project as well, which we have since clarified with.
thank you for that. And in your evidence in chief, you talk about the new site plans outlining the various stages, and you've referenced the updated site plans, which we've heard about this morning. And I note that in paragraph 19 of Mr. Vile's evidence for Karunaka, that he's noted that the dimensions of the sediment and infiltration ponds required for each stage are not specified. Has that issue been resolved as far as you're concerned, or how have you addressed that?
Our feeling on the sediment control plans is we would like to see the water come out of the sediment control ponds clean before it leaves the sediment control ponds. It's a difficult thing to put a time frame on how long that water needs to settle the suspended solids out. So as we have begun with having the sediment control ponds now, which we're working perfectly fine with the volume of water we had coming up, they're roughly 80 metres, I guess, by 20 metres wide, and there's two of them. They settled the water out just fine. In the future, if the water's slightly dirtier, we may need to increase the size. If the water is fractionally cleaner, we can reduce the size as we build them. As something that we anticipate taking in our stride as we.
Would you use flock socks and flocculants to change the size of them?
No, not at all. We didn't see that was required. The material settled out quite nicely actually.
Right. Okay. So in that sense, you're not wanting to fix the dimensions?
We didn't want to fix dimensions, no. If that's something you see as important, then perhaps it's something we can condition on consent.
Thank you. We'll talk about that issue. Thank you. That's it from you.
Thank you, Ms. Johnson. Would you say you've got a good handle on the management plans that have been suggested by various experts and pulled together in the draft conditions? Do you think you've got a good sense of that? Yeah, okay, great. In your evidence, para 6, you've talked about an erosion control plan. Where would we find that? Is that the one that's appended to your evidence?
Correct. Yep.
Yeah.
I have a copy here.
Okay, great. And is that, I couldn't find that, and this might be a question for Ms. Colley, but I couldn't find reference to that plan in the conditions that have been put up for the district council consent. I haven't had a chance to go back and check the regional consent. I assume that it's mentioned in there. And I also note, in addition to that, just this district council consent, we've got the gold mine management plan, site emergency management plan, operational noise management plan, dust management plan, rehabilitation plan, number of plans. How would you, I assume will you be responsible to ensure that if we did grant consent, that those plans were, you know, completed, certified, given effect to? Would that be your responsibility? Yeah.
Yes.
What methods will you use to make sure that's happening? It's a pretty big job. What's the,
Huge.
yeah,
Well, for a start, I think, as been earlier mentioned, we will require to employ extra staff to take care of all of these plans and all of the compliance required. So perhaps a compliance officer on site would be a wise move for us to take care of all of that stuff.
yeah, I mean, it's certainly my experience with projects of this sort of scale that an on-site compliance officer / environmental advisor is sensible.
We have had
That's
the option
something we
of dealing with Quinn McIntyre from the Boroscope, who has kindly offered his services to take care of these problems, which is also an option for us to farm that out with him to look after our compliance side and put together our gold mine management plan as such.
And if we were of a mind to grant, and obviously we'd be looking to impose conditions, how comfortable would you be if we were required as part of that, a specifically appointed person to be responsible for compliance and environmental advice?
As long as it's somebody we can.
We wouldn't say who it is. That would be for you.
Have on our staff, that would be not a problem whatsoever.
But just someone that has that responsibility that we require.
Most definitely, because it is a really large job to take care of, you know. And yeah.
And would be working in with the council compliance officers.
Yep.
Yes. Thank you. I think most of mine have been covered actually.
I've got one other question. One additional question from me. The Archaeological Authority that has come in very timely fashion this morning. I appreciate you may not have had time to read through it, but has it been approved on the basis on which it was submitted? Or have that? That's fine. We can.
It literally came in 5 minutes ago.
That's fine. Thank you.
I think just
Anything like the archaeological report, it'll take a long time to read.
Appreciate that.
just to flag though for your witness that one of the things we will be looking at is whether there is consistency between the commitments under these consents and the obligations imposed by the authority, and whether either we'd need to duplicate those or we would need to cross-reference. So just flag there. We'll be looking for your witness to cover that.
I'll need to have a look and probably will double stroke, but I can see it.
Great. Yeah, and we'd probably be looking for a copy of that authority too, please.
Well. Okay, thank you. I've got some nitty-gritty questions which you'll look forward to, which are important, I thought, Just you've attached the domestic water supply and infrastructure agreement to evidence. And under the definition of properties, it's got 3 properties listed, A, B and C, with reference to section 91, block 8, Benja, SD. I just wondered if you could maybe point out which properties they are on the written approval plan, or make it easier for us to understand what that relates to. It's it's not page numbered in the evidence, but it's the
Is that on the agreement?
appendix B.
Yeah.
Second page, first page, definition of the properties that agreement relates to.
Oh, yes. Section 91.
Yeah.
This is the legal title.
So that's not, they're not something that's not something I've learned in the last month. So I'd be interested in finding out which properties they relate to.
Although they are the 3 at the end. One of the properties belongs to Gareth and Gabby Wilson. And
I think you can just supply those in a right of reply.
right,
We can refer.
the other 2 properties do belong to us.
Okay,
That's rich.
Right,
So one is, Eric and Gary Wilson, and the third is Jethro.
that just helps us understand that agreement a bit more. Just scrolling through 126 page document. Next questions. Okay, so so just looking at your site plans, in stage, in this site plan start, you've got the sediment retention pond and infiltration pond labelled on that plan.
Correct.
And that disappears for the other plans, so it'd be quite useful to show us where that's going to be located on the other plans.
We haven't included that on the other plans, as we continue through the line, they will follow around and sit in the centre of the line slot.
But Mr. Heller's evidence states that he's recommending discharging by the old tailings because it's a more suitable location. So I would have thought that you need to take his evidence into account when citing those ponds.
So the old tailings could also be suggested to be our old tailings as well. Once the
He's made specific reference to a preferred site to discharge to meet.
Right.
So, yeah, just wanted to flag that with you.
Okay.
On site plan stage 3B, the stage 4 boundaries are not clear. It's a red dotted line and then I think a blue dashed line, red dashed line and a blue dashed line, is that correct?
The boundary between stage 3, well, between stage 3 and stage 4, is that what you're talking?
Site plan stage 3B.
Yes.
Oh, actually, if you you've got red hashed line and then you've got a blue hashed line down towards the letter O or turquoise or whatever colour it is that all of stage 4?
If you look to the left of, just below where it says Go Rowan Roads on the plan, you'll see it says stage 4 and it is inside the blue lines. So that is stage 4.
The blue lines are actually underneath the red. Yeah, so just wanted to state that you need to.
So obviously stage 3 and stage 4 share a common boundary.
Sure.
In the centre. And when that spots from red to blue at the southern end there, the blue hashed line is the extent of stage 4 to the southwest.
So you need to change your logo, your legend there. So I'm also interested in why the stockpiles in the state. So you look at start from the start of stage 4, you've got 2 stockpile areas, one's a circle, one's a rectangle. Wondered why that stockpile area shrinks down at mid stage 4. Does that mean the topsoil will be piled up higher? Like you've got a 7 metre stockpile height, is that correct?
Yep.
Is that with respect to soil, topsoil and silt?
The stockpiling height will be basically only for the overburden material. the silt and the, topsoil will be held lower than that. We don't have as much of that to deal with, so.
Yeah, and also it's better for the soil characteristics if you don't go to 7 metres, isn't it?
I think the nature of this site here is the amount of topsoil we have available is minimal. And we will be, doing everything in our power to save every little scrap of topsoil to be able to rehabilitate the site correctly.
So those two stockpile areas that you've got, the circle and the rectangle in stage 4, start of stage 4, are they referring to gravel?
Correct.
Okay, they don't show the topsoil stockpile
No,
areas.
the topsoil will all be stockpiled around in the bunds. I think it's stated somewhere.
Okay.
That is the plan with the topsoil. The topsoil will be put in the bunds around the outside of the project.
So the stockpiles, as you've got on the plans there, gravel only.
Yes.
And presumably that's from the first cut.
That'll all come out of the starter pit.
Okay.
Yeah. And once that is in place, then we shouldn't really be adding much to it once we've got a working hole.
Because it's moving,
Yeah.
putting back into the hole.
And then as the project comes round and through into, sorry, I'm getting a bit ahead of you, into the site plan end of stage 4, the material will be, the stockpile will be removed and shifted over to the, where indicated in the plan.
So the rehab of the topsoil that's on the bunds, you will be using that to rehab the site and presumably removing the bund at the same time. So that will have to be coordinated. with
Yeah,
that.
it's a big coordination job as and when the bunds are coming down, when the topsoil's going back on.
And which document sets all of that out most clearly that will be attached to the consent? Is there a management plan that sets all that out?
I can't actually tell you that, I don't know.
Okay.
We haven't got a management plan for that.
Typically, that is dealt with through an annual work plan.
Yeah.
And so, I was surprised to not see a condition about an annual work plan for a mine site this size. So I just sort of flagged that. Be quite useful for us to see an annual work plan condition. That then refers back to how, every year you submit a work plan to the council for certification, which then demonstrates that the site project's occurring in accordance with the stage plans that we've proposed, and how everything's going to be managed on an annual basis. If you differed from the previous year's mining, why you differed, what issues arose, that's a typical condition. You've seen those work plan requirements before?
I have, yeah. Just to clarify on that, these are things that happen on a day-to-day basis in our mines as we operate. It is a thing that is constantly happening. We're working on these things as we get up in the morning, as we drink a cup of coffee. We work on all these little jobs and are well on top of them when we operate.
Yeah, that's helpful to know, but I think our position is that we need to make sure that if we grant consent, it's very clear what your obligations are, when you need to do what, how you're going to do it, what reporting you've got with, say, Runanga or councils. We need to be confident that that's all set out. So I appreciate that on the ground, you are doing it, but it's about being transparent about how you're doing it and make sure that it's required to be done, which is pretty important. In terms of all the different management plans and things, who's the best person to talk me through how they fit together and how they'll be the planners, or is it
probably lands squarely in my lap, I would think, which is a bit daunting, I guess. But as far as all of the bits and pieces with the plan are concerned, they all just intermesh with each other, and the project will just quietly chip away at its job, and if one part of it doesn't line up, then it gets remedied as we operate through.
so Okay, so that's your lap. You're happy for me to answer your questions about this?
Yes.
Okay, and if you,
I don't know, it will, and it will bleed into the plans.
Mm, yes.
For example, there is a reference to an annual work program and reporting and the draft conditions as Colin's done. Whether that goes far enough, I'm not sure. And I'm only mentioning that just because off the top of his head, Mr. Johnston wasn't aware of that, so. These are your questions, and I'm getting back out of the way, but just there'll be some crossover, I imagine.
yes, thank you. Well, if we'll see how we go. And if there's anything you're not sure about, that's totally fine. And if you need to say, oh, so-and-so can deal with it. So, so you've got a gold mine management plan. That's the first. So is that the overall management plan? What does that deal with? How does that?
That is where all of the documents, I believe, will be collated.
Okay.
As in, right the way through from here, our settlement control through to our operational security.
Okay. So that's your umbrella management plan, if you like. Is that right?
I believe so. Yes.
Okay. And then are the other subsections effectively subsections of that?
That's correct.
So you've got, in the conditions that I've found, you've got site emergency management plan, you've got operational noise, you've got dust, and then you've got rehabilitation, and then we've talked about erosion and sediment control. So will they be essentially sub plans or subsections of that?
Yeah, as we spoke, when I spoke with Quinn McIntyre, when Laura spoke about this stuff, he said this is the sort of thing he specialises in, and he would happily put them all together in a gold mine management plan, and yes, they would all be subsections of that basic document.
Yes, I would have thought that would have happened already. I'm not suggesting that you would have had all your management plans finalised when you lodged application, but for something this complex to run, and you've said yourself that it's a complex operation in terms of all your staging and the different obligations you're going to have in terms of monitoring. I would have expected that you were more advanced around these plans. Now, you may have things that you haven't shown us yet, but I just wanted to flag that, and Ms. Colley might be able to help us out a little bit more on that, because if this was granted, it's very important for us to feel confident that the implementation of the consent can carry out in a robust way, and that we're really confident, so that next time I'm driving past, I don't go, oh, what have we done? We're confident that actually things are being done as they need to be. So at the moment, I just wanted to flag, I'm a bit uncomfortable about how advanced you are in relation to that. In that you've got recommendations of management plans. We've seen a few drafts of some, but it feels quite early in the development of that. So I don't know if you've got anything more to say on that now. Obviously, Mr. Evans written that down, and we'll no doubt think about that. But yeah, over to you if you want to comment on that at this stage. Okay, yeah.
Just a big picture question with the topsoil. Will be going back on the bunds, or will you have topsoil stockpile areas as required?
Once the project is up and operational and the hole is excavated out in stage one, started to complete, the bunds will be built in the appropriate place to be per the plan. The topsoil will no longer need to be stockpiled. It will literally come off 6 metres each day. It will come off of a 100 metre wide bench at the front and get put back on the backside of the rehab area.
6 metres, I thought the topsoil was
Not deep. Wide.
right.
If we work on
So
those.
you're talking about direct transfer of the whole sod?
Correct.
Yeah.
Yeah. So the silts will come off, the topsoil will come off, and that will be relayed in the rehab zone at the back.
Yeah.
to stay within our 27 hectares, which is going to be pretty tricky to stay within our open area. We'll need to make sure we're staying on top of the topsoil rehab.
Quite useful to have just a little bit of information about that soil transfer process, please.
In what sense?
Where you just said that you're basically going to be lifting the whole side with the grass intact and putting it on top and lifting it up, just some evidence on that. Written evidence so that I don't get my notes incorrect. Quite a few comments on the erosion and sediment control plan. I'll just stick with the bigger picture ones at this stage. You've got a figure 2 in the plan that's supposed to show vegetation cover. I had a look at it. I don't think it's quite useful for a practitioner. If you have a look at that, it's sort of like slightly different coloured quilts. Shaded quilts, it needs to be better diagram from management plan for an operator to follow. I mean, you're saying that 80% cover. You look at that plan and then you look at the ground and you go, no.
Which page is that?
Section 4.6 of the erosion and sediment control plan. You got figure 2, visual cover estimation. I think that plan's useless and it needs to be improved to put it in the channel. We've got a plan here, Horoscope of a plan. It's got different coloured polygons placed on top of the site. And that's on page 1. There's a diagram in appendix 1. Just quickly pass on some comments here. We'll ponder on and then we'll move on. First comment is that stockpile areas don't match your stage 1 plan stockpile areas, so I wonder which one is relevant. Wondered why you'd be is there a need for stockpile area right next to the dredge pond? Wouldn't you just put that straight back in the pond area? There's a lot of dirty water reporting to, Have you got that diagram from you?
Yep.
So you've got the clean water disposal swale on the mid right-hand side. You see that? There's 2 blue arrows pointing to it, which are clean water. I just wondered why there'd be 2 clean water arrows when that water's running off the stockpile, which is just beside it. There's a lot of dirty water reporting to a sediment pond on the bottom right-hand side, which is a small pink oval. Why doesn't that report to the main settling pond? It's not. It seems to be more water reporting to that than there is reporting to the main settling pond. You could probably bypass that pond and put it into your big pink polygon.
that small area at present is just a spot where water pools naturally. Because of the, well, I guess not naturally, from the bunding that we've built, water's pulled there.
Sure, but I'm just saying, I think basically that plan needs a lot more work, thought put into where the water's going to. And because you're taking water out of the pink polygon in the middle and putting it in your land disposal area, why doesn't that small pink pond report to that big pink polygon and then go to the discharge area? So you're just sort of flagging across skin cycle.
Yeah, it's height related, obviously. The whether we
Pumps
think
in?
vertical is,
Can you get pumps?
oh, of course we can pump. The volume that it winds up in that area is minimal.
Yeah, it's just that all the. Another bigger picture question I had, is there a need for an erosion and sediment control plan on the site? And it's quite a straightforward flat site.
It was something that was flagged by Okaha, and we produced something to cover off any concerns with overland flow paths.
Yeah, I go on split past though. If you've got external bunds which will control and contain water within the site, is the finer scale redirection going within those bigger bunds actually doing anything to keep water out of the Mataho or Timbervine? You're saying like it's overly complicated?
Not overly complicated at all. But yes, inside the bunds, it holds all of the runoff water from our site inside the project boundaries. And the majority of the water will be directed to the monitor. Where it will be pumped back out into the settling ponds and then discharged to land.
Yeah, that makes sense, but the diagram doesn't reflect that in the erosion and sediment control plan. Also, your stabilised access diagram doesn't comply with the transport evidence and the erosion and sediment control plan. Transport evidence talks about diagram D and then Annex 3 doesn't comply, Annex 2 doesn't comply with that, the stabilised access picture. And the photographs attached to that plan, is that, which is on the page called sediment basin, is the second photograph the actual land disposal area at the moment.
The second photograph on the right.
Yes.
Yeah.
So that's what is referred to in the evidence as an infiltration pond. And in a lot of the evidence, people talk about infiltration ponds rather than land disposal area. It's not actually a pond, is it?
It's not a pond at all.
No.
The water runs away and just disperses into the river.
Yeah. So some of the evidence talks about ponds, disposal, the final soakage pond. But you actually, it's a land disposal area. It's not a soakage pond.
Depends how you word it, I guess.
Well, no, one's water and one's land is black and white. So what I'm sort of flagging is that any of the evidence that refers to as final soakage pond is not accurate. It's a land disposal area and it's dry as evidenced in that photograph.
This photo hasn't had water running through it for many months. When the water is running, you will get a slight build up and slight ponding in spots and down in that area. but it does just seep away. So at what point do you define a pond to a?
Okay, and you just design that land disposal area to ensure that there'll be no topping of pond overflowing. It would be catered for the flow going into it.
Most definitely. So at present, that is 4 metres below surface level, which is about 5 metres above water level, natural water level, in the aquifer. And that's where it is discharged and then flows down, including the rest of the gravels.
Sure, I understand. You've got pictures of recycling stations and waste bins and oil spill pits. They all relevant to erosion and sediment control?
I guess the spill pits are probably fairly relevant, making sure that any spills that happen on site aren't running away into aquifers and being discharged through our pond system.
We usually see those in a spill contingency plan rather than erosion and sediment control. So I'm just wondering if you're conflating the two. And just wondered how storm would relate in site shutdown.
Say that again, sir.
To Victoria, when storms are forecast, it's critical that tools are down in time for rapid response procedures to be implemented. And then talks about site shutdown. Are you talking about temporary, just temporarily ceasing work during storm activity, not actual site shutdown?
Not for a long term, for a short period of time.
Okay, that was the back of appendix 3. It just gave an implication that something could be so serious that you need to shut the site. That's not what you're getting at. And I can finish there just to say that the erosion sediment control plan, I consider there's a lot more work. And so I've got some questions for the other witnesses. I know we're as long-winded, but you know, we had only had you here for a certain period of time. So thank you for bearing with me with my questions.
Fine.
And I've got no further questions.
Okay. Good enough. Thanks, Mr. Johnson.
Thank you. All right, the next, what this is Mr. Moore and the landscape.
Sure. Going to say good morning. We're not morning, we're afternoon.
Ready to go?
Yes, thank you.
Right, just read my statement.
Thank you.
My full name is Michael William Moore. I'm an architect. I hold a BSc, AAA and Master's of Regional Resource Planning qualifications. I'm a registered member of the New Zealand Institute of Landscape Architects. As set out in paragraph 1 of my evidence and show. I've continued, I have continued to comply with the code of conduct for expert witnesses in preparing the summary statement. My evidence addresses the effects of the proposed mining on landscape patterns and visual amenity. The landscape context of the site is a working rural character. and the site has previously been modified by gold mining activities. The site and area is not recognised as an area of outstanding natural landscape or significant amenity landscape in district plan, but falls into the category of other rural landscapes. Rural character based on openness and generally modest impact built form or natural landform modification contributes to landscape quality and amenity values of the area. Landscape impacts of this operation will arise from vegetation and landform disturbance, gravel stockpiles, the presence of plant machinery, funds and lighting. An important factor is that the proposed operation will be temporary and the effects of this will be for a limited approximately 5 to 7 year timeframe. Once completed, the area, including the existing dump area, will be returned to pasture land with virtually no sign that it was mined. While the whilst the site area is large, it will not all be impacted at once. And the proposed progressive rehabilitation of pasture immediately following mining is a key mitigation measure. Funds are proposed to provide screening and separation as a colour treatments to mitigate the visual elements of the structures. The proposed mining works for their fully industrial character and will impact the rural character of the site. The mitigation measures proposed will reduce these impacts to an extent, and the timeframe of the operation involved is limited to the medium term. The long-term legacy effects will be a return to pastoral farmland with the existing dump site also tidied up. My assessment has considered the key topic viewpoints surrounding and finds that the nature and degree of effects of the proposed activity or operational on landscape values will vary over the life of the project and will fall within the ranges of adverse style to adverse non-required. Following final rehabilitation, I assess effects of mutually positive very low. In terms of natural character effects, I'll include the river as about. The proposed mining is largely beyond the river margin and will have no direct physical effects of any significance within the river margin. For operation, there will be some temporary adverse experiential effects associated with noise and visibility that will vary with the proximity of the areas of the life of the project. Following rehabilitation, there will be no long-term adverse natural character effects. The majority of property owners in the area surrounding the site have either signed written approvals or have not cited visual effects and submissions. I have, however, assessed the visual effects of the proposed mining from the property of two submitters, and actually we're going to talk about some 334. Given that's fact.
Is that the one with the submissions being withdrawn? Yeah. Oh, we have an approval. I just see that's landed on our.
Yes, very told them aware that had arrived on we spoke earlier to the original.
Yes, I see that. We've got a copy of that. Thank you. So, yeah, you could, so on that, you'll delete that from your evidence. Yes.
The other one was 67 people road. As that one, consider the effects from will be adverse, low, moderate, to minor during stage 2 of the works, and adverse very low or less than minor during other stages. The evidence addresses the simply later district council consultant reports, and I consider that the updated, more detailed site plans addresses most of the issues raised with regard to the suggestion of the funds on the river. Mr. Howard, I recognise that this will have a positive effect. My conclusion is that my evidence refers to the further reviews to stage and detail, size and location of bunds, and revised conditions of consent, which one is color relevant to the landscape and visual effects. Based on my assessment and the revisions referred to above, my conclusion is that the proposal will result in an acceptable level of visual and landscape effects.
Yes. Should I think it?
Thank you, Mr. Moore. So in your in paragraph 10 of your summary, you've stated that the majority of property owners in the area surrounding the site have either signed written approvals or have not cited visual effects and submissions. Am I correct that the property at 67 is one of those submitters that hasn't cited visual effect?
I don't believe so.
Okay. Yeah, okay. And any other of the other properties down Clutha Road, were you? Yes, right down from 61 through 60 through to 68.
Yeah, just sure. Yeah, please have to further, please.
Okay, but in any case, they weren't the subject of your assessment. There's no public viewpoints from those properties further down. Is that correct?
No, from the road, it's very hard to see through to the site from the area.
Yeah. Okay, great, thank you. And this morning there was some discussion around which plan sets we were looking at, and I see in Ms Mackenzie's summary statement, she has mentioned that provided the latest plan set depicts an appropriate extension of the bund during stage 2, I consider the adverse effects on views and visual amenity can be adequately mitigated. So you can confirm for us that that the latest plan set does depict that appropriate
Yes.
alteration?
Yes, I've recommended extension of the bounds now.
Yeah.
So is that shown on the April plan set?
Yes.
It's not?
Let's just confirm that. Thank you. Thank you. Take your time.
Stage 2 on that set, reflects my recommendations and doing that.
Right, so there's nothing outstanding there. And in your summary statement today, Mr. Moore, you mentioned that in paragraph 11, the more detailed site plans address most of the issues raised. What are the issues that you don't think have been addressed?
I think sort of there was issues about bund height, for example, which we talked about movements. Some things like temporary, for example.
Yes.
So I'm really referring there to nuts and bolts stuff
rather than substantive landscape.
Yeah.
Okay, thank you.
So can I just follow up on that? So para 11 in your summary, when you talk about most issues raised, do you mean the issues raised in your evidence, or do you mean issues raised from other parties?
raised by other parties.
Okay.
Consultants. Such
Have
as McKinsey.
Okay, thank you. And are you comfortable that the recommendations you've made in your evidence have been reflected in the updated site plans?
Thank you. And another question from me, in your evidence in chief, you have made some comment about the opportunities for biodiversity or Indigenous planting enhancements to the Mata'o. And you've also indicated that due to property issue, and we'll hear about that perhaps a bit later when we hear from the appropriate submitter, that from your understanding, there's no opportunity for similar enhancement at the Timberburn. Putting the potential barriers aside that are reported and that we will test through this process, from a landscape perspective, are you able to comment on the merit and benefit of any enhancements to the Timberburn?
Well, obviously, the riparian planting is an enhancement of natural character. I think visually probably less important for Timberburn because it's fairly it's quite low. You don't see it much from the road, the slope away.
Yeah.
I think natural character, yes, probably.
So, and would that benefit? So that's a positive benefit. Yeah, significant benefit, moderate benefit.
Moderate, probably.
Moderate. Okay. Thank you. And also,
You're good.
okay. Paragraph 37, in your evidence in chief, you have raised the temporary effect. We've had some discussion today with legal counsel for the applicant around perhaps that could be considered effects of limited duration. Do you have an opinion either way on that in relation to your assessment of effects?
Yes, I was using temporary in a planning
Right.
legal sense. I was using it as just that, limited duration.
Great. Okay, so that all lines up from your perspective. Okay. Thank you. That covers all my questions.
I have two. So in your assessment, when you looked at your viewpoints, you didn't produce any sort of visual sums that might show how stage 1 is going to look versus stage 2 from various viewpoints, or and I note there's no, as far as I can tell, there's no sort of end game, end of mine life rehabilitation outcome plan that we can look to see what it's going to look like. Is that firstly, is that correct? Am I correct?
Yes.
And is there a reason for that?
Because the mine is such a dynamic thing.
Yes.
There could be an indication that it will be not particularly accurate illustration of what would actually get in problem.
In terms of the visual stimulation. Yes.
But it was perhaps needed in this case.
So that's my second question. Are you comfortable that you're comfortable with your conclusions based on the assessment you've done, which was without a sort of visual simulation?
Yes, I'm very comfortable.
Yes.
I think the other thing to say there is that there is something to say already.
Yes.
And you can compare that with what the various stages are going to be. So you've got a baseline to use there in envisaging the effects to various viewpoints.
Yeah. And then my second question is, and you've heard some questions of the other witnesses about the sort of level of detail in the site plans, which is pretty light compared to other projects, I think, of this scale. How confident are you that the recommendations you've made, I mean, there's a line showing a bund,
Yes.
but we certainly haven't seen anything about, well, what's that actually going to look like, how, dimensions, how it's going to, what's going to be planted with, do you think it's fair that I'm suggesting there's a bit limited detail in relation to that, the implementation of your mitigation measures that you've recommended?
Well, not really. I think the bund is pretty easy to envisage. It's just going to be a grassed
Yeah.
bund up to 24 metres high, depending where you are. And the rehabilitation will be basically what you see now tidied up in the rest of the farmland. So that's easy to envisage as well.
Mm.
So I didn't think there's too much need for too much more in.
Welsh? Language? That's great, thank you. Yes, that's your answer. Thank you very much. I'm noting it's 12:30, which is our scheduled lunchtime. I'm also noting that we've got quite a few witnesses to go. And so we have an obligation, a time issue for Mr. Goodhue, I see.
Yes, there are 3 time issues.
Okay, thank you.
I was about to raise with you. So
Okay,
one is
let's have
Mr.
that.
Goodhue.
Yeah.
And I understand he needs to get away by 2:45 p.m, I believe.
Mhm.
Then Mr. Heatley has travelled here with Ms. Ross, and I was checked with them before, and they need to get underway by 4 p.m, please. And that may mean I need to check the all around the as well, just to make sure we don't come under pressure on that front.
Yes.
Everyone else is either online or is locked in, or has flat experience, and so will be here.
Fantastic. Lucky them. Okay. Thank you. also understand Mr. Dom's. Okay. He nipped away. Fair enough. He is only able to present today. So what we might do is pop him on at the end of the day. He's obviously prepared a statement. It's fairly short, I don't imagine.
And I had
Keep up
no
with it.
objections to that, real world commitments break in, and that's understood, so I'm not going to take issue with that.
What I guess I'm foreshadowing. Do you have a sense? It's a tricky one. How long the rest of your witnesses are going to take? I know it depends on how many questions we ask them. But
Yes, I'm sorry to throw a boomerang at you effectively, but it really, I guess, depends on your question. As you know, there are summary statements for everyone.
yeah,
The bulk of those are short. There's a couple of sections slightly longer,
yes,
but they don't take particularly long to read. And from there, I don't, as far as I recall, there isn't a whole lot of freewheeling that those witnesses are proposing to at the back end. It's very much driven by how many questions you have.
yeah, okay.
Noting perhaps that it helps,
Yes,
but those who are online, so that's three, it's Mr. Copland, Mr. McDonald, and
that's Keo.
Yeah, I mean, look, you will know, not me, because I can't see your notes, but I imagine you might not have a lot for them, so at least those three offer the prospect of speeding up toward the end.
Yes. Yeah. I mean, I think there are a couple that we've got a number of questions for. The planners, obviously, we want to have quite a good chat with. But other, and some of the hydrology stuff, aquatic ecology, but yeah, I think we'll be speeding up. The question, I suppose, is to give submitters an indication of whether they're likely to be on today or not. So,
We're available all week.
oh, you're amazing. That's great. Thank you. Thank you for being so helpful there. I think we're going to have to play it by ear, unfortunately, everybody. I think we need to make sure that we've talked to our witnesses as best we need. But we need to take the time that this takes, and this is the nature of hearings. So it's just foreshadowing submitters that we may not get to you today, but I'm still quietly confident, but let's see. Was that someone online wanting to speak?
I think it was just something
Oh,
that unmuted themselves.
Okay.
I mean, I suspect with the exception of that person who needs to get through today, if one was being realistic, he might not get
Okay.
there based on speed today, but look,
Yeah, I think we will speed up, but yes, okay, let's see where we go. So I will leave, we'll break for lunch now. I'll leave you to decide whether you want to reorder your witnesses.
I will, why don't I tell you now, so you know. So the proposition, I think, would be if we had next, this will be a heads up for them too, because they don't know I'm going to do this. Next, I suggest would be Mr. Goodhue, which is air quality, which is kind of a standalone scenario. And then because they're travelling together, it seems to me logically we will then flow into Mr. Healy and then Ms. Ross.
Yeah.
And then we would revert then to that previous summary we had grouped up Dr. Wills, which of course is ecology, and then into Mr. Allen hydro geology, and then Mr. Allen freshwater. So that sort of comes as sensible.
Yes. Okay, and then after that, we'll go Mr. McDermott, Copeland, and if we have anything for Keo, and then obviously the planet.
Yeah.
So we don't, can we confirm, we don't have anything for Ms. Chapman? So I think he is excused. I don't know if he's there, but.
Can't tell, but no, I think we told he was excused, but he was available, but in the end, yes, if he is floating around online, which I can't see, we can let him know he doesn't need to be.
Okay,
Thank you.
Yeah. And what we'll also do in the lunch break is check whether there are any other witnesses we don't have any questions for. In some cases, though, I may actually like to hear from them anyway in terms of their summary. And if there's anything we want to ask quickly, but let's just see, there may be one or two others, but my sense at the moment is we will want to hear from them. Great. Okay, thank you. Happy with that?
Yes, thank you.
Great. So we will, what are we, 12:40? We will reconvene at. When do we need one? It's catering's here, I think, is that right?
I believe so.
Okay, so we're not having to go away. We do half an hour. I think we'll do half an hour for lunch, so 1:10.
1:10.
Yeah, thank you, everybody. That Commissioner Welsh too quiet and you're struggling to hear him at the back. Can everyone hear me okay? Yes, they can hear me.
Okay.
So,
And me?
if you are struggling to hear at any stage with anybody, just do this or something, because I can see you all, and we will make sure, because it's nothing more frustrating than not being able to hear. If there is an issue, if you are hard of hearing, by all means grab a chair and just come up a little bit closer. That's no problem with that. So the last thing we want is people to be feeling frustrated that they can't hear. The other thing I wanted to cover before we continue with the witnesses is and just in terms of submitters that are wanting to speak, just a reminder that you're able to speak to your submission. You need to cover only matters that you've raised in your submission. So you're not able to add things that you may have considered later or you've heard or so on. So just a reminder, if you're speaking to your submission, we're very interested to hear from you, but it's not an opportunity to add other matters that you wanted to cover. So just a reminder to those submitters that are coming up. Mr. Dons, you're here now. I understand, I heard you ducked off, which I totally understand. You need to appear today, is that right?
Yes.
Yes. What we will try and do is just pop you on at the end. If we don't get to the other submitters, we'll pop you on at the end of the day. Is that suitable?
Yeah, that'd be really good.
Yeah.
I'm working in the lead tomorrow, so.
Certainly. Okay. So our intention is that we'll do that. We'll accommodate you there. We're hoping to get through the witnesses before that, but we'll just see how we go.
Does this mean that it's likely that the other submitters will not speak today?
Yes, we're pondering that before lunch. It's always really hard to know how long the sort of discussion with witnesses will take. We have had a conversation over the lunch break to see how many questions we have for each of the remaining witnesses for the applicant. There is about 9 to go or something, so there's quite a few. Some of them we don't have many questions for at all, and they may be on and off within 5 minutes, and others there might be a little bit longer. So it's hard to know. I can't guarantee that you'll speak today. We have, if there's any, we're trying to accommodate people that have constraints on their time. Are you Mrs. Gunn, is that right? Yes. Do you have any constraints about coming back tomorrow, or?
I'm not happy that I have to, but if I have to, I will.
Thank you. I appreciate your patience. Yeah, that's the nature of these things. It is very difficult to know how long things will take. And if we can get you on today, we'll definitely endeavour to do that. So thank you. All right, Mr. Goodhue.
Correct. Mr. Goodhue.
Great. Thank you.
Good afternoon, Commissioners.
Good afternoon.
My full name is Nigel David Goodhue. I hold the position of Environmental Scientist at EMS Limited. My qualifications are a Masters of Science degree from the University of Waikato, as set out in paragraph 1 of my evidence in chief. I confirm that I've continued to comply with the Code of Conduct for expert witnesses in preparing the summary statement. My scope of works included peer reviewing the dust management plan and undertaking assessment of environmental effects to support the air discharge consent sought from Otago Regional Council. I'm familiar with the area to which the application for resource consent relates, including a visit to the site and surrounding area on the 19th of October last year. The focal discharge to air from the proposed activity and the emphasis of the AEE was particulate matter, more commonly referred to as dust. A range of activities on site have the potential to generate particulate matter, including removal and transport, stockpiling and replacing overburdened topsoil, and vehicle movements on access ways. In general, the surrounding land use is considered as giving a low to medium sensitivity to the effects of dust in accordance with the Ministry for the Environment good practice guideline. The exception to this is residential dwellings and accommodation facilities adjacent to the site, which were identified in the AE as having a high sensitivity. My assessment of potential dust effects followed the MFB guideline. An initial screening evaluation using appropriate separation distances was undertaken, followed by a more detailed consideration of identified adjacent sensitive locations. Potential for adverse effects at sensitive receptors to the northwest and southeast of the mining site were identified. The assessed risk level is based on there being no mitigation or active monitoring of these controls. Hawkeswood Mining Limited is proposing a range of best practice mitigations and controls to minimise the discharge of dust from site operations. These dust mitigation measures are described in my evidence in chief and captured in the dust management plan. Continuous real-time dust monitoring is proposed to be undertaken on site to monitor the effectiveness of the controls. The range of best practice controls are considered sufficient to mitigate the effects of all the identified higher risk receptors. Provide an additional level of control for any anticipated acute events such as very high wind conditions. Sensitive receptor management zones are proposed where dust generating activities are within 400 metres at high risk sensitive receptors. These management zones with additional controls that also capture the dust management plan. Methods arising. A number of submissions identify the potential adverse air quality effects as a result of their activity. I have addressed these matters in my evidence and provided clarification where required. In conclusion, the matters raised by submitters can be adequately addressed through the existing mitigation measures to ensure the potential effects remain less than minor. I am also aware of air quality expert evidence that is provided to support submission by the owners of RM230325 road. This submission and the corresponding evidence has now been withdrawn, and the update was also record proofs are now provided by the occupiers of that property. However, I make a few general comments on the matters raised in the matter. Regarding the dust management over the active working area, Hawkeswood Mining Limited have proposed an extensive range of best practice controls, including use of high volume water cart and dust suppressants, stabilisation of bunds once established, progressive rehabilitation of grass areas post mining, and inclusion of an area limit relating to the high dust generating activities. Patrick Gallimore Partners Technical Review agreed with the conclusions reached in AE that the proposed controls are appropriate to mitigate dust effects from the entire active working area. The process of target alluvial material in the dredge is undertaken as a wet screening process and will not be a source of dust. For us, the crushing of aggregate, which has a potential to generate additional dust in the wet and the withdrawal evidence does not form part of the proposed activity. A number of proposed conditions were included in the evidence that I consider not appropriate, and I just reiterate my support for the proposed conditions contained in the Otago Regional Council and Central Otago District Council's Section 42A recommending reports. The only exception is the two matters as outlined in my evidence in chief. In conclusion, based on the assessment of effects, subject to the proposed test practice mitigation being implemented, the effects of nuisance and calculated air discharges from the site can be appropriately managed and mitigated to a point of having less than minor effects on the receiving environment. This conclusion is supported by the technical review undertaken by Patrick Gallimore Partners and reflected in the Otago Regional Council and Central Otago District Council Section 42A staff recommending reports.
Thank you.
Okay. Just with respect to written approvals, the written approval we got this morning is for the Central Otago District Council application, but it's not for the ORC application, and dust is primarily the Regional Council issue through the discharge permit. So just wanted to get that updated. If it's supposed to be for ORC's application, it has to be explicit. Makes sense?
Oh, absolutely. No,
Yeah.
there should be one for both. So if there is not, it will be attended.
But it doesn't have, I couldn't see any record.
Oh, there may not be
Application.
I'm just indicating consequent on the agreement, there should be. So
It's all
that
good,
will be followed up. Thank you.
just flagging that. Okay. In paragraph 17, you've labelled A, B, I, N, D, and M as sensitive receptors. I think 1334 Teviot Road, location A, we've just discussed with written approvals. I see 133 Teviot Road has got District Council written approval. But I just wondered if N and M, your evidence, had Regional Council written approval.
Yeah, it's been a bit of old speak progressively updated or improved have come in, but as I understand, this colleague too, that N has written approval, that N site N does not, there's currently.
And in paragraph 22, you don't refer to M. Is there a reason for that?
Yeah, so the reason for not referring to M really relates to the predominant wind direction. So the distance is above the threshold of 250 metres and also outside of the predominant wind direction, so we haven't categorised them as a high risk sensitive reflector.
So you're saying that N to M are inside 250 or just beyond, but they're not in the predominant wind
Yes.
direction. Is there any need for the SMZs now that you've got written approval from the Northern Neighbour?
Yeah, so the only one property we've still identified is B on the map there, which is 67 Clutha Road. So if you draw it out from their property, they are within the side of 400 metre zone and within a prominent wind direction. So probably the only property now subject to current approvals that would be included in the sensitive or sector management zones.
So could you give us, sorry, could you please give us an update on your evidence with the current bundle of written approvals and the SMZ changes that you wish to?
Yes, yeah. And so it pretty much follows exactly as it was in the submitted dust management plan, just now 1334 to be updated. So that plan will need to be updated now.
So what I'm saying is, can you give us some, I guess in the right of reply, update evidence to reflect the changes that are occurring as we move along?
Yes.
In paragraph 40, you talk about a mobile dust monitor located in an appropriate location downwind from the active area. How would that work in reality? Because the wind changes direction at the drop of a hat. And so it wouldn't be that easy to then get the mobile monitor onto the other side and then it changes again, you know, so wouldn't it be better to have fixed monitors on boundaries?
Yeah, the challenge I guess with the activity on this site is because it progressively moves around the site, we want to make sure we've got the dust monitoring as close as practical to the actual activity area. The second part of that really is the unique kind of wind pattern within the activity. based in here, we've got quite a predominant wind direction. So you say, I do agree that the monitor is not always going to be able to be downwind, but I guess we're trying to manage for the overall effect of it and having it in a predominant downwind direction and yes, the receptors.
It's just the way that you worded 40. It indicated to me that the mobile dust monitor would be moved around all over the site.
Yeah, no. Sorry, that might have been slightly misleading. Intention if it wouldn't be moved on a day-to-day basis.
Yeah,
It's this progressive
The
stage.
staging is not that fast.
Yeah, but it'd be moved off the stage of doing a day-to-day.
So that's not reflected in any conditions that you're seeing.
No, and so suggested to deal with that through the dust management plan to have.
Yeah, that's just, we're not going to defer everything to a non-existent management plan at this stage. We've seen a draft of it, which we've got comments on. But there needs to be something in conditions, some meeting the conditions for the management plan to hang the hat on. So it seems to me that, you know, referring to management plan with these basic monitoring requirements on the boundaries is not appropriate. Just leave that with you. Can you hear me at the back? Good. Just. My wife's always telling me I'm too loud. Right. Now, in paragraph 41, you talk about a trigger threshold. And it's a preliminary value, but it could be adjusted from time to time. Is that a bit loose, a bit vague? Wouldn't you, I normally see triggers and conditions that are well developed over time through national standards and they don't get adjusted? What's the basis for that statement?
Yeah, so the trigger there is follow the UEP guidance, which I think is appropriate for this site and the sensitivity. I guess I'm referring to adjustment as in it wouldn't be adjusted up to have a higher level. Potentially it could be adjusted down if, for instance, there was unanticipated effects across the boundary, and then it'd be a lower trigger limit to advise the applicant that there could be an issue on site.
If the trigger level was set and there was an issue, you'd address the issue.
Yes.
You necessarily need to change the trigger level, would you?
No, you wouldn't, but I guess more there was a effect at the boundary that wasn't being picked up by the trigger level. You may want to have the option to reduce that so that you get hit at that time and adjust your response to that.
I've seen trigger levels of 150 and some consents 65, 55 and others. Seems to me there's enough certainty with science to actually put trigger levels in and not need to change them as you go along. Could you give that some thought, please?
Yes. Yeah.
And given that you've got quite a friendly windrose, it's, you know, predominant that way or that way. Would it not be easy to identify monitoring locations on a plan now and stick to those? Given you information about who's around that area?
Yes, and now that more approvals have come to the end, to identify those sensitive receptors, they probably can be updated to have a stage by stage location for the monitoring. So I think they agree.
Can I just add to that? In terms of written affected party approvals, we can't consider effects on those parties, but presumably Mr. Johnson and Mr. Hawkeswood will, and ensure that they don't have dust effects on their properties. So I'd just be slightly nervous about narrowing down locations of monitors to only deal with those properties that haven't provided affected party approval. Legal matters aside, so just something else to consider as part of the answer to Mr. Welsh's question.
Paragraph 59, stage one, you've assessed the stage one generator set. 600 kVA diesel generator. And then stage 2 to 4 development will operate from mains power. So you're saying that from an air discharge point of view, stage 2 to 4, because it doesn't require a generator set, it doesn't need to be considered.
Yes, that's correct. Yeah, like the combustion emissions associated with the operation of the generator.
In terms of the dust management plan, that was provided in draft with the application. I think it's not attached to any evidence, is that right?
I believe it's attached to Scully's.
Oh, apology. Okay, so is that an updated version, Ms. Colley, from the application?
Yes, it is. It's a version which was edited following comments from PDP and Mr. Clinton's peer review.
Okay. And there was some suggestion from, it may be a submitter that's no longer a submitter, but forgive me for asking the question anyway, that the management plans as submitted with the two council applications were different. Are we now in a position that it's the same document?
I'm not aware of any difference in the
Okay.
plan as submitted to various calendars. But the version that forwarded is the version attached to my.
Thank you.
Which is slightly evolved, but not massively changed from the version.
Yes, okay, thank you.
Paragraph 80, you're referring to a condition removing the word crushed. Referring to crushing. Proposal doesn't include crushing, does it?
No, it doesn't.
So it's redundant. Wording's redundant. It's just some of the submitters were concerned about crushing. You just wanted to hear from you. There's actually no crushing on site.
Yes, that's correct. Yes, I understand that. Yeah, it's not crushing like the typical aggregate quarry with crushing screen material, the dry process.
In paragraph 83, recommended topsoil strippings limited to 1 hectare at any one time. Just wanted to get Mr. Johnson's comment on that. Is that, or maybe you could comment on it. What did he think of that idea?
Yes, I discussed that with Mr. Johnson, and he was happy with that.
As a condition of
it was an area before. I think there was one caveat on that around the archaeological monitoring, but there was something to be found near the area maybe open, I believe.
Just returning to referring to the dust management plan dated 13 February. That's the latest plan.
Yes, that's correct.
Have you reviewed that?
Yes, I have.
You're happy with it?
Yes, I am happy with it.
On figure 3, what are the red squares? Like houses.
No, I don't believe that. Environmental with maybe water balls potentially.
Could I ask that question, brief question?
Sure.
The underlying aerial photograph is from the Central Otago Council GIS system, and those red squares and the accompanying text, which is a little difficult to read, is the address details associated with the properties.
Okay. So it doesn't relate to your evidence, Mr. Goodhue? The red squares don't relate to your evidence?
No, they don't. Other than possibly giving that. But it meant quite difficult to read the addressing each property section.
2.3, the closest meat station with historical recent records is adjacent to the site on the opposite bank of the Clutha River, Mataho. I read somewhere that there's one on the site. Is that, could you clarify that?
Yes, so there is a met station currently on site, and the applicant is proposing to install their own met station on site as well. But the data that was used to generate the windrows in our AE and presented in the dust management plan is a met service station, which is on the opposite bank.
So when you say it's the closest,
As the closest, sorry, with a long-term record.
oh, okay. So there's two.
There is two currently, yes.
Thank you.
Yes, I just clarify the one on site is a net service. Marker, the data was used as a long-term net service marker.
So it's privately operated.
Yes, that
Yes.
Right. Is there any difference between, in your opinion, between having the met station mast 10 metres high versus 6?
Yes, there definitely is a difference in the height.
Which is your preference?
I think for an open site, such as Miller's Flat, where you don't have any buildings or large trees that are going to affect wind speed, I think 6 metres is an appropriate height. The only part I'd add to that is making sure your trigger limit, your wind speed trigger limit, was corresponded with that height, so it'd be slightly reduced and AE provided a value from that reduced height.
And so given a sort of flag that we'd like to see a trigger limit in the conditions, you'll take that into account when you recommend those conditions to your client?
Yes, that's correct. Yeah, they will do.
Okay. And would that be continuously monitored
Yes, that's correct.
with a telemetry system on it that would go to the site manager?
Like real time words, but site manager or nominated site staff.
So the dust management plan in section 6.2 refers to an appendix D. There is no appendix D. I just wondered if you could clarify that.
So yeah, apologies, I think it was just us transcribing the area accurate in the dust management plan. It should refer to appendix C, which is a dust level exceedance investigation.
Okay. So some brief comments on 6.3. It doesn't mention the alarm sent to the site manager. The list of mitigation measures shown in the PDP audit is not accurately covered in the discharge management plan. And it should, if you implementing what you said, preferred visual dust inspections as well as data from the PM10 monitor and weather station in the recording section.
Thank you.
Okay.
Thank you.
Thank you. So next will be, we'll just slightly tweak the order again, just by swapping Lord York and Mr. Heatley around. The reason for that is that during the lunch break, another document appeared from Styles Group for Mr. Heatley to consider, which you may have done by now, but we signalled to him that we would swap. And then he was Ross over just to make sure he had enough time to look at that.
We got that. Here.
Thank you. Ms. Ross. Kia
My full name is Victoria Ross. I'm a principal archaeologist and team leader for New Zealand Heritage Properties. I prepared a statement of evidence dated 29th April 2024. I outlined my qualifications and experience, all the project and commitments from time of environmental pieces of fitness code conducts in my TSC. I confirm that I continue to comply with code of conduct for exhibit certificate and summary statement.
Ms. Ross, I suspect the people at the back may struggle to hear you. You are speaking this way to us, which is difficult for people behind, but if you can try and project your voice, that would be very helpful. Thank you.
I was not the primary author of the archaeological assessment, but I worked on the archaeological assessment before it was mine. My EAC addresses the scope of archaeological assessment, archaeological and heritage landscape, recommendations and mitigation, and matters raised by the Central Otago District Council's 42A report and submitters. The archaeological assessment identified two previously reported archaeological sites, G43232 and G43233, and two sites that were reported as a result of the assessment, G43285 and G44159, that will be impacted by the proposed works. While there are no reported archaeological sites of interest to Manawatu within the project area, the sites G432 and G412 are evidence of the presence of modelling on the landscape. G432 is recorded approximately 730 metres northwest of the project area, and G4412 is recorded approximately 230 metres southwest of the project area. The assessment identified there was further potential for unreported archaeological remains to be encountered throughout the project area. There are no scheduled items on the Central Otago District Plan within the project area, nor any listed places on New Zealand Heritage List without any korero. No wahine tūpuna were found to be reported on available district plans or management plans. However, Kalinaka had noted that there are wahine tūpuna proposed for inclusion on the COPD.
Just like to say, normally in these hearings we have microphones, but yeah, it's the technology wasn't available, so we apologise for that. We forget sometimes that, you know.
Oh, just doing the best for the project.
The EAC outlines recommendations and mitigation measures included in the archaeological assessment, including gaining an archaeological authority under Section 44 of the HNZPTA 2014, archaeological monitoring of all topsoil stripping completed with a hydraulic excavator in high-risk areas, which are figures 9.3 and 9.4 of the report. 2 test trenches shown as orange zones in figure 9.3 of the report to identify any archaeological remains around the vicinity of the timber burns. If archaeological deposits or buried topsoil are encountered in these test trenches, these will be left in situ until a new authority is sought for excavation of these sites. Beyond the red and orange zones, works should operate under an on-call protocols. Artifactual remains should be salvaged and reinstated. Work should be guided by an archaeological management plan. And if archaeological material of Māori origin is discovered at any stage, all work must stop within 20 metres of the find until all required parties are notified. In my view, the recommendations and mitigation proposed in the archaeological assessment are seen to appropriately manage or mitigate the potential adverse effects on the reported and potential unreported archaeology, with the negative impact on the physical and contextual values being supported by the positive impact on the information value of the reported and unreported sites as well as the amenity value through the display of salvaged items in the interpretation panel within the view of the cycle trail. The ERC addressed submissions from Okaha and Kaitahu regarding the location of archaeological sites of interest to Manapōnua, as well as the limitations of the survey in steep areas. In summary, I conclude that from an archaeological perspective, the effects on potential unreported pre-1900 Māori archaeology is suitably mitigated, as that archaeology will be avoided, and that with the proposed mitigation measures, the overall effects of the proposal would be appropriate. The evidence lodged on behalf of submitters, including Te Runga o Tahu and Kaitahu ki Otago, do not raise any additional archaeological concerns not already addressed in my EIC. I therefore remain of the view that with the proposed mitigation, the overall effects of the proposal will be suitably mitigated. I consider that the overall impact of the proposed work on archaeology will be major, however, with the mitigation recommended in the assessment, overall adverse effects will be reduced and can be supported.
Thank you. Have you had a chance to have a look at the archaeological authority that's been issued?
Yes, yeah, on my phone, but yes.
You seem to have a hard copy here, although part of it's upside down, which is intriguing. And in Miss Colley's evidence, there's a recommended condition. Conditions 44 and 45 relate to archaeological sites. Perhaps if you could bring that up. So for a resource consent situation where you've got an authority under different legislation, in your experience, what level of conditions are appropriate to deal with archaeological values when there's an authority in place? And you can answer that one first.
I guess it depends if you are looking at it in terms of the archaeological values as assigned by the RMA or the archaeological values as assessed under the HNZ PTA.
Yes.
And the archaeological values as we assessed it in our work was based on the guidelines under the HNZ PTA. It's difficult for me to say essentially that they are, I guess, the same or should be addressed the same. In my view, the conditions proposed, but the conditions set out under the archaeological authority should cover all, aspects of protecting those archaeological values and addressing any adverse effects on those archaeological values.
So you said that there's a difference between archaeological values under the, sorry, I can't recall the name of the Act, Heritage New Zealand Act, apologies, and the Resource Management Act.
In my understanding, yes, and that the Heritage New Zealand Act is based on a physical feature.
Yes.
Our assessment of that has to be related to a physical item or feature or site.
Yes.
And can't be assessed based on a potential site if there is no physical feature. Whereas my understanding is that under the RMA is a bit more a landscape view and potential view. And it's not 100% tied on the physical.
So is your assessment hasn't been undertaken under the RMA? Is that what you're saying?
Correct. We can't assess an archaeological site that isn't yet there, if that makes sense. If there is no physical site as yet, we cannot accurately assess that.
So who do you mean by we?
In my case, New Zealand Heritage Properties are concerned, but in general, an archaeologist working under the Heritage New Zealand Act.
Yes. So your evidence was provided to us as part of the resource consent application. And what I'm hearing is that it's not, you haven't assessed archaeology under the Resource Management Act. I'm a little bit confused about that. Maybe your legal counsel.
What I understand is being pointed out is simply that there is not an ability to be definitive about an unknown archaeological item, because you don't, it's not, you haven't seen it.
Yes.
This witness could refer back to the report if they chose to, and my recollection is there are indications given in there as to the anticipated value of what might be found, or it is necessarily speculative, and therefore, as I understand it, this isn't an indication of a shortcoming of the evidence in this particular case. It is simply making the point that the difference between the two regimes is one is dealing with the known. The RMA process is slightly more challenging because there might be something found, and therefore you have to put in place conditions that
Yes.
anticipate what might.
Yeah, thank you. And Ms. Ross, so back to Ms. Colley's recommended conditions. She's recommended that the consent holder must comply with the recommendations of the archaeological report, which presumably was prepared to support the Archaeological Authority application. Are those recommendations now, have they now come through in the authority? Are they the same or are they different?
Correct, they are essentially the same. The authority refers back to the report and the AMP, and notes the mitigation methods set out in the report.
And so either you or Ms. Colley might want to think about a change of condition that's more up to date in that regard. So that hopefully that's noted. And in addition, given you've said that your assessment can't speculate what you might find once you start digging up the land, do you think it would be appropriate to have an accidental discovery protocol condition listed in the resource consent?
So I would just ask for clarification here on whether you mean an accidental discovery protocol or an on-call protocol. An accidental discovery protocol is used where there is no archaeological authority in place, whereas once an authority is in place, we refer to it as an on-call protocol.
Okay.
So just checking.
So tell me about an on-call protocol then.
So that is stipulated in the report and in my evidence. So paragraphs 26 and 27 discuss the on-call protocols.
Yeah.
The on-call protocols, it's where we have an authority in place from Heritage New Zealand, but we do not have enough definitive proof that there is a physical archaeological site within that particular area. And so we work under the on-call protocols, which is where all crew on site have been briefed on the authority conditions, in this case, in the RMA conditions, and the archaeological management plan. Works take place with an archaeologist on site, but there are a set of rules that the contractors will follow, which dictates if, while they're doing the excavation, they encounter anything that they think is potentially archaeological, they would stop works. They would call the archaeologist, either send a photo, or the archaeologist will come straight to site. An assessment will be made if it is archaeological or not. And then it will, as long as it's not a site of high significance, works would continue under the monitoring of an archaeologist as outlined under the other topsoil stripping monitoring requirements. Once that site has been excavated, works would continue under the on-call protocols again if the archaeologists had determined that there was no further visible risk to archaeology.
Okay, yeah, no, that's helpful, thank you. And to the on-call protocol is that's not included in the authority, but it's in your report, is that right?
It is.
Or it's, I
believe it is in the authority under one of the conditions that states all works must follow the AMP, which includes a description of the on-call protocol.
So AMP is what, archaeological management plan?
Correct, yes.
Okay, so would it be more appropriate then that the conditions of consent refer to the AMP than the report?
So we don't yet have an archaeological management plan.
It hasn't been written as yet because it relies on the conditions set out by the archaeological authority.
So the conditions made.
Yeah.
Yeah. So on that, so just continuing on from Commissioner Taylor. So what we've had is we've had your recommended way forward with your recommendations, and that was submitted to the archaeological approval. We've got the approval, which refers to what's set out in the archaeological management plan, but we don't yet have a management plan. Is that correct?
Yeah.
Okay. So in terms of how this works, the approved person, is that you?
In this instance, yes.
And will that continue to be you?
Yes.
Right, so yeah, there probably needs to be some reworking, I think, of the conditions and Miss Colley's evidence so that it marries up with this process. And I guess that relates to quite a lot of the other questions around management plans. And there's also that potential duplication with the archaeological authority versus RMA conditions. But I guess what I'm interested in is what certainty does the consent authority have through conditions of the land use consent that the site briefings and everything will be undertaken in the way that was envisaged by your recommendations?
In terms of that, how we would generally, both of that is site briefings are always undertaken by the approved person or a person appointed on their behalf. A register is always kept of all attendees of that site briefing, date, contact numbers, which is provided to Heritage New Zealand, and in this case could be provided to the councils as well. We keep an open communication with site management. We have suggested that the topsoil stripping and archaeological works happen at the start of each stage to reduce the hopeful need of work on site that requires an archaeologist. But we work on an open communication kind of scheme, and that we'll keep in contact with the site manager, they'll keep in contact with us. We do general check-ins, and we can potentially make the condition of a yearly check-in or at start of or end of each stage before the next stage progresses. We are required under the authority, the archaeological authority, to also undertake reporting at the end of the authority, and I believe this one is within 12 months of the completion of on-site archaeological works. So that's not just the on-site excavation, but that's the works involving the archaeologist. So in theory, our report would be submitted before that time.
And would all of this, forgive me for interrupting you then, would all of this annual reporting and monitoring then be a subcategory of the overall gold management plan?
I believe so. It would be included in our archaeological management plan, so I believe it would be then.
Right.
That overarching.
Okay.
Just on that, I'm not particularly happy with the word gold management plan. I think it should be a site management plan. Overall site management plan, because we're not managing gold.
Yes.
Okay.
Yeah.
Did you hear that at the back? I said, but it shouldn't be called a gold management plan because it's not managing gold. It should be called a site management plan because it's managing the effects of the site. So just wanted to flag a change in the name of the plan.
And if I might, Mr. just this line of questioning to help Ms. Ross. It seems to me there's a flavour here of whether, as currently we've talked for sort of cross references, that separate process, and in a lot of ways is really what we're driving at, whether the conditions should more expressly set out what controls are engaged in so that someone can see on its face what is required as opposed to having to go away and look at those other things.
Yeah. And Ms. Ross, I seem to recall it could have been in Ms. Colley's planning evidence. There was some suggestion that not everyone who was working on the site needed to be briefed. Do you recall that?
I don't recall that, no.
Okay, but, okay, so I'll potentially explore that with Ms. Colley later, but in your opinion, anyone working within the site would be subject to the on-site briefing by yourself as an approved person about the archaeological work required and all of the conditions of the archaeological plan?
Correct.
So that's all personnel, all contractors within that site?
I think the legal requirement under the authority is all contractors taking part in excavation works. We usually include in our archaeological management plan, and it's one of our standard conditions that we have, is that all on-site contractors who are taking part in excavation, as well as site managers and project management, all undertake the archaeological briefing, so everyone is aware of the different conditions and where they need to do their part on each thing.
Mm-hmm. Great, thank you.
Just, sorry, to add to that, so your on-site briefing is done by an archaeologist. The authority covers archaeology. It might be European, it might be Māori. You don't know until you've discovered it. Would it be appropriate to include cultural briefing as well at that stage, and perhaps having a cultural monitor there as well, given the concerns raised by Ngāra Naka?
It is under one of the conditions does note working with Runaka to ensure that all tikanga protocols are adhered to, and usually as part of that we would undertake a cultural briefing and invite a cultural monitor to site.
Is that a condition on the archaeological authority? Or
Yes. Not exactly sure which number.
Okay, condition 8.
This authority refers to all contractors working on that project. It doesn't define that project. Well, my first look at it. What I'm sort of taking with the conversation is that you've made a number of recommendations in your report to mitigate effects. And it'd be quite useful for us if you could go through this authority and identify the your recommendations that aren't in here and provide an updated set of conditions that cover your recommendations that aren't covered by that.
Yeah, are you wanting that now?
No. I want, 1 minute. No, you have a right of reply, so we're flagging a whole lot of things that we think we'd like to see more information on, and that will be in a right of reply. If you get it to us earlier, that's fine, but yeah. No point in bringing it today because we've got enough to look at. Thank you. What do you think? Questions, because I didn't actually answer.
No, you haven't had a turn yet. Off you go. Darling.
I guess my bigger picture question is, could this excavation that occurs potentially add value to history, to the heritage values? If you discover something, you can put that in the history picture. The heritage value, you can, there's actually evidence in this part of heritage is there for present in your mind rather than being buried in the ground. So isn't there, does this add value to history if something is discovered?
Yeah,
it's not necessarily all bad, is it?
Yeah, no, definitely. I definitely agree with that. In terms of the recorded sites that we already know of, there's potential there to learn more about those sites. Some of them we've only seen on face value, they haven't been properly investigated before. So this offers the opportunity to learn more information from those, as well as in terms of what's already been recommended, the moving of some of those physical artifacts and putting them in a place closer to the site locale with an interpretation panel really allows that amenity value. And in terms of the currently unreported or potential sites, it really does offer the opportunity for us to see if there is anything else on the property and those instances to learn what else has happened on these sites and where that might fit in with the current understanding of the history of the land. So there's definitely room for that positive kind of learning from this, yeah.
And thank you for your updated plan with all the different figures on it and your recommended high risk areas. Found it quite useful.
I just got one follow-up question. One follow-up question there about some of the positive benefits of the revealing perhaps built heritage, but physical artifacts. Are you saying that from a perspective of European history? Or yes, so you're not including that, you're not saying that through a cultural lens, you're saying that from a European history point of view?
Correct, yes. That's based on the currently reported sites.
Yes.
Which are the.
Thank you.
Yeah, we were just discussing whether, just in terms of that answer, and I'm going to put this carefully because it's for the witness answer, not me, whether the witness should clarify, setting to one side the cultural view of other discoveries, in particular modern discoveries, whether I presume it would be fair to observe that you would learn about any discovery made which has value. If that were the proposition, what would your view be?
Yes, so then, yes, my answer was in terms of the former answer being in terms of the reported sites. In terms of all sites in general, there would be value in all sites. However, it's not my place as the archaeologist to assign that cultural value. That's outside of our expertise. So the cultural value of those sites would be outside of our.
Yes. Understood. Thank you. Yeah.
Thanks, Mr. Ross. Appreciate your evidence.
I didn't want to embarrass Ms. Ross, but it's the first time she's done it.
Oh, well done.
Well done.
Just as she's doing it.
Expert now, so I can
Yeah.
say.
Thank you.
We've all had a first hearing, so well done. Yeah,
Mr. Heaton.
it is not his first hearing.
Good afternoon.
Good afternoon.
My name is Midland Heatley. I'm a civil engineer specialising in environmental acoustics. I have qualifications and experience as put out in programs 2 and 3 of my information. I confirm that I have continued to comply with the code of conduct for instance in preparing this summary statement. The Central Otago District Plan sets out noise limits for permitted activity to keep the noise environment for the neighbours around the proposed mine site. These limits are 55 decibels as an LTM during the daytime and 40 decibels LTM at night and 70 decibels maximum value at night time. The district plan also provides guidance on the objectives and policies to ensure that noise is controlled to within a reasonable level. As there's no other guidance in the control of noise in the district plan, then if noise limits, objectives and policies are satisfied, it's considered reasonable to assume the noise effects will be within a reasonable noise level for the neighbours. Noise from the proposed mine would be predicted based on field measurements undertaken that all plant will be used on site for adopting a recognised computer noise prediction model. This is the same place has been used successfully and has been successfully adopted at many similar mining ventures both locally and throughout the country. Based on the predicted noise levels, the current noise limits as set out in the district plan will be achieved with objective of safety. Similarly, the objectives and policies will be satisfied. The existing noise environment has been measured and compared with the mining laws. On this, the noise from the proposed mining will be well within the noise level and not have any adverse effects for the labour. There have been a number of submissions that raise noise and potential concern for this. I've addressed these concerns in my evidence and conclude that with the proposed mitigation measures, the noise effects will be less than minor. It's important to realise the mining is a transient effect and will not continue at any given point for more than a few months. By that I mean at the upper levels of obviously you're here at lower levels too. Other transient noise sources that can occur for a similar period to the proposed mining include the construction of a building or highway reconstruction. Both these activities treated as construction noise and so may generate much higher noise levels for the reasons than what ever be experienced from the proposed mining. Subject to developing minor changes, as the doubt made and achieved, the noise conditions that are proposed by the council plan are accepted. In conclusion, in my view, with the noise control proposed, plus achieving the noise limit for the good factor of safety, to ensure the objectives, policies, noise conditions for permitted activity, in section 16 of the RMA to adopt the best practical option to minimise the noise are all satisfied. Considering above, the requirements of source today, those that individual goal point can be managed so the noise effects will be less than minor. Thank you. Now, I've just received after lunch additional information that's filed with us given. I was wondering if I could quickly go through the comment on the main points in that.
Yes,
Don't
Mr.
tend to go through it. I'll let have one that page of picking out the main areas of.
No, that's fine. I wonder if you could just try and speak up a little bit. I know the people at the back are struggling to hear you. Thank you.
If you've got that,
Just one moment. Yes. Got that? Yep. Yes, thank you.
okay, go to table 1 on page 2. And point out there's an AQ column there. I don't want to get confused with noise as bad enough as it is. You can repeat that. I've not mentioned in my evidence, not in the plan. So I would suggest it will only get confused because about worrying about what AQ means. So cross that table off. The quote to start with paragraph following that table. Sorry, it's start with excellent. My noise measures only do $30 and not presented as complete or typical sound environment in the area. That's if I can. I think they're reasonably representative for a short period of time. You can also look at my evidence on page 8, please, where you see 2 gaps of proper noise.
Is that figure 2?
Sorry.
Is that figure 2 in your evidence or?
Figure 2, yeah, figure 2 is the one which is normally at the same location.
Yes.
As the explorers. So normally on the other side of the road, but for intention it's the same. Now, I should also point out in my evidence on paragraph 29, I point out monitoring is unattended, results will be taken representing the general noise environment. Then one such as this only guidance on what's going on. You don't look at a man from, you don't look at the you look at the basic training. Because the numbers will also vary over seasons too. If you look on the graph in figure 2, you can take and the basic terms. I'll put the district plan levels on there, the red line stepping up and down. And the second level for the daytime period, you see the noise level starts near up near district plan limits, drops right down and goes back up. Where it's dropped right down, that's around the middle of the day. And this X is in his measurements around the middle of the day. So that period is represented the day I measured. He's actually got level, I've got level below what he's got, and levels obviously above. So it does, that demonstrates very clearly, look at the whole day, levels. Very important when you start hearing noise level, what you're actually talking about half the day. The same applies if you go on to the number of first steps a day, so 1, 2, 3, the 4th day along the middle of the graph. Same sort of thing happens slightly later in the day. And then go on to the second last day, the same thing happens. And the last day it drops down to levels the specs has reported. So yes, what he's measured, I've exactly got those. I have as well. what I'm saying, if you look at this as a trend, the same way the mining law is not exactly the same all time, it varies all the time, the truck fast and that. So you look at the trend there, and that's what I work on, and looking at what the effects are. And that's why we do the extended period of measurements. I can go and do 5 minutes, but I think it's representative if I'm only there for 5 minutes or an hour or whatever it happens to be. You don't know, let's say you clean nothing very every day. So I think that's important. In that sense, I agree with Mr. Easter's levels, but he's then adopted those as represented the entire period, which I think is very risky. I never do that. Now, in the third paragraph down on the same page, start by comparison. Again, the attitude is ignore that because that's confusion, doesn't help at all. The next paragraph is saying that events cannot be news levels for them once they are controlled, but sources of events that cannot be identified. I agree, and that's what I'm saying. We're looking at a trend. We're not looking at absolutely what we're doing long-term monitoring. I've only had one example we've done long-term monitoring that's been attended, and that was looking at a particular noise software before it happened, with the issue or not. And that probably relates to the whole night. You had to be there and listen to it together. It's an unusual example.
So just is Mr. Exeter listening?
Yes, yes.
Okay, thank you. Hopefully you can hear. We just check. Mr. Exeter,
Mr. Exeter, Jane.
Mr. Exeter, are you online? I can see Jamie.
Yeah.
Hello, yes,
you
I am
there?
here.
Ah, fantastic. Lovely. We can hear you. I was just checking that you were listening to Mr. Heagley, and can you hear him?
Yeah, on and off. Yeah, I think I heard most of what Mr. Higley said.
Okay, thank you. Just to flag that we will be just asking you to provide comment on your paper and any comments Mr. Higley is making when you present tomorrow.
Sure, no problem at all.
No, we'll wait till tomorrow for that, but thank you.
Okay, thank you.
Good. Page 3, section 4, and the 1, 2, 3, 4 page down. I'm unable to, I'm not quite sure what's going on here with the proposed, read what he said. With the proposed noise limits, the noise would not be able to exceed a predicted 49 decibels L10 at the national boundaries of the sites. As I understand, the condition I've recommended and the conditions that recommended the section 42A report, which is based on Mr. Exeter's report, is 55 in the daytime. So I'm not sure where these levels come from. So I can't comment and say it's unclear to me what's going on here. And it also goes on, but I think it could be 5 dB or more higher. It could be, it's not going to be. That's my evidence is that it won't exceed the limits. Okay, cool. We won't. In fact, if we get approved and get a condition, we're not allowed to exceed because I'm assuming the level 55. So it's compliant with finding. On the second to last paragraph, starting proposal is to comply, etc. This says, the last sentence, I therefore consider it appropriate to reduce potential noise effects through conditions. Again, I'm not sure. It's not good work in how we got there, but what makes me more unsure what's going on is Mr. Starr's original report to council. And if you've got that, sorry, mistakes of this substance there. His original report. Just read what he says in the recommended conditions in that report. He sets out the noise levels, which are 55 in the day and 40 decibels at night time. So I'm not sure he's talking about lowering them there. It seems to be a change of where he's coming from. Because it's in conflict with his original recommendations, which the council plan had picked up on, and I agree with. The only time he has recommended lower levels is for the water pump, which I think I've covered in my evidence. And I'll summarize that so that, except for the stage one, when we've got to use the generator, will be run on power. So I won't say silent, it's very quiet then. But just because it's quiet doesn't mean say it's appropriate to set a lower noise level. The level that should be set should be the appropriate for the area, not simply what applicants says they can or can't achieve.
Thank you.
Yeah, and then that's
I just have one question for you, Mr. Higley. You have addressed the various submissions in your evidence. Thank you for that. Ms. Gunn, Wendy Gunn, has suggested that a noise monitor at her property would give confidence that the noise levels are not going to be. Little visitor.
It's a good omen.
It is, just, no, it's not.
They don't.
No, it's not a good omen. You're okay.
It's a good omen.
As a, okay. Sorry, Mr. Higley. Sorry, I lost my train of thought. So Ms. Gunn has suggested or has asked for a noise monitor at her boundary to give confidence that the noise levels will be met at her boundary. What's your opinion about the value in doing that?
I can understand that it would be sought, and I agree with it in principle.
Yes.
And this is where the noise management kicks in very nicely. You don't put a condition that noise should be on the perimeter or anything like that, because that creates a huge amount of data which is going to be no use at all in real life. The noise management plan can specifically address things such as noise monitoring related to exactly what they're doing at the time. And also, I would expect the noise management plan will have a complaints procedure. If someone rings up and says, I don't like the noise that's going on, because we encourage the residents to get in touch with the mining company first, because rather than council, mainly because we don't want to create a third person in the line, so it speeds things up and be looked at very quickly.
Yeah.
And the noise management plan will include things such as if there be a complaint, the noise level will be checked at that point. It's very easy to do. We have a portable monitor available, people trained to do the basic monitoring.
Yes.
And then you get up there and do it. So you can get that way, you get instant results. As the central, all due respect, thanks to the council at the end of the day, sort of thing.
So though that requires a concerned resident to go get annoyed enough to make the phone call and then wait for the response and so on. Is there not a, I guess from a from your expert perspective, is there any value in having a monitor on her property compared to where they've proposed on the site boundary?
So perhaps I should say that I gave the answer to that particular person. We would also have the management plan, the noise levels will be checked at the start of the commencement in a particular phase that it was compliant.
Yeah.
And it's not obviously you get in extra quickly and
where does that get checked? Is that at the boundary of the site or?
it may be checked close depending on the practicality of it, because you can measure closer and interpret back to the notional boundary. But the notional boundary is the critical location. Typically, the first line of attack would be measure the notional boundary, where it's practical or something like that. We've had cases where people don't want to be on site. So we measure the representative position to reflect what they're getting. So yes, there's two stages of the monitoring. There's one, check that you're doing what you said you're going to do, and that's a different thing. Check repeat complaints.
Yes. And for Miss Gunn's property, are you familiar where I'm talking about? Have you looked
at the name? What about the number?
1581.
Oh, yes, no, at all.
Yes. Is there a need to have specific monitoring out on that property, at the notional boundary of that property?
Because I'm always reluctant to give a specific location for a specific person, because everyone's important. If you can find all sites. So what I'm saying is then I think we'd probably use her as a sample of where we go, but it doesn't mean to say she's the worst affected of chicken passing mining. So where she's the worst affected, yeah, that would be more an site. Where she's not, it wouldn't be a real site. It would be something to keep in mind. And that goes for anyone who's played at any stage, that you would keep them in mind all the time is people who are particularly concerned about noise, but people who are concerned in compliance. Some people because that's human nature. But we would monitor those people more regularly than we monitor the person who's totally oblivious to noise, whatever noise.
And in terms of those, so that checking, so not of complaints aside, I understand your process there, but for the ongoing the checking as you need to with the change of activity or change of stage, that's set out, that would be set out in the management plan. Yeah.
And I should point out
operational noise management plan. Yeah.
We have that, and the term I would normally use is available to council if required. We don't want to overload you with all the unnecessary work.
Yes, in terms of reporting. Yeah. And that management plan, can someone help me with the latest version of that? Where would I find that?
The noise one hasn't been prepared.
So not prepared yet.
And one of the reasons I'm reluctant is something to say, I don't know exactly what the conditions will be. I like to think I know if you can 100%, but we tailored around the condition. But remember, it's a management plan, how we manage the meetings. We need to know what's different. For instance, one thing that's changed since I started this project is in the area one, no longer using bulldozers, and my predictions are well over there. Because we've still ecological sites. Well, not the area that you know the area. They're not using bulldozers anymore, they're using excavators because it's easier to check if it spikes up and it didn't know was there.
Yes, and so there are a number of conditions set out in Ms. Colley's evidence. Conditions 26 onwards relate to noise and vibration. Through to and including 31. Have you had a chance to look at those before now?
Yes, I know what's on this.
Yes, and are you comfortable that they cover the recommendations that you've made?
Yes, but I should point out the management plan is a living document.
Yes.
So if you get started, you find the whole of it, you probably add it to the management plan.
Yes, so in the condition, and this was a general comment for me around the conditions about management plans, there didn't seem to be, or there's a number of things about the management plan conditions that I'm not a fan of, but one of them is it's not clear about the purpose, it's not clear about certification, and it's not clear about how you would deal with variations or changes to the management plan and how that connects into your certification process. So just flagging that in the reply, it'd be useful to have that covered off.
And can I point out, I see this is the minimum requirement. Management plan is a lot more than this minimum. For instance, complaint procedure, we can keep our complaint procedures, things like that, and then actually take a bit of this is the minimum requirement. And it depends on partly on how much we put in there, what we don't know the burden system, but we want to get it right.
Yes, well, it mentions procedures for receiving and responding to complaints, so
yes,
that is in the condition. Yes.
That's what we do.
Yes. Okay.
One question. Paragraph 20 of your evidence, you've made your assessment on the basis of bunding at that point in time. The bunding has since been expanded. Does that improve your assessment?
Yes, perhaps I should address the bunding is not intriguing, is probably why I've done the bunding for this stage. The bunding we've recommended is the minimum. If you want more info other reasons that can only improve things.
That's not my question. My question is in paragraph 20, you've based your assessment with bunds at that point in time of your assessment. Since then, there's been additional bunding put in, recommended. Because you're only talking about 300 metres down the western side, whereas the current bunding is quite a lot more bunding.
That's right.
Does that improve the situation from a noise perspective?
There's a house between the, beyond the bund, yes, but obviously there's no house, but there's a bund wall. But
So it wouldn't make your assessment any worse?
oh, no,
It
no,
only ever improve?
only improve.
Okay, thank you.
But with the bunding, what I haven't put in there hasn't been clear, I think, for a lot of people is the width for the bridge is about 12, 13 metres down from there. So you've got a 12 metre bunding line. I've modelled my predictions based on the ground level.
Yeah, that was my next question. Does working down below ground, does that mitigate noise as well?
Absolutely.
It does.
And that would have more effect than the bunding proposed by government. Obviously got some equipment like trucks still at the top. They're right.
So when you say your worst case assessment, it's really is worst case because you're going to be a lot of attenuation because it'll be down at 18 metres, 15, 12. Yeah, okay.
It'll make a huge difference going down.
And could you help with an updated set of consent conditions recommended or offered at some stage in the point?
Yeah, I reckon the planning instance of years.
That take your recommendations into account?
Yeah.
Thank you. Also.
Thank you, Mr. Hickley.
Thank you.
Thank you for allowing us to just move those witness order around. So the next witness will be Dr. Barry Wills.
Okay. Oh, good. Yeah. Kia ora. One moment, we'll get ourselves organised. Lost your evidence, Mr. Wills. One moment. Actually, why don't you make a start reading your summary? Thank you.
So my full name is Barry John Wills, consultant scientist. I have a BSc Honours in Genetics and PhD in Botany and Microbiology from the University of Canterbury, basically relating to high country vegetation, soil conservation, set out in paragraphs 2 to 7 of my evidence and check. I confirm that I've continued to comply with the code and come back to expert witnesses in preparing this statement. In addition to concerns raised by submitters and in the FFA reports, my evidence primarily addresses the site physical environment, i.e. the climate, soils and land use capability, and botanical vegetative biodiversity, rehabilitation recommendations, and Indigenous enhancement opportunities. Majority of the land within 68 hectare line boundary is currently farmed, as you've already heard, and has an extended history of agriculture. The ground has been intensively modified by fencing, filling, and drilling, and some of it by historical gold mining. By way of summary, I note climate, variable climatic conditions going forward, they're a given, plus all mining site activities must adapt accordingly. Soils, some reports name soil differently. However, I agree with the New Zealand Soil Bureau designation as the Gladbrook soil, recent soil rather than a Hawkeswood type. has a medium to low nutrient status, pH 5.7 to 6, and is responsible to fertiliser additions, particularly sulphur and phosphate. However, it is also susceptible to wind and sheet erosion when exposed by elevation. Land use capability. Main land use capability class across the soils that dominate the mine site has the following parameters. The land has moderate limitations for arable use and is suitable for occasional cropping, pasture, or forestry. It has some soil physical or chemical restrictions in the reading zone, such as shallowness, stoniness, low moisture holding capacity, low fertility. These can be mitigated with the correct management.
Mr. Wills, am I correct that LUC class would be lower than a 1, 2, or 3 in terms of NPS highly productive land?
It would be in the lower critical, yes.
So not 1, 2, or 3? Or what about a 2 or a 4? So if it's a 3, that would mean there are obligations under the National Policy Statement for highly productive land.
Well, not it's shown as such in how you register based on those case law.
Yes, correct. Yes. Can you clarify it's not?
My understanding is not.
If I should just answer that question, I can clarify that the LUC classification on the register is not 1, 2, or 3.
Yeah.
It's 4S6, isn't it?
Yes,
That's what DTM carries from before.
Okay, thank you. Yes.
Botanical or vegetative biodiversity. Bulk of the area to be mined currently comprises exotic from grasses, legumes, and brassica community. Areas previously disturbed by mining exhibited a mixed cover of exotic scrub and trees with annual grass and nothing native. Given the area has such a long history of mining and pastoral farming, it largely consists of exotic monocultures with indigenous biodiversity virtually completely lacking. Indigenous vegetative biodiversity is low, only existing to a minor degree on historical vegetative. Land and soil rehabilitation. The rehabilitation technique described in the updated site plan description, which is dated 22nd of the 4th, 2024, will be sufficient to restore the physical land and soil profile to a landform with sufficient subsurface stratification that will enhance drainage by an upper soil horizon capable of supporting ongoing productive pastoral farming practices. Several possible rehabilitation issues to be aware of are described, including topsoil compaction, topsoil deficits, soil biology, comprehensive soil characterisation, vegetation establishment and seedlings. Options for ecological enhancement during rehabilitation. For the bulk of the mined area will be progressively returned to a productive pastoral and agricultural ecosystem. An opportunity exists to provide indigenous enhancement and rehabilitation along the adjacent Fleet Gold Trail corridor Durban. Such a project would require mechanical removal of pockets of exotic scrub along the river embankment and the planting of a range of indigenous plants, which are described in Appendix 1 of my evidence and sheet. Matters arising. In terms of the Central Otago Clutha Trails Company Limited, which I'm a director, I understand that the panel raised my position as a board member of the Rocky Gorge Trail Charitable Trust and my directorship of the CL Clutha Trails Company of the American Comment and Legal Commitments. I am advised that Mr. Braddock has addressed that in legal submissions. I confirm that the question of probable conflict of interest was raised with the chair of CACP, Marie Patterson, prior to commencing work with Hawkeswood. No issue was anticipated. The board are also supportive of Indigenous enhancement plans along the trail. Enhancement plans. The location of 4 sites is outlined in Appendix 1 of the site staging plan, including the location of these biodiversity clusters. Each avoids heritage locations and large riverbank cracked willows, and will be planted with indigenous stock plants. Plant age size will be dependent on nursery supplies, may vary depending on season. Species outlined in my report are appropriate to the riparian ecosystems in Central Otago. Planting will be carried out in early spring, August and September, usually the best, and can be staged along with the mining program. Planting methodology details are discussed in my report, including the use of natural file stuff to enhance symbiotic association and therefore survival and growth. The nearest substantial block of natural indigenous flora I'm aware of is within the Rongheri Gorge, which is south of Beaumont, some 20 kilometres away. Once planned enhancement plantings are mature, they'll provide a natural habitat link for avian fauna and local preferred fauna, by lizards. And at this scale, they can be more easily managed and protected from predators and other pests. I believe they will enhance the natural character of the Clutha margin, provide amenity values for Clutha trail users, and indigenous ecological values in the margin. In conclusion, I consider that the mine site can be successfully restored to productive agricultural land-based mining. Given that indigenous vegetative biodiversity is lacking on the mine footprint, enhancement planting along the adjacent Clutha Gold Trail corridor, Clutha River Boom is recommended to enhance indigenous rehabilitation. That's me, thank you.
Thank you.
Yes. How do you
Ross.
Thank you, Mr. Wills. With regard to enhancement plantings, you would have heard me asking a couple of questions in relation to that today. You've explicitly talked about the natural character enhancements to the Clutha Mata'o margin and values for the Clutha Gold Trail. You are likely to be aware of the Runaka's submission and the evidence of Mr. Weil, who noted that there's no riparian planting proposed for the Tema Burn. Have you turned your mind to this issue and with your knowledge and experience? Can you talk to us about your viewpoint in relation to that potential enhancement?
Yes, the timber verticals is very heavily overgrown at the moment with fake willow. I guess there are advantages down the line if farming was to be made there, but the offer by Hawkeswood at this stage of the game is basically along the our river frontage.
Yeah.
If they can't get access to it, obviously, then I guess they has to wait until the situation will change. But I can see advantages to doing it.
Yeah. So the advantages would be similar to that which you've described for the Mata'o, or is there distinct advantages?
Yeah, I don't see any different.
Any different, right? So your assessment would apply equally.
Yeah.
Right. Okay. Great. Thank you. And the other issue regarding the detail of the conditions, have you had a look through? Are you involved at all, or have you discussed with Ms. Colley about the conditions on the land use consent with regard to plantings, enhancement plantings?
Yeah.
So
Yes, so this is number 47.
yes.
Yeah. I haven't actually seen this yet, but what we're saying. Yeah, okay, rehabilitation plan. So, I mean, I'm happy with that, the rehabilitation plan. There is some information already given, of course, in Enviroscope's report and also in my own land use reports. And I guess this will fill in on that more detail to actually have a plan.
Mr. Wills,
Issue.
sorry, Mr. Wills, the Enviroscope report you're referring to, what's that? Is that the erosion sediment control plan, or is it something else?
Actually, apparently that hasn't been tabled, but it's a draft mine site rehabilitation plan.
Oh,
Could I clarify that?
Yes, please do.
The rehabilitation plan, we have a draft in hand that has been sent to Karen through Olka several weeks ago. Their initial comments. It really is a first cut of the document, and for that reason, we didn't table it to the commissioners. And so because there hadn't been any feedback today from town, they can incorporate some of that. Mr. Wills has been involved in the drafting of this. This has had a number of other experts. We had anticipated taking a copy as part of right reply.
okay. So is the intent that that rehabilitation management plan would provide in much greater detail the proposed enhancement, types of species, methods?
That's correct, and Mr. Wills refers to his report where he's already done some work on what those appropriate species might be.
Yes, I've outlined a number of species in there that they can choose from. They're all appropriate to riparian areas here. And I've also made suggestions as to which ones to start with. And also the comment I made about bringing in duff from perhaps the longer hairy gorge. It's going to bring in seed, etc. So that will diversify the process as we go along.
Okay.
I'll expect to see it improve with time.
So, Mr. Wills, have you been feeding into the, sorry, was it who's the author? Geoself, no.
The rehabilitation plan has been prepared in Enviroscope.
Enviroscope. Have you been feeding into the draft Enviroscope plan? Yeah. Okay. Thank you. Yep. Sorry.
No, it's all good.
Are you doing anything?
Yeah.
You've given a number of recommendations in your evidence that aren't reflected in that condition we just looked at. I was wondering if you could please look at your recommendations again and advise Ms. Colley on conditions that you think should go in the condition set that implement your recommendations. Otherwise, it's just a big debate.
Yeah, totally. I'm quite happy to do that.
Thank you. The other big picture question I had is who owns the land along that riparian margin that you're talking about doing enhancement planting on?
That will be Lynn's land, Crown land.
Have they given an access agreement to do that planting?
They will need to be, they'll need to be advised, and I presume they'll have to give authority to do that.
So they haven't given an access arrangement.
I haven't been part of that discussion with the state of going, no. If they books with that.
So how much weight can we put on that as an offset?
What's an enhancement? I see it. Offset.
Well, under section 104 of the Act, we're allowed to look at offsets. And so it's been pitched through the planning team as an offset, a positive effect. So regardless of term, how much weight can we put on that as an enhancement or an offset if there's no access to plant it?
Well, I mean, from my point of view, I guess that is the process going forward. The next stage of this, if the rehabilitation plan is completed, that will be part of those discussions. And of course, we see the enhancement planting as being staged along with the line, and therefore it can be done over a period of time.
Okay, so to put it another way, if you took that enhancement out of the equation because they can't get access, how does that change your assessment?
In terms of the mine footprint, it doesn't change it at all.
No, yeah, in terms of your assessment of effects, is it?
Well, as I say,
Like, how much weight did you put on that enhancement when you wrote your evidence?
it's an additional extra, as I said.
Right.
Okay. It's something that Hawkeswood are offering because we have very, very high levels of Indigenous biodiversity on the mine footprint itself. And so that was something we discussed, and we thought that has been advantageous to the mine site, the footprint going forward, and to the trail next door. And as I said, the board.
I understand all that, and
Yep.
I agree it is an enhancement,
Mm.
but if we were minded to grant consent, when it would be an enhancement. I'm just not sure that we can take it into account, given that the landowner hasn't agreed to it. Same case with Timber Burn.
Mm.
So therefore, my question is, how much does that change your assessment? Do you still find the effects are minor? Putting it to one
Yes, I would clearly love to see it done, but it's in terms of the overall mine type, it's a minor addition. But it is definitely an enhancement.
I understand that. I'm just trying to get a feel for how much weight you put on it in your finding about the effects being minor. And it sounds like you've given it little weight. It's an enhancement and add-on,
Yes.
but your evidence is that the effects on terrestrial ecology would be still minor.
Mm. I mean, my main focus is on the mine footprint itself and how that is actually rehabilitated. And so this is an enhancement, it's an extra, but it's not a major part of my overall assessment.
Is there a plan in the pack somewhere that shows the ownership structure of the rehabilitation area that you've recommended? Is it in the application or in someone's evidence
Certainly in that document, which came from the environment.
that we haven't yet
So
seen?
that in the back.
Oh, that's helpful.
There's several, it's coming.
Right, okay, but we'll take your word for it that it's Lynn's land, not privately owned.
Anything within the margin of strip will be,
Yes,
be crown land.
yes.
And of course, we'd have to deal with them through the prior business.
Can I also check for the record?
Yeah.
I just want to check something for the record. Mr. Wells, as you were talking, you used the pronoun we quite regularly. And I just want to check that you've prepared your evidence as your own opinion. Okay, so when you say we, who were you referring to?
I'm referring to myself, but I guess I talked about we when we've actually, when I mentioned Hawkeswood, in terms of getting access to that land down on the berm.
Right, okay, right, okay.
So that's something they need to do.
Yes, okay.
It's a part of my recommendation. So hence working.
Thank you for clarifying that.
Just when you're thinking about conditions, I'm wondering if there would be any conditions that you intended keeping soil quality alive on site, stockpiling. If you've got any recommendations about that, it'd be good to see those in the conditions as well.
They are covered by.
Yeah, so bring them through.
So, I've indicated minimum periods for storage, not allowing the, particularly the topsoil, to get anaerobic. And you reuse it as quick as possible, basically putting back onto.
How friendly to that process is it to put that soil on the bund and then bring it back off the bund, because you've got to get up onto the bund? Wouldn't it be better to have a stockpile on site somewhere separately?
Well, Jim, look, from what I've seen on site already, it is actually stored separately.
Yeah.
Yeah.
But I've heard from
Separately, separately.
preferably separately.
Yeah.
I've heard from Mr. Johnson that it would go on the bund, and I just see logistical issues with that, because those bunds are quite big.
Yes, they are. One of the things I had.
And in fact, you destroy your bund trying to get up there to get off of me.
As I was going to say, one of the things I mentioned in my report is you could use a seed mix, which again I've described in my report. It's called a bush burn mix, which is very basic. Put that on those bunds of subsoil, etc., and that would give a good cover in fairly quick time. Protect them.
The reason I was asking that question is because it's covered in section 5 of the Act, life supporting capacity of soils. So it is a matter of national importance. So it's not a light-hearted question.
And just to add to that, I know Mr. Hearn, your report makes quite a few statements about soil health, and suggestion there's a lack of information at the point when you wrote your report. Just to flag that, obviously we'll be looking for an update from you on that based on evidence today. Sure. Thank you. Good. That's great. Thanks, Mr.
Thank you.
Thank you.
Thank you.
We'll take an afternoon break for 10 minutes, 3:10, all this year. Actually, what we might do, Mr. Don, is after the break, we might pop you on. Yes, and then we'll go back to the applicant's witnesses. Thank you. Something to raise with Mr. Brabant around the previous witness. You will have heard sorry, could I just ask for quiet? Thank you. You will recall the discussion, particular Commissioner Welsh was having around the riparian planting and rehabilitation planting that has been recommended by Dr. Will, and the suggestion that, or the question about how much weight we might be able to give that, if any, given it appears there's no agreement with the landowner to do that. Is that something that you can update us on prior to the hearing, or is there at the end of the hearing, or is there nothing else?
The answer to that is yes, on multiple fronts. So there is the prospect of resolving that issue potentially with the Crown prior to reply when provided. There are some alternatives with land under control of the applicant.
Okay.
And there may potentially be on the developing front another alternative, which I don't think we're in a position to enlarge upon just yet. There may be something else coming to the fore as well. We're not intending to be unnecessarily cryptic. I would literally just told this during the break. So I don't
no, it's fine.
jump ahead of things.
Yes. I guess we have some concern about the sort of, in fact, we haven't seen this rehabilitation management plan. There's a very broad light condition in the recommendation so far. And we hear that you're intending to provide that plan in your reply. That does give us a bit of nervousness because that's right at the very end of the process. It doesn't give council staff an opportunity to comment. It feels very late to us. And so we were just wanting to flag that or question whether there's an ability to see that earlier, or at the very least an actual plan, as in a map, that shows the outcome that you're trying to achieve. Because at the moment, it's all very theoretical to us and we haven't got really any idea of what we're trying to do.
That's a fair observation. But what I would say is the reason sitting behind why that is the case, that the applicant has been endeavouring to do the right thing by way of consultation, the Karanaka, and in the event that hasn't gone anywhere at this point. But that is part of the driving force behind where that is that the applicant didn't want to simply present something as a virtual fait complete. They were trying to get input. Having said that, I understand as decision makers from your point of view, if a proposition is being alluded to, then really you'd like it to have some form rather than sit there in an ephemeral way. So
yes, I
understand that. We will look at that straight after closure of today's hearing.
Thank you.
And we'll look to address that in a way that's appropriate.
And I would add, I'm not sure if it's fair to say, oh, well, we sent it off to Runanga and they didn't respond, so we didn't do anything. And I'm not sure that is what you're saying, but I just wanted to say, there's many options, including sending us a draft to say we've provided it, we don't have feedback yet.
Yeah.
So I'm not really that sympathetic with that position.
I want to make clear that that was not a criticism of Karanaka, so I'll make clear that that's the case.
Thank you.
But I also want to make clear that that is a genuine motivation for the applicant, that they are trying to get info. But we will look at that, as I say, at closure of today and provide you with something which has more form for tomorrow.
Thank you. Thank you. Okay, let's move on. Mr. Dons, thank you.
Thank you once again, and appreciate the opportunity to present our statement today. My name is Tony Dons. I'm the chairman of the Miller's Flat Water Company, and I've got beside me here Alistair McIver, who is one of our fellow directors, and Alistair is particularly keen to answer all questions.
Sure is.
Anyway, I'll get.
Sorry, I missed his last name, Alistair.
Alistair McIver.
Thank you very much.
So I'll read the two-page statement.
Thank you.
Get on to the job. My name is Tony Dons. I'm chairman of the Miller's Flat Water Company, and I'll refer to our company as the company through this. The company was established in 2010 and is a small, community-owned and operated water supply company. The company is operated by 5 voluntary directors. It's got 110 shareholders and supplies total water to 123 connections within Miller's Flat and north along Teviot Road. The company has significant duties under the Water Services Act to supply safe and sufficient water to its shareholders and to manage risks to its water source. Our role today is to present a summary of the company's submission to the Central Otago District Council and the Regional Council on the application by Hawkeswood Mining Limited for permits to operate an alluvial gold mine near Miller's Flat Township. We have reviewed the Hawkeswood applications, the District Council and Regional Council Section 42A reports, and had a helpful meeting with Hawkeswood on the 23rd of September 2022. The company has also entered into an agreement with Hawkeswood regarding the company's infrastructure located in the northern paper road. So now turn to the 4 issues of concern to the water company. The company considered the Hawkeswood applications at several of its board meetings and determined that it had a neutral position on the applications, but we did identify 4 issues that were the subject of submissions to the councils. Miller's Flat Water Company infrastructure is outlined in our submission. Part of our pipeline infrastructure is located in the northern paper road and is located within the proposed mining area. This pipeline services 3 water connections, 2 of which are now owned by Jack's Ridge Limited, which I understand is associated with Hawkeswood Mining. The company is obliged to ensure that water supply is continually maintained to these 3 connections and has now entered into a written agreement with Hawkeswood to ensure that this will be accomplished during the mining operation. The company also requests a resort condition to ensure continuous supply and prior consultation before alteration or relocation of the pipeline. The District Council 42A report recommends a condition number 46 to protect our pipeline, and we support the inclusion of this condition, particularly given the responsibility placed on us by the Water Services Act. Looking at the management of hazardous substances, the Miller's Flat Water Scheme depends on a groundwater bore for its water supply, and although the risks of the contamination from the mining operation are small, we are keen to see appropriate conditions to ensure diligent management of hazardous substances and notification to our company of any significant breach. The District Council Section 42A report recommends suitable conditions, and these are 12, 13 and 14, and we support their inclusion, particularly the requirement to notify us of spills greater than 4 litres. I also note that the Regional Council 42A report recommends a spill response condition, number 9 in Appendix 1A, including immediate notification of the company, that's our company. We support the inclusion of this condition also, particularly as the Regional Council would likely be the lead agency in case of an incident. Potential effect on groundwater quality and levels. The company has a significant duty to protect the groundwater source that provides the water to the Miller's Flat scheme. Although we accept that predictions show that the risks are small, we are keen to see appropriate monitoring, assessment and reporting as the mining operation progresses. The Regional Council 42A report recommends conditions regarding groundwater level and quality monitoring and annual reporting to the Regional Council. We wish to stress that the annual reporting should include a technical assessment by a suitably qualified technical expert, and a copy of this provided to the regional council and the water company. I also note that condition 15 in Appendix 1C recommends comparison against the New Zealand drinking water standards. The company wishes to be notified of any exceedances of these standards so that we can fulfil our responsibilities under the Water Services Act. Provision of additional connections. As noted in our submission, I wish to record that no specific arrangements have been made with Hawkeswood to supply additional water connections. We have some spare capacity, but additional connections would be considered as and when required. I note that in condition 4 of Appendix 1B requires provision of 2,000 litres per day within 48 hours to any effective bore owner. It is very unlikely that we would be able to provide a water connection within 48 hours, but we would be able to supply water from our hydrants subject to certain conditions and limitations. So in conclusion then, the company has taken a neutral position regarding the proposed Hawkeswood gold mining operation. As it proceeds, the company is very keen to see appropriate conditions applied regarding protection of our water infrastructure, management of hazardous substances, and groundwater level and quality monitoring, assessment and reporting. We also note the limitations of our ability to supply alternative water supply to affected bore owners. Thank you.
Mr. Dons, in your statement, you refer to the Central Otago District Council 42A report conditions. Ms. Colley has issued an updated version of those conditions in her evidence. Have you had a look at those?
Quite a long while. I'm sure you'll appreciate I spent quite a bit of time reading what I hadn't read. And has read the updated version.
Yeah, I'm not sure that they align. I wonder if you would do us a favour and would be able to have a look at those conditions and come back to us to advise if you agree or disagree, and if you disagree, let us know in writing. Could you do that at some point in the next week or two?
Okay, I thought you were going to say tomorrow.
Well.
Very good. So her updated conditions are on
That's B to Collins statement.
Anita Colley's evidence.
Okay.
Yes.
I'm not sure I can see any conditions in there relevant to that, what Mr. Dons was talking about.
I think condition 12 is.
Oh,
right. So you're saying that some of
that's
the
only,
conditions that I've seen might have disappeared?
it's
Well,
only a spill event condition.
Yeah, that's
There's no other condition.
the conditions that you've referenced, for example, can number 46 and numbers 12, 13 and 14. I think number 12 is the only one of those that refers to your interests.
Oh, that's in the, that's I see.
In the CODC.
Yeah.
Yeah. So you'll just have to check the references to the conditions and see that it's reflected in the updated version.
Okay. So has Anita amended the regional council and district council?
No, so just to complicate things, the regional council 42A officer has recommended conditions as an appendix to their report.
Great.
But we do have some suggested amendments by the applicant's regional planner in their evidence, but I don't think they relate. I don't know if Mr. Jones here. Do they relate?
But I can look at Anita's evidence and find appendix B and look at
Thank you.
basically the applicant proposed conditions.
Yes, or she might be very helpful in sending those to you, and then perhaps also the latest regional ones. Someone do that? Yeah.
I can send them too. It's no problem. Always. I can send them to.
Well, I'm sure I can find you all.
Yeah, great, in hand.
I'll check
Or
both these conditions.
Karen could send them. Anyway, someone get them to you. Can you let us know reasonably quickly if there's concerns?
Yep.
That would be very helpful. Have we got any other questions?
Are you concerned about the contaminated groundwater that may sit under the old landfill being drawn into the mine pit and discharged to land affecting the bores? That you service.
You were like, well, yeah, I read about that and saw, I think it was an independent review of that aspect, and there seemed to be some questions about how certain it was that there'd be no contamination of groundwater quality, and it's because of those sorts of uncertainties that even though our bore is some distance away from the mining operation, that we're.
And we saw it's down by the bridge.
Yes,
There's a hebe growing up in front of the sign, but you look behind the hebe and could see the sign. That's the one.
Yeah, it is. So I certainly accept the evidence of the experts that the chances of contamination going from the mining operation to our bore are small, but it is a one-way thing. So we would definitely want to see these annual reports on groundwater level and quality monitoring, along with a technical assessment of that, make sure that everything's going according to plan. So we can see the problem coming before it arrives.
So you're talking about robust reporting procedures.
Yes, yes. So where I talk about the independent expert producing a report each year on the monitoring data, I put the other bit in that covered water level as well as quality measurement. And yeah, when the mining company were emailing that to the regional council, if they could copy us in, that would be super to do that.
I don't know if you'll be listening tomorrow, but I've got some comments to make on the ORC discharge permit conditions.
Yeah.
I don't think they quite match up with what you're seeking. So just to let you know, that's not the end of this line of questioning. The ORC witnesses will be getting some questions on that, as will Mr. Heller.
Good. Great, that's all we have. Thank you both for coming. Really appreciate you coming in person. That's really very good of you to give up that time. Thank you.
I'll do the job in a week.
Thank you.
Good. Thank you.
Or
See all the great.
your words.
No, I shouldn't do that because it's.
So the next one is Mr. Heller.
Right, Mr.
Hello, Mr. Helen.
My name is Tom Heller. I'm a hydrogeologist, and I've worked on quite a few mining proposals, very similar to the mining ministers throughout the Otago and Southland region. And just to note that only two mining proposals are absolutely identical. I'll go through my summary statement and I've noted some questions throughout the hearing, so I'll cover those. Just to front that,
Yep.
hopefully I'm covering a few questions that the panel may have.
Great.
So the existing environment, and scope and scale of the mining and the effects and so forth are largely agreed between the applicant and the Otago Regional Council. And I noted that there was a question around provision of environmental data for information that's come up in that. To my knowledge, I'm not aware of any additional information that hasn't been supplied already, particularly with the application. And then certainly with the Section 92 request that was made within that package, all of the environmental data was provided, and there were comprehensive maps of sites showing individual information, and it covered very much all of the mining area. And I'm not aware of any other data points, if you like, that are outstanding.
Okay.
Yeah.
So the proposed groundwater taking discharge land activities for mine dewatering and so forth are able to be undertaken, certainly within the proposed and agreed IC conditions of consent. And I'll just raise one issue with one condition, and that is in condition 15 of the discharge to land permit. Now it talks about investigating areas where groundwater quality sampling, the results show that there's an exceedance of any drinking water standard. And just to make this condition a bit more sensible, I was just included the word where this was not previously exceeded from the results of baseline monitoring. So where the groundwater would already naturally exceed drinking water standards, just a bit of clarity here. It certainly is not absolutely important, but just a bit more sensibility in the condition wording.
Okay.
Okay, I'll just go to the page. So what's some temporary effects of the mine dewatering activity with about 40 litres a second may result in a reduction of local well wood levels and possibly some depletion of water from the lower reach of its inlet. I consider the suitable monitoring and mitigation and reporting and those agreed conditions from the Taylor Regional Council to completely mitigate those effects. I consider that there'll be no measurable effect of the discharge of land activity as anticipated by the proposal. Now, it's also been demonstrated by a similar mining activity at Waikaia Gold down in Waikaia with their discharge quality compliance data.
Is that exactly the same characteristics?
Exactly the same, but I will cover those aspects. So the Hawkeswood mining site is much better suited to discharge to land than the Waikaia Gold Limited site activity. The reason for that is that where the discharge will be occurring, there is a much greater depth from land surface down to groundwater level.
You're talking about the Vado zone?
Vado zone.
Yeah.
Zone of aeration. The hydraulic parameters or the hydraulics of the aquifer at this side of Miller's Flat are much less permeability than those at Waikaia Gold. The river.
Stop you there. Referring back to a site we know nothing about there's nothing to peg on.
Yeah, I will get to the point, Commissioner, on that. And another aspect, so I am talking about the Waikaia Gold Limited compliance monitoring data, and they fully comply with their discharge to land requirements and effect on Waikaia River. So another aspect is that the Cleveland Matau is a much larger river than Waikaia, and Waikaia Gold have discharged, approximately 3 times that of their discharge containing sediment to land than what Hawkeswood would be doing. What I'm saying there is that the conditions here are much better suited to a discharge to land. We would expect effects to be of a much lesser nature than Waikaia Gold, and Waikaia Gold Limited information confirms that there were no effects of their activity. So in a sense, I'm saying this can be done. Now, within the Alcaha evidence, Mr. Viles did question exactly that, so comparison of site conditions. And so I just want to reiterate that it's really about saying that certainly there's much better potential for compliance at the Miller's Flat site than what there was at the Waikaia Gold site. There was an aspect raised before we about discharge sites, and it was suggested that in my evidence that I had said that would be going into tailings. That possibly was within the original application, where there was a possibility of final discharge could go into tailings. So that's after it was being polished in the settlement ponds. I don't consider they do have to go into tailings. However, in areas where there is a large depth from land surface down to wood table, which is where the discharge areas are proposed, would be quite sufficient.
Could you repeat that, please?
Where the discharge areas are proposed, they are in areas where there is a reasonable depth from land surface down to wood table.
In Canterbury, in the original plan, they have a 1 metre Vado zone as being a good filter for sediment. You've got what? You've got 12 metres, 10 or 12 metres. So you're saying
pretty good.
That's a big filter, isn't it?
Yeah. The more the better, and this is why I also say that at Waikaia Gold there was only about 2 metres sort of gap between land surface and the wood table. And here there's sort of all 10. And materials are much better for it. So just on point 9, I've just said that I've tried to address outstanding matters from the RC230325 report and submit this concern. Don't want the matters arising. The groundwater quality at the Hills Flat landfill, effects and lag time of mine dewatering upon the gun wells, the two wells of Mr. Guns, effects and mitigation for flow and the timber burn in relation to Hawkeswood evidence. I have just obtained sampling results for the CODC landfill, Hills Flat, on Brian. I got that. It was a report. I was given a report, a CODC compliance monitoring report.
Is that soil or groundwater?
Groundwater. Right. So groundwater, and that's groundwater sample at the CODC landfill monitoring piezometer, which is directly down gradient of the landfill. And that's an annual compliance report. And all the results that were taken, it shows that the groundwater quality below that landfill is remarkably good. So the groundwater quality that were sampled were required by CODC for the landfill compliance to characterise groundwater quality beneath that landfill. And I do have a couple of numbers there that may or may not make any sense. I'm not trying to add in extra evidence, but
yes, you are.
I'm not concerned.
But you are adding in extra evidence, so
sorry. Yeah,
and that's fine.
I was told to.
Yeah, fine.
Because I think it's very important.
It's public information. It'd be public information, is it?
I'm not sure.
It would be if it's held by a council, you
Must be.
request it or the board, so the thing is your public council.
Oh dear, the poor bird.
Cited by the data.
Very, very.
We will accept it. Carry on.
As I say, only got that report by that.
Yep. Yes, carry on.
So I consider that there are no issues apparent from the water quality results. And additionally, Hawkeswood Mining is prepared to monitor groundwater quality downgrading of the landfill over time in respect of its mining proposal. Just moving to the gun wells, 3.40132 and 0111. So they've been assessed as being potentially affected by mine pond dewatering of between 0.2 of a metre and 1 metre at those wells, and that's for maximum seasonal drawdown. I consider that this is unlikely to compromise those water supplies. And additionally, consistent with the calculations for that seasonal drawdown given in the application, a 0.2 metre, so that much, 0.2 metre, that much baseline drawdown effect from that location, from, let's say, start up at the current location of the test pit pond, which is sort of central to the site, slightly closer to the Clutha Meteo. It would take approximately 110 days to develop that displacement or drawdown in the gun wells on startup.
From the existing
site. So this will provide more than sufficient time in advance of providing alternative water supplies if that is the case. And Mrs. Gunn will be able to confirm.
So are you saying that it'll take 110 days to get to the maximum effect?
No, it will take 110 days for
the 0.2.
That much effect.
Yeah, okay.
And much later.
Well, how will you know that how will you know that's happening?
Because there'll be external piezometers tracking the progress.
In the gun wells?
For the gun wells and for everybody else as well.
Yes. Okay.
I know that I think the guns are the only outstanding written approval, and they haven't provided written approval, but just because everyone else has provided written approval, also still applies to provide.
Yeah, okay.
Water supply. So Mr. Gunn will be able to confirm this, but I've been made aware that the two wells, 0132 and 0111, necessarily the only water supplies for that property. The property is also served by the Miller's Flat Water Company. But again, I've just been made aware of that, and that Mrs. Gunn can confirm that to the panel. Now, the Miller's Flat Water Company has also concerns over timing of water supply replacements. In that case, what I'm saying is that really there's only likely that it will be 4 wells that are going to require replacement water supply, plus the Parker irrigation well, which is not so reliant in terms of drinking water. 110 days of effect as an example to Mrs. Gunn's wells sort of gives the panel a bit of an idea of the lead in time that Hawkeswood Mining will have to appropriately monitor and make provision for alternative water supplies. And just another aspect of the Miller's Flat Water Company, Mr. Don was just talked to his evidence, and my evidence in chief, I had agreed with the Miller's Flat Water Company that provision of information regarding the monitoring and compliance for groundwater quality, groundwater level, but also discharge quality and discharge quantity. Whilst that's going to be provided to the Total Regional Council, that can also be provided to the Miller's Flat Water Company. And I had a very brief word to Mr. Hume about that, and Mr. Hume will be able to tell you if she's happy enough with that. But no problems in terms of where I sit.
Okay.
The assessment of effects of the mining proposal upon the Tenadurn have been provided based on Regional Council Regional Water Plan Schedule 5 requirements, and otherwise inclusion of sufficient augmented flow as an adaptive management provision. And they are in the proposed conditions of consent. The classification of Tenadurn with the Schedule 5 with the Regional Plan Water indicates that effects of stream depletion would not be apparent on the water body. And this is primarily due to natural water losses occurring and separation of the water body from the local groundwater level. So zero flow sightings and in-stream ecology evidence from Dr. Allebone indicates that the timber burn goes naturally dry or exhibits very limited flow during summer periods. I will wait around until Dr. Allebone finishes his evidence because there's a little bit of overlap between both in case I need clarification required. So ordinarily, a standard stream depletion approach would indicate that there is potential for the mine dewatering activity to temporarily deplete some water flow from the timber burn. And this outcome has also been anticipated and adopted into the proposed adaptive management conditions of resort consent. The adaptive management conditions will provide for an augmented timber burn flow of a minimum of 21 litres per second with cool, clean and oxygenated groundwater. Dr. Allebone considers 21 litre a second augmented timber burn flow as being substantially better than the typical natural flow. So it's quite generous in terms of the existing condition of the timber burn. Part of the proposed adaptive management conditions includes for an optional additional investigation of natural timber burn flow losses. Now, I stress that this does not indicate an information gap in regards to the effects assessment and the proposal. The conservative 21 litre a second timber burn flow augmentation fully stands and is agreed to by the applicant and the Taylor Regional Council. So I conclude this company no measurable effects. Mitigation is fully encompassing of that. I still remain of the opinion in my evidence in chief that the effects of a mining proposal on hydrogeology are appropriately mitigated through those proposed conditions we have seen.
Thank you, Ms. Teller. Commissioner Day-Cleven, you got some questions?
Thank you. Thank you, Mr. Heller. Just so that I'm clear in my own head around your evidence in the summary today, if I could take you back to Mr. Vile's evidence from Kaurunaka. You've got that in front of you? Excellent. So in paragraph 18, and he's got some bullet points there, which I believe you've structured your summary evidence to us today about those matters raised. So where Mr. Vile states that, in his view, there is no information provided on the interaction between groundwater and surface water, you've addressed that for us today.
Yes.
And so could you just, in response to that statement, just very clearly articulate your response to that?
In two approach made.
Yeah.
And first is the policy approach or a scheduled approach in the regional plan water.
Yes.
And what comes out of that is that the schedule would otherwise say that there is no determinable effect because of the state of the timber burn already.
Yeah.
So the second approach is that notwithstanding that, also mining are fully prepared for all lead flow as and when required on the basis of that there may be an effect.
Okay. And that's why you say that it's, to use the word generous.
Generous is a word.
Right. Yeah.
Conservative.
Conservative. Yes. Yeah.
So that proposal and that assessment is the worst case conservative approach.
Okay. Right. Okay.
About the augmentation.
Yeah. Okay. So in that respect, you would disagree with Mr. Vile's evidence in that regard because it's been.
Well, I suppose Mr. Vile was just asking the question.
Mm-hmm.
No problem there.
Sure. Okay, thank you. And I think that actually is my question. Thank you.
Paragraph 15 and 16 of the evidence, you talk about steady state dewatering restriction. And you state that it's approximately 62 litres a second steady state in paragraph 15, and then 16 you talk about in areas of high aquifer saturated thickness, the steady state would be 40 litres per second. I just wondered why it's lower, steady state slower where the aquifer thickness is greater.
I suppose that there's a little bit misleading in terms of paragraph 15. The annual volume of 1967836 cubic metres equates to 62 litres a second steady state. That's the maximum for the proposal. But when we sort of look at reality and we look at what's been achieved with the test mine pit, we're sort of going to be generally no more than about 40 litres a second.
So that 62 litres a second is really an average steady state.
That's the maximum annual volume over 1 year.
Yeah,
because it's a free calculation,
which is an average, isn't it?
Which is an average if they're achieving that.
The reference to a discharge site that I mentioned before is in the application to ORC.
Yeah.
Page 48 of Environmental Associates Limited.
I think have that, but on 10. What's the way you read that?
They state that the discharge areas are proposed to be located approximately at least 50 metres in the direction of groundwater flow from the flowing Clutha River. And then in the conditions that are proposed by ORC, these coordinates. On condition 3. And then you're saying that it doesn't really matter where you put it on site because the radar zone is quite thick. So the question is, do those coordinates that that are in condition 3 match up with the technical report?
Yes.
About 50 metres.
So they do, and that's the envelope for the discharge to land. And that envelope is located no less than 50 metres to the Clutha River, but it's in that area that I talked about where we've got a large radar site.
Have you got that identified on a map?
I haven't with me, sorry.
So I'm just wondering if the site plans that you've looked at, you'll just have that orange polygon, discharge polygon in that area, rather than moving around all over the place.
They could show that envelope for.
Yeah, and then it becomes a pumping cost question, whether, for the applicant, if you're going to get it back to that site, can you pump it to the, so there needs to be some thought put on that.
The area has been deliberately kept open within an envelope because.
Yeah, so I'm wondering if you change. I get that. Can we put the envelope on a plan so that we can see whether it's an A4 size envelope or an A3 or. And then site plans would then need to reflect that.
Yes.
That envelope.
I was thinking that was something that we could go in a site management plan showing the envelope for discharge to land. The reason that, and also another reason that the discharge to land is where it is because our viewing needs to be optimally adjacent to the matter. Don't want that being in the centre of the site where you're getting recirculation that would go back into the mine pond. So trying to avoid as much pumping from recirculation as possible.
That makes sense, but the site plans need to reflect that we're being provided.
Yeah.
The discharge location in stage 2, 3 and 4 has disappeared. And so in terms of certainty for what we, for us as decision makers, we need to see that back on the plans and where it's going to be.
Yeah, okay. My apologies, I haven't been involved with those plans, but that will be fine.
It's good that you've got that groundwater data from the landfill gasometer. Is that the one that you're proposing to monitor over time? You mentioned that you'll keep an eye on that data.
Yeah,
That's the gasometer you're looking at using?
Yeah, that's the CODC monitoring gasometer.
You're going to put your own one down as well?
But probably put my own one down.
And that could be presumably be in a location where as the mine moves around, you don't have to move it because it's in that buffer zone.
Yes, and that will also become part of the monitoring you do.
Sure. Okay, so I'd like to see that reflected in updated conditions if we could, please.
Thank you.
Now, you mentioned the groundwater data. Under the landfill is relatively good. The quality of the water under the landfill is relatively good. What's the thickness of the Vado zone under the landfill?
It's about, I think it's almost 10 metres.
That's not a very thick landfill.
Oh, hang on, because so from land surface to the water table. So
Rubbish, Vado zone, aquifer. What's the thickness?
Okay, the thickness of the landfill from land surface, I believe, is no more than 5 metres.
Okay.
And so there's another 5 metres down the water table. And the base of the landfill is 5 metres above ground level. And there's quite significant zone of aeration.
Yeah, so the Vado zone is 5 metres under the.
It is 5 metres.
So you've got a landfill with contaminants, you've got a Vado zone of 5 metres, groundwater under it is indicated as good. If you've got a 10-metre thick Vado zone for sediment discharge, could you not draw some conclusions from that about what the effect on groundwater would be from that sediment discharge? I don't really have, but does that add to the picture? You've got a 10-metre thick Vado zone, 5 metres is obviously hindering the rubbish.
I know you like to say that it means that there's going to be no effect of the discharge to land. I already consider there will be minimal effect of the discharge to land because it has polluting ponds before it goes into that. But the difference between the landfill and the discharge to land is that the landfill is capped.
Right.
So there's very little recharge going through that landfill just from rainfall.
Okay, so
there'll be very minute amounts of contaminants, if there are, from that landfill going through the Vado zone and then mixing with groundwater.
Okay, so there's no interpretation from that data about groundwater quality that could be applied to the proposal. That's fine, I understand that.
But unfortunately, there isn't.
In terms of the drawdown effect, when you put the pit under, there's a draw through of the landfill, the water under the landfill into the pit. Provides some data with that effect, doesn't it? When you're digging the pit beside the landfill,
yes,
there's evidence that there could be a drawdown of that landfill, the water under the landfill coming back into the pit.
Okay, so the drawdown from the mine pit when it's in close proximity to the landfill will not induce any more drainage. Is that what any more drainage from that landfill? Because the separation distance from the base of the landfill to the water table is 5 metres. So when you've got a Vado zone like that, when you lower the water table more, there's no more inducement.
Okay.
No inducement whatsoever because of that large gap.
Right. So it's like there's a break.
There is separation.
Yeah. Okay.
So it will just continue to naturally,
But what I'm saying though is there will be groundwater under that landfill.
most definitely.
Yeah. And once you get down past that groundwater level, the groundwater that's there will come into the pit.
Yes.
So the data you've collected from that piezometer you just mentioned indicate it's relatively good water.
Yes.
Does that have any inference for what could be going into the pit?
I've always maintained that the water quality that's in the pit is simply reflective of the natural groundwater quality in the area. It's only when it's pumped out of the pit and discharged to land that you get essentially the sediment that comes with it. Because the sediment is just kind of.
I don't think you understand what I'm getting at. If you dig your hole beside the landfill into the groundwater adjacent to underneath the landfill but adjacent to the hole, that could come back into the hole, into the pit, trickle through walls of the slice into the pit. You've just indicated that groundwater quality is relatively good. So does that give you some assurance that your system you're talking about will have no effects from that contaminated landfill water coming into the system?
Okay, absolutely.
Right. Okay, thank you. Have you seen any evidence of the 1 metre variability in the Creek River affecting the levels in the current pit?
No, I haven't. But I did note the variability of the Roxburgh hydro generation pattern in the aquifers that was done for the Parker irrigation well. It was quite significant.
Just remind me where that is in relation to the current pit that's been done.
It's this way by probably a couple of hundred metres or more, maybe 300 metres, and it's about 60 or 70 metres on this side of the river.
So, what I'm getting at is there any evidence from the current pit that you've dug with groundwater and the Roxburgh Dam moving up and down a metre?
No, there's no.
There's no movement up and down in the pit, so hydraulically there's a lag, there's a real lag effect there.
I wouldn't say that they're hydraulically isolated, but there's no evidence of any sort of fluctuations of the river that's some in my mind. I think it's just too far away from the river. But it certainly was in the Parker irrigation well.
Paragraph 32, you talk about which may involve the use of non-toxic flocculants in the sediment-laden water that's in the settling process. But Mr. Johnson said this morning there'd be no flocks. Can you just clarify that, please? Paragraph 32.
Yes, I think initially there won't be use of flocculants. Flocculants will only be required if the sediment levels don't naturally fall out. But they're typically used on updates that there's never been any problem with them. They're not environmentally but there's no environmental effects of those. They're non-toxic. They biodegrade. No effect of those.
So from your technical evidence, are you happy that flocks could be used?
Yeah, more than happy. And they've been used to, as I say, used to very good effect in other mining proposals that I've been involved with.
Coming off AMD, there is no risk in your opinion?
None. I've never seen any in the food our watch list.
So just wanted to clarify paragraph 69 about flow augmentation and the team of burn. That sentence that goes, the 21 litres per second is made up from fresh, clean groundwater to the stream at Cheviot Road Bridge. Is that saying where you'd put the water back into?
Yes, it's going in the Cheviot Road Bridge.
So where would you get fresh, clean groundwater from?
From groundwater.
Yeah, but
closer to Hawkeswood.
Which bore?
That bore is yet to be.
So you'd have to construct that purposely to implement that condition?
Yes.
Okay, can you please put that in your updated consent? Proper consent conditions that you're talking about?
We can indicatively show where that bore would be. Yeah, I think for the purposes of the panel, it will just show where that is at this stage.
Not so much worried about the location, just the intent and implementing it through conditions.
I think the intent of the conditions in terms of the actual augmentation are covered in the RC proposed conditions. Although the exact location of the bore that will be used to provide that water is not. And just perhaps would require a little bit of flexibility around the actual location. It may well be that something similar to the existing Parker irrigation bore could be used.
Yeah, just some thought on this.
Yeah.
I appreciate the questions, please.
Yeah, okay.
And there's levels of groundwater. This forms part of the watering campaign, so there's inherently built into the allocation that's provided to the groundwater take. So it's not a separate groundwater take to what is being proposed, although it is an environmental enhancement.
We'll check with the planners whether the consent's covered in the application or not. We have no further questions for you, Ms. Taylor. Thank you very much.
Thank you for your patience. Any more questions?
Can I just check? Share the questions.
One.
Just one.
Three other news questions.
Yeah.
I could see you slumping.
We have Mr. Alibo.
Mr. Elba, correct.
Doctor, my apology.
No, you've earned that.
That
Sorry,
hard earned, yes, thank you. As soon as I said that, we're in your hands.
Give the summary.
Yes, thank you.
Full name is Richard Alibo. I'm the director and principal ecologist at Wayne Consulting. My BSc, zoology and geology, never studied ecology, neither PhD in ecology, all from the University of Otago. I've been working as a freshwater ecologist for over 30 years, and my experience with the paragraphs for one was my editor in chief. I confirm that I have continued to comply with the code of conduct of expert witnesses in preparing the summary statement. Summary. I conduct a fish, macroinvertebrate, and habitat survey in the lower Thames Zone to determine the economic position of the stream and assess the possible effects of any dewatering as a result of proposed mining activity. The fish survey found the only common fish was long-fin eel, 3 other fish species, fram, with 2 individuals, a single individual, and an upper bully, and 1 individual with and of the 3 size fish. None of the fish are threatened species.
Environmental DNA samples did not detect any other fish species present. Observations of the macroinvertebrate community and the eDNA samples found the common accident were worms and snails. These are low flow and low oxygen tolerant species. Species such as mayflies and caddisflies are indicators of good habitat are very rare and limited to 1 or 2 individuals from very few species. No threatened fish or macroinvertebrates were found in this divergence. The riparian habitat upstream of Heaviett Road is accessible to stock. Downstream of the road, the riparian zone is fenced, dominated by crack willow trees, and their root mats extend into and often across the river channel. These willow root mats smother in-stream habitat used by fish and macroinvertebrates and are a major detrimental health effect on stream health. Present assessment is that dewatering of the mine will not impact on the Tillaburn, and therefore there will be no effects on the Tillaburn and the low ecological value of flora and fauna present in the stream. In the event there is some reduction in flow this will occur in the area already subject to low or no flow. This reach has a low or no flow, low dissolved oxygen tolerant fauna, and further induced low flow will not impact on any significant ecological values, and drought and low oxygen tolerance will not be lost. Furthermore, as flow augmentation is proposed in specific circumstances to prevent dewatering due to mine dewatering, this protects the lower Tillaburn fauna from any induced drying. I consider that the amended conditions of consent put forward by the applicant addressing paragraph 55 of the evidence in chief are appropriate from the freshwater ecology perspective. Matters arising. Mr. Vile has raised issues regarding the Tillaburn and the assessment effects of the application. The preference refers to assessing the natural character, and the application cannot show it preserves natural character. My assessment report and a technical review by Mr. Hammer both characterised the lower Tillaburn as a stream of low ecological health with a fauna of pollution and or poor habitat quality tolerant species. I've also described the riparian margins as being graze, pasture or crack willow dominated riparian zone where the crack willow root mats further reduce the in-stream habitat quality. In my opinion, this provides an assessment of the present state of the natural character.
Can I just ask a question there? That is my reading of Mr. Hammer's evidence, but he also says that the fish values are actually high.
I find my evidence in chief that this fish application calling Eno and Morphin eel threatened species. That's incorrect. They are not threatened. That's outlined in the evidence provided. They are at risk of declining, which is under the NPS and the Not Threatened Species Manual. They are not threatened species. They're simply declining species. There's a very specific NPS about that. And so that assessment of the threatened species present is wrong. With the NPS, I wrote a submission for the New Zealand Freshwater Science Society on this to make sure it was defined correctly, or in the NPS, which it is. They have to be nationally critical, nationally vulnerable, nationally endangered to be a threatened species, and Morphin and Eno are both at risk declining.
Okay. So is Mr. Hammer listening?
You should be online.
Mr. Hammer or Dr. Hammer, are you online? You listening?
Mr. Hammer.
Mr. Hammer,
Kia ora, everyone.
you? Hello, are you listening to Mr. Alba? I don't know whether we can clear this up now but I'd like you to address it at some point.
Yep. Yeah, I'm happy to speak now if you'd like, or I can wait till my turn, whichever helps.
Those in the room are looking a little tired. I don't want to elongate the day. Can you resolve it with a I agree or disagree with Mr. Allibone? And if you disagree, we'll come back to it tomorrow.
I agree they are at-risk declining fish. I concur with that, and that's in my evidence tomorrow. Yep.
And so you agree with his conclusion then that fish values will be, and I don't know if you said low, but low, was that?
I think that,
No,
was that
yes,
in relation?
No, I agree that they are at-risk declining fish. But in my evidence tomorrow, I'll still be saying the fish values are high because of the 2 at-risk fish present and the historical records of lamprey, which is a threatened native fish. So yes, we still disagree on that point.
Okay, thank you. We'll move on from that. Thank you.
Right, paragraph 10, I think we're at.
Yes, thank you.
Further, my report and evidence achieved assesses the possible effects of the proposed mining activity. There will be no effect if there is no groundwater drawdown that affects the timber burn. In the case that the present natural characteristics remain unaffected. Some lowering of the water table and the flow of the timber burn is recognised while mining is occurring, then the flow augmentation will be initiated to protect the stream flow. This will protect the existing natural character. List of Ireland paragraph 101 discusses the use of the precautionary approach and providing a safety margin and managing activities that may cause harm and raise the concern that the flow augmentation is unsuitable in paragraphs 105 to 110 and possible water quality effects from groundwater augmentation. The dominant macroinvertebrates, worms and snails and fish mongrels are known to tolerate poor water quality conditions. I do not consider the flow augmentation to represent a water quality risk to these species and expect the existing poor natural character to be maintained. I would also consider the flow augmentation proposal as a good precautionary condition as it is readily achieved and will provide assurance that the flow is contained in the lower timber burn even when natural low flow conditions can occur. I would also note that the poor habitat and or water quality conditions extend well upstream of the potential area of any groundwater impact. Following the completion of mining work in the vicinity of the upstream water quality issues and the effects of crack or appearing crack waters will continue and the natural character will continue in its present state. Finally, with respect to natural character, the mine proposal could potentially reduce flow in the lower 600 metres of the timber burn. There is approximately 50 kilometres of timber burn upstream of this reach. There is also the network of tributaries, meaning by far the majority of the timber burn is also at no risk of any effect from the proposed activities. Conclusions. The lower timber burn is assessed as having low ecological value. The present assessment is that dewatering of the mine will not impact on the timber burn and therefore will not affect the timber burn in its broad form. In the event there is some reduction in flow, this will occur in the area already subject to low or no flow. The proposed flow augmentation will prevent any stream watering due to the mine dewatering, and this will protect the lower timber burn from injury fines. Finally, with respect to natural character of the timber burn, the majority of the catchment cannot be affected by the proposed activity. In the event that the ground will draw down, effects on lower timber burn, the proposed flow augmentation will provide protection of the existing natural character. We do not consider the augmented water represents a risk to the low ecological value because of the lower timber burn. I'd also like to add, if you want an example, I've been working on flow augmentation with the mine pit water. It's been successfully operating now for 3 years continuously, and has actually exceeded our expectations of achievement.
Commissioner Day-Cleven is interested in that. Is that something you want to talk to us about or give us something in writing on?
I can quickly describe that.
Quickly, it's new evidence, so
Yes.
I have a limited tolerance for that.
I worked with Newvale coal mine in Hawkeswood River down in the tower. The mine has truncated 2 small headwater streams and we have a golden glacier, which is an at-risk species in there. And we've been worried that we have to keep it alive through the process of the mine until the stream areas are rehabilitated. And to achieve that protection from droughts, we have installed a pumps thing. It pumps water about 100 metres altitude, kilometre from the mine to the head of the stream, delivers 1.5 to 2 litres a second to that stream, and has been doing that continuously now for 3 years. It's protected that population through 2 droughts. We've extended its range upstream right to the discharge point, so it's got an extra 500 metres, double its habitat, available water. And we've actually seen now longfin eels, albus and small eels colonising the stream there. The migratory passage downstream has improved, augmented flow, and we're getting unexpectedly a number of eels turning up each year. So it's working incredibly well. It's exceeding our expectations.
Thank you. We've just got one question.
Yes.
Yeah, so in relation to the one area of disagreement between yourself and Mr. Hamer, so we'll hear from Mr. Hamer tomorrow, but while we have you, so at paragraph 7 of his summary statement, he did raise the issue that while he acknowledged that lamprey were not found in the survey undertaken by you, that they have been found to be present on 3 occasions in the last 25 years, indicating that they do use this waterway as habitat. And on that basis, he assesses the ecological value of the fish present of the Timberburn as high. Could you respond to that now and just explain the difference of view?
Firstly, lamprey bury themselves in the mud. They're on lamprey and they put a head out to build trees. So most of the day they're buried in mud. When we get to the willow line section, which is the most at risk section of this proposal, those willow root nets grow across the substrate. And so look at that, they ruin it because there's nowhere for the little lamprey to burrow. They don't burrow into root nets, they grow into mud and fine sand. So the crank willow is buried in habitat. Upstream, we tried electric fishing. Most of the frustration of my fishing partner with at the amount of area with fish, there's very little back there, which is kind of what they use. We couldn't find a simple lamprey, so we took the eDNA samples. That has another way of detecting them. And again, they came back with no lamprey. That didn't even pick up the E-number we found. But it's kind of indicative. We couldn't find it. Habitat's missing in the impact zone, and the eDNA couldn't detect it as well. So they are there. Recently, it was down in Waitahuna, and we were able to find them within a couple of minutes to turn the machine on. The habitat's there. As soon as they got the timber settled around, this doesn't look good. See a lot of strains in timber is not good now.
Right. And so the eDNA samples that you refer to, that's quite a reliable, common assessment tool.
We have more common to do them. We took one at site 3, which is down in the impact zone, and we took one at site 1, which is well upstream, just where you come out of the schist bedrock country, to have a look. You can take more and more samples if you have some chance of detecting really rare things, but certainly if lamprey are there, the habitat is very limited or gone, and they're in very numbers, very sparse.
Right. Okay.
Yeah, they should be there, but the timberburn certainly is declining in quality, I think, from what it was 20 or 30 years ago. So,
Thank you.
Thank you, Eunice. I've got no questions on it. Just one thing, implementation of the recommended mitigation measure about 21 litres a second being put back into the Timberburn, or topped up to 21 litres per second. The condition that's proposed at the moment is condition 5 in the ORC condition set. And that talks about any flow augmentation shall be reasonably oxygenated by aerating the water using a diffuser and or riffles of similar approach. My question is the riffles practical in this situation? Because it seems to be, as you said, there are no riffles. So should that condition just refer to a diffuser only?
Well, there are riffles, but in the lower Timberburn, the root mats are going across them.
Yeah.
Further upstream, there are riffles, but the habitat's not good with that. But the other thing is that if you read the report, it mentions that Flight 2, which is just upstream of the road, is 2 small waterfalls. And you really, in fact, use those as a point. Just down still, that cascading series and adding ration and a diffuser as well. And really, I mean, the one we've got leading south, and we don't worry about this, it's just discharging from pipe straight into the stream. But it's just to cover off if the groundwater has been under the surface for a long time, the delta level will be reduced from surface volume. So it's just making sure that you're not discharging long distance from water. And it can be done, it's not a problem. It's just simply putting it.
I'd like you to look at that condition.
Yep.
And see if it's practical, because you just mentioned upstream.
It's about.
But the condition says it needs to be discharged downstream. So just just flagging, have a look at that condition set, read it carefully and make sure it makes sense. That's all, I'll leave that with you.
Well, it says from the Timber Road, the stream flow through. You could change it so it says. Take 10
We
metres.
don't need the detail now. The
I'm not-
commission's just asked you to deal.
Yeah.
Liaise with
Read
your
it in
team.
detail, make sure
Thank
it
you.
works before you bring it back to us.
Yes. Thank you, Dr. Allen. Appreciate your evidence.
It's fine. Commissioners,
Yes.
Mr. Heller has just realised one answer he gave you may not have been accurate and would like to correct that for you, which I think is proper that he do so. He's realised that there's an issue. So if you may even just release that matter.
Yep. Thank you.
And presumably it will be covered in the right of reply accurately.
Certainly hope so. Yes, I'm not aware of what the issue is. So.
No, but
Question was asked if the current test mine pit pond showed any fluctuations in relation to the Pluto matter out. I was just speaking to Simon Johnson and he has noticed there is about a 1 week lag with high Clutha river flows. And that's, to his knowledge, that's produced about a 700 to 800 millimetre variation from that mine pond level. So I wasn't aware of that commitment, but just wanted to make sure that that is noted, and that would tie in with my assessment that there is connection between that site, the lower area and the.
okay, thank you.
Thank you. Thank you.
And that's just for the record, you might want to record, perhaps Mr. Johnson could just acknowledge, because it was technically hearsay, that is the advice he's provided to Mr. Allen.
Thank you.
Well covered, thank you.
Thank you.
So at this point, commissioners, and I can't tell if they're there.
So I can compare that all thing there and waiting.
Oh, lovely.
I've been waiting all day.
Yes, I'm still waiting. Okay, so next then would be Mr. Coughlin.
Mr. McDermott.
Oh, sorry, apologies, Mr. McDermott.
For the next three witnesses, can I ask, we have maybe one question of each.
Yes.
Can they, I'm happy for them to read their statement. We don't need to hear the first para about their qualifications and experience. We could just step straight into their summary and then we'll ask our question and move on.
So
I'm sure they heard me.
witnesses, hopefully you do, please skip over your qualifications and experience and just progress straight to the bulk of, or the body of your summary statement, please.
Yep, that's fine. Can everyone hear me okay?
Yes, we can. Thank you.
Okay.
Welcome.
Yep, hello. Okay, summary. This summary statement considers the stability of proposed temporary batter slopes adjacent to Teviot Road. The stratigraphy of the site is very simple and has been confirmed by site inspection and geotechnical drilling. It comprises a thickness of outwash gravel which contains the gold-bearing horizons overlying schist bedrock. The test pit at the site provides a working example of batter cuts which can be achieved within the on-site outwash deposits. I completed slope stability analysis to determine suitable temporary batters adjacent Teviot Road within the outwash deposits. My assessment concluded that overall batter angles of 45 degrees are suitable for the temporary batter slopes adjacent to Teviot Road for the proposed 7.5 metre offset from the crest of the batters to the road reserve. Conclusions. I remain of the view that the proposed temporary batter slopes are appropriate and can be managed through conditions of resource consent. It will be possible to review these recommendations as the mine is developed and the performance of batter slopes can be reviewed. Additionally, if the proposed offset were to change, the recommendations could be updated. Thus, from a geotechnical perspective, the proposed batter slopes are appropriate and supportable.
Thank you.
Good afternoon. Thank you for your patience. I'm waiting online.
That's
Can
okay.
you hear me?
Yeah.
You looked at the suitable temporary batters for Teviot Road. Did you also look at the power lines that are running in between the proposed mine pit and the road, like the power lines are closer to the pit than the road would be?
Not specifically, but that's something that can be assessed as the mine progresses, if that's an issue.
Well, it is an issue, and we just wonder how that might change your evidence in terms of an offset from the road edge, because it's they're quite big power lines and they're a couple of 2 or 3 metres back from the road. Does that change your slots in any way?
I've not considered that particularly. I guess in the area of the power lines, we could look at amending the offset to cater for their presence if they're closer to the edge of the pit than Teviot Road.
Our site visit indicated they were, so just want to leave that with you to provide more information on that, please. You've talked about an overall slope batter of 45 degrees. Sorry, is that an overall slope profile? Because there will be a batter and then a bench and then a batter.
Yeah, the 45 degrees is an overall profile. So the individual batters will be steeper, but then there'll be a bench and then a slightly steeper batter. So that's the overall essentially from the toe of the slope to the crest of the slope.
Thank you. And that would that apply to all of the mining that occurs? Would you recommend that as an appropriate batter, because that's what Mr. Johnson's evidence refers to?
Yeah, I mean certainly. I mean we particularly looked at Teviot Road because it's a public road. I mean similar batters around the remainder of the mine pit would be appropriate as well.
Okay, thank you.
Okay. Anything? Thanks, Mr. McDermott. That's all we have for you. We appreciate you attending.
Okay, thank you.
Yeah.
Next then would be Mr. Cochran.
Good afternoon, Commissioners. Can everyone hear me?
Good afternoon. We can hear you. Yes.
Cool. I heard your comments that you just want me to get into it, so I'll just start with my summary.
Thank you. Perfect.
Cool. So I prepared a transportation assessment on behalf of Hawkeswood Mining Limited to assess the potential transport-related effects of its proposal to establish and operate an alluvial gold mine at 1344 to 1536 Teviot Road, Millers Flat. I concluded that, subject to conditions relating to site access design, that the safety and efficiency effects of the proposal on the transport network will be acceptable. The access ways will not be designed in accordance with Figure 12.3 of the District Plan, as I consider that this standard is not required from a road safety perspective. Under my direction, Abley staff have prepared concept design drawings for each access way. These are shown in Appendix C of my evidence in chief. This design is based on a Diagram D accessway as per Appendix 5B of the NZTA Planning Policy Manual. My analysis, as set out in my evidence in chief, concluded that this design approach is appropriate for the site accessways. This is based on Teviot Road having low traffic flows, particularly relative to other arterial roads listed in Schedule 19.7 of the District Plan. Teviot Road having an excellent safety record. A large proportion of traffic movements at the accessways will occur outside of peak times. Forward sight distances from through traffic to vehicles turning at the accessways being excellent, and the total number of heavy vehicle movements using the accessway being very low, and on average 4 movements per day. That is 2 in and 2 out. These movements are also unlikely to occur during network peak times. These concept drawings will need to be developed further as part of detailed engineering design. Rising. I have reviewed submissions made where those submissions have raised concerns relating to transportation effects of the proposal. These submissions assert that traffic generated by the proposed activity will pose unacceptable traffic safety effects on Millers Flat School and generally on other road users, including cyclists. I conclude that any traffic effects arising from the proposed activity will be indiscernible to other road users. Teviot Road has low traffic flows and an excellent safety record. Moreover, the types and flows of traffic generated by the proposed activity will not lead to any capacity or safety problems. Conclusions. Having reviewed submissions in the Section 42A report, I remain of the view that subject to conditions of consent, as set out in my evidence in chief, that the proposal can be supported from a transport perspective. Thank you.
Thank you very much. You refer to conditions of consent. Have you reviewed the conditions proposed by the planner, Ms. Colley?
I have, not in detail compared with what I had recommended.
Okay. Are you able to do that and in the reply or at some point advise that you're comfortable with those? And in particular, I will just take you to condition 17, which relates to the Miller's Flat School. This might be more of a planning sort of issue, but my read of that, it says heavy vehicle movements associated with the mine shall be scheduled so as not to coincide with pick-up and drop-off times at Miller's Flat School, or be required access the mine via part of the roading network that does not pass the school. That to me isn't meet the certainty required for a condition, which is again a planning question. But have you had conversations with Miller's Flat School about what times? Because the obvious next step with that condition would be to put times around that. And have you had any correspondence with the school itself or the Ministry of Education?
I haven't myself. No.
Okay.
I'm able to add some context to that condition if that would be helpful.
Sure.
So my evidence in chief, I can't remember the exact paragraph. So in paragraph 45 of my evidence in chief, I state that given the number of heavy vehicles generated by the mine will be low, the associated impacts on the road network, including Teviot Road as it passes the school, will be insignificant. However, in response to concerns raised by the Ministry of Education, I have considered whether it may be appropriate to ensure that heavy vehicle movements are scheduled so as to not coincide with peak school pickup and drop-off times.
Yes, and just to stop you there, yeah, I'm familiar with those paragraphs, and I see the applicant's happy to offer that, so that's fine.
Okay.
I might have a discussion with Ms. Colley about the wording of that condition to provide a bit more certainty. But otherwise, if you could have a look at the other transport conditions and confirm you're comfortable, that would be useful.
Sure.
This one.
We've got one more question for you from Commissioner Day-Cleven.
Thank you, Mr. Copeland. One question, the conclusion that you've summarised here in your summary report, just for the record that accounts for the increase in staff proposed by the applicant. I recall in your evidence in chief, you have assessed that from the increase from 20 to 30. And so your conclusions that you've summarised today take account for that?
That is correct, yes. Yeah, so that conclusion takes account of revised numbers on site, yes.
Okay, thank you for confirming that.
Thank you. Thank you, Mr. Copland. Very helpful evidence.
Thank you.
And Mr. Keogh, is that?
Correct, that brings us to Mr. Keogh.
Thank you.
It's Keogh here. I presume I'm next, am I? Am I coming through clear, Commissioners?
Good afternoon, Mr. Keogh.
Good afternoon. Do you want me to read through my scope of evidence, or will you take it as read?
We can take it as read, and I think we have perhaps one or two questions for you. Okay, I'll have a crack. So in the application, it states that there is a consent sought under the National Environmental Standard for contaminated soil. Under the discretionary activity rule, which is required, a consent's required if you don't prepare a detailed site investigation. I think I've summarised that correctly. But in your evidence, can you advise, I guess where I'm getting to, can you confirm whether that consent is required or whether the site is not a site in terms of the NES contamination of soil?
No, outside of the old Millers Flat landfill, the site isn't a hail site.
Yes.
But when we did our initial site investigation, of course, it was for a more limited mining area with a particular say focus on the old landfill site, and subsequently the mining area was expanded to include two stockyards that were to the south and east, and we did a subsequent a sampling routine across them, and again found no contaminants associated with either of the historical stockyard area or the current one. And so concluded again that the NES doesn't apply to those areas either. And so the only area that is identified as a hail area is the old landfill. Our reference here to a mining perimeter is also the area that we found clean samples, so that effectively you're saying, we've got a line around the landfill that is known to be unaffected, and that if you move inside that line, you'll need to do a full detailed site investigation before undertaking any work in that area.
Okay, thank you. And Mr. Brabant, am I right that there's not an intention to do work within the landfill area?
Correct. So there is, and this can, others can check on this maybe, but my understanding is there has been a perimeter set that has been informed by the work undertaken by Mr. Keogh. And that creates, it's almost like perimeter and it's being confused with you inside outside. It doesn't help. It's an exclusion zone.
It's an exclusion zone. Yeah,
because we got involved in the debate about the word perimeter and within without was properly described. The short version is it's an exclusion zone, and so the mining is outside it, and that has been set by reference to export input from Mr. Keogh.
Okay, and so
could I just check the
yes, please.
Clarification on that. So there is the close landfill that is excluded from the site, the work area.
Yes.
The term landfill has also been used in various reports to refer to the Council Green Waste landfill, which is a separate site, and that is within the project area.
But it's not a hail site.
No.
Correct. Thank you. And so we might as well deal with it now. Is it your opinion that a consent is or is not required under the NES or for this proposal?
I think there's a technical requirement for consent because that exclusion in clause 5 and 9, I think the NES doesn't apply because there is no DSI prepared.
Yes.
So, and that would relate to the stockyards. So even though
I see.
Yeah. Has been through and done sampling, stockyards are on the hail list.
Yes. So it's just discretionary activity.
DSI would be required to make that area not a site under the NES service.
Yeah, okay. So given it's technical, I don't think there's any conditions recommended.
No, that's
no. So Mr. Keogh, given there's it seems a technical matter around consent under the NES, are you comfortable that no specific conditions have been proposed in relation to the, I suppose it's the stockyards?
No, I don't think there needs to be any in relation to those. The stockyards, the old historical stockyards, which were the area that presented a risk because the contamination risk associated with stockyards goes back to the days when arsenical dips were used or DDT or deoldrin were used, and that tended to have all gone out of practice in the 1970s, and the yards were only established for a short period during the 1970s. They had no dipping facilities or treatment facilities with them. And the sampling effectively proved that. And the reason why a DSI wasn't done is it would put the PSI in, and then the sampling was done in response to a Section 92 request for additional information. So which sort of, I mean, we'd effectively address the general area of the farm. And we had noted the stockyards were present, but not within the site when we initially did it. And then council asked for a verification through sampling. So we feel it's been appropriately addressed to the level of a DSI, but a DSI report hasn't been prepared.
So the sampling that you did, that doesn't constitute a DSI?
It would not, it's sufficient sampling for a DSI, but it wasn't in a DSI report format because it was a Section 92 request response.
Okay. Yep. No, that's fine. The choice of
So,
thanks. Anything else? That's all for you from you, Mr. Keogh. Thank you very much.
Thank you.
I would just like to have a quick chat with my commissioners about what to do next. I'm tempted to say let's finish for the day now. We're all looking a bit tired. We've got the 2 planners to go. There's a bit to discuss with them. They may want to have an opportunity to sort of consider today and what we've discussed, and they may well come back to us bright and fresh and be able to answer some of our questions that we might ask.
I would support that. I think I don't think it would be particularly productive to sort of get halfway through one of them. I mean, I'm in your hands, but I think that would be the smarter scenario, that we will turn up bright-eyed and bushy-tailed tomorrow and launch into it.
Yes. The other option might be, if there are submitters in the room who would really like to go today, we could hear from you now and be heard now. So I'm open to that. Is there any submitters that I would like to finish at 5, so we've sort of got 10-12 minutes.
Who that what I said earlier, I wouldn't want to jump the gun.
So to speak. You'd like to stay. Thank you very much. Okay.
Speak tomorrow.
Fantastic. Yes. And any others wanting to speak today? No. Okay. No. Karen, are we able to start at 9? Is there any reason why we couldn't start at 9?
No reason we can't say
Yeah.
And there wasn't anybody that felt like that. Missing out possibly.
There's option online, I guess. Let's just plan it, but I'd rather just keep going.
The link will be open.
Is it?
Yeah, we're just checking if there's anyone else, but I think no, everyone's looking toward tomorrow.
Okay, great. We would like to suggest that we start at 9 tomorrow. Is there any reason why that's not going to work for any party? Happy?
It's fine for us, thank you.
Thank you. So what we'll do then, we will adjourn. We'll start at 9 a.m. tomorrow. We'll have the 2 planners for the applicant. And then we will go to, depending where we are at timing, we'll try and have Harunanga at 10. So we'll see how we go. Mr. Violet, do they have to be at 10? How flexible are we about 10 o'clock?
It's quite flexible because I was still leaving.
Oh, so they're here for the day. Well, for as long as, okay, great. Fine. Well, look, we'll have the planners, then we'll go to you, Mr. Vile, then we'll have the other submitters, and then we'll hear from the council officers. Anyone have any concerns with that? Great. Thank you very much for your attendance today, and we'll see you tomorrow.